He morena tātou. Tēnā tātou i rungi te kaupapa hira nei, te kaupapa whai maramatanga. Rā e pāne ki ngā mātā pono o te Tiriti o Waitangi. Ko tāku hei whakatūtara whata ki te wāhi ngaro, ka tai ko tō mātou pakeke i whakamihi atu ki a koutou. Nā reira mi ino i tātou. E te ariki, nā hau rā, i ārai te hurai ki a taipai mai mātou ki roto i te whanganui a tara nei. Tēnei mātou au punanga e tuku
And so
ngā
we, your
whakamoemiti
followers,
ki a koe.
give thanks to you.
E tuku ngā whakamoemiti ki a koe
Pāheki, can you wait till I make you an interpreter, please?
e te ariki. E tono i homai te tō mai rangi o tōu a te whai ki rungi a mātou katoa e te ariki. Ka inoi atu ki a koe, ka kariki atu ki a koe, ka whakawhetai atu ki a koe. Mō ngā tangata katoa ao te aroa nei, mo te kāwanatanga, mo te ropu whakamani te Tiriti o Waitangi, mō ngā roia, te hunga roia kua hui nei, mō ngā kai kōrero, me ngā kai kreme, kai konei, kai te whakarongo mai i ngā wāhi mahi i ngā kāinga, kai te mātakitaki mai nā e te ariki, manakitia mai mātou katoa i tēnei wā. Kai roto i o Piture e te ariki, kai roto i te pukapuka a Matthew, ko tērā whakatau ki te tāhuri te tai whare ki ai anō e kore taua whare e tū. Nā reira arahina mai mātou e te ariki rungi te huarahi, ki te rapu, te huarahi pono, te huarahi tika, kia whakatū mō mātou katoa ngā iwi o Aotearoa, te whare kotahi. Whakatōngia mai ki roti a mātou e te ariki, ngā māramatanga e pāne ki tērā kāwena tapu, te Tiriti o Waitangi. I reira koe i te wā, i waitohungia o mātou mātua tīpuna, i te Tiriti. Taua wārā e te ariki, i huri rātou ki te whakapono. Ko te kuini o Ingarangi, i taua wā e te ariki ko te whaia o te āhimihinare. Nā reira e te ariki, hātepe tia rātou e hiahia ana te whakawehoehe i a mātou i tēnei wā. Tā ka ingia te kai whakawāmatua e te korowai aroha, paihere tia mātou katoa, i roto i taurangi Māria, mutunga kore e te ariki, ka inoi atu kia koe i rungi te ingoa tō tama a iukareiti ake tonu atu. Āmene.
Reire ngā reo, e ngā mana, e ngā waka, e ngā tini kārangaranga, e ngā roi hoki, e ngā mema te karauna, kia koutou ngā kaitono, tae atu ka koutou e hono mai nei rungi tīpurangi, tēnā la koutou katoa, kua tae mai ki te whakarangatira i tēnei noa tātou te rānei. Haere mai rā, tuki mai rā, whakauru mai. Whakauru mai ki roto i tēnei noa tātou te rānei. I raro e te whakahaere te kai whakawā matua a tākuta Karen Fox. A reira nau mai. Haere mai rā me ngā ito maha i rungi a koutou. Ko rātou hoki ko taka atu ki tuara tua te ārai. Ko tahi ana te koro mō rātou. Ko maunu hoki rātou i te waka o tēnā tangata ka hako aitua. Ko akawhiti atu rātou e nā moana atu uri ki te pō. Ki te pō nui, ki te pō roa, ki te pō uriru, ki te pō e au wai te moe. Nā reire ngamate, ko tahi tonu te koro mō koutou haere, haere, wati atu. Kei warero ki te ngā mihi ki tō tātou kai arawhata ti a tātou ki tō tātou kai hanga. Tēnā rā koe e te rangatira e Monty, e tuko tēne te o whakawhetai, whakamoemiti ki tō tātou kai hanga. A korong kua tau ngā kupu ka ronga au ki hae wāhi mahutu i a koe, ngari pātana te katoa tēnei noho mo te roa ngā kia te noho. Nā reira, kaua te koro i tuatu i tēnā ne tua na whakatau mai ni a koutou rauru mai ni ngā ahuatanga o tātou te iwi Māori, huri noa, tēnā koutou, kia ora tātou.
Mawaira.
whakaawatea. Anō reira, ko te mea tuatahi, te mihi tuatahi, e mihi tēnei kia koe e te rangatira, nā mō ngā kupu wairua, e te arawhata ki tō tātou runga rawa, nō reira, kia koe hoki, ki tēnei rā te mihi, kia koe, kia tūwhera, kia whakatika, kia whakawātea te kōrero ko kōrero hia i runga i te kaupapa o te huinga. Nō reira, ka mihi ake, ka mihi ake, ka mihi ake. I runga i ngā mihi tuatahi, e tautoko hoki ngā mihi ki tō tātou runga rawa, anō hoki ka huri ake ngā mihi ki a rātau o te whenua nei, te moana hoki a Raukawa, a Te Atiawa Taranaki Whānui, anō hoki ki Ngāti Toa Rangatira, tainoa ki a Ngāti Raukawa, o rātau nei, a kua whairikihia, ki tautoko hia ki a tātou, e noho mai te whenua, mahi mai te whenua, anō reira ka mihi ake tēnei ki a rātau. A ka huri ake anō ki ngā mihi, ki ngā whakaaro aroha ki a rātau, ko wheturangi hia. Rātau kua haere atu ki te wako o te rangi, te kūpenga o Taramainuku, no reira ki a koutou e ngā mate, haere, haere, haere. Moi mai koutou ki te moinga o rātau mā, ki tō tātou tūpuna no reira, tēnei rā te mihi, tēnei rā te tangi, tēnei rā te poroporo ake ki a koutou i no reira. Haere atu rā, haere atu rā, haere atu rā, ākati ki a koutou. Ka hoki mai anō ki a tātou, ngā kano hiora ki o koe hui hui mai nei i runga i tēnei kaupapa nunui, kei te mihi tēnei ki a tātou. Nei rā te tūake mō a mātau o ngā tari o te karauna, kua tai mai nei mō te kaupapa. Wēnei rā ngā tari o te karauna, te tari ture o te karauna, te arawhiti anō hoki ki te tāhu o te ture, kua tai mai nei mō te kaupapa nei. Anō reira kia koutou ngā mema o te tribunara, anei rā te mihi kawana ki a koutou, whakatau ana ki a mātou, ki a tātou katoa kua hui hui mai nei i runga i te ata nei. Ko huri ake ki ngā waka, ki ngā maunga, ki ngā mana, ngā kārangaranga maha, ki Wainganui a tātou, tēnei rā te mihi kawana ki a koutou, te mihi tēnei ki a koutou, no reira tēnā koutou. Hoi anō, ai e ngā rangatira, ka re tō rohia te tū, ka re tō rohia te kōrero, waihotia te kōrero mo te karauna whainui nei. Engari i runga i tō tātou tikanga nei rei te tuake nei ki te whakahoki te mihi, ko mihi ki a tātou, ki te mihi ki a tātou katoa, ko hui hui mai nei i runga i te kaupapa nunui e pāna ki a tātou. No reira, ki a koutou katoa, ki a tātou katoa, tēnā koutou, tēnā koutou, tēnā koutou katoa.
Roha anō he wai, e pupu ake ana, e awa e mapuna mai ana, i roto i te whatu manawa. Tōna matapono aina i a karere anō, ko tōna matapuna e honu, aina i a karere anō. E kai timu, e kai mari, e kai ope, e kai oa, e kai nui. E kai nui. E kai nui.
Anō reira ko ngā kupu whakamutunga māku, ka piti hono tātai hono rātau ki a rātau, ka piti hono tātai hono ki a tātou, ngā kanohi ora he mihi nei ki a tātou. Tēnā koutou, tēnā tātou katoa.
E rūru ano te rūru he kai ai anō te kai ai. Tēnā ko hau ko Māui tiki tiki o te rangi. Mai whiti taki mohanga hea taki te paerangi. Ke hui e te kura pō i ti whaona ki te paparei o te ihorangi e iri hone. Ki e kao, kao, kao te rā. Ke a turu turu a tai, turu turu a auta. Whano, whano, whano mai te toki a haumi e. Hui e, tai ki e. Ka riro mā tēnei klaki a ngā whainga tawhito. Ko te klaki anuku tawhiti hei hohou i te rongo. Hei whakapuakina mai i aku mihi. Whakau tuai. Ki kā mihi ranga tira. Ki dunga kia mātou te ope. Puta i te motu ko tai mai nei nā runga i te karanga o tēnei kaupapa. Tuatai iho. Karae manti, e mihi atu ana. I tō reo whakamoimiti, i tuku nā tuai, i ala whatai ki tō tātou matu ora tonu nei te rangi. Kia tomo mai tōna wairua, ta whai me tōna wairua manaki ki roto, ki tō tātou whakaminenga e tau nei tēnei lopu minenga. I runga i te kaupapa rangatira, I tō tōngia mai tātou, I kōi o tātou kāinga. Kia tae mai nei, I runga I tēnei kaupapa. Me ki ka rongo, I roto I au krakia, kia mara mai, te tuku, kia tātou, ana manakitanga. Kia puta I tātou I tēnei āhuatanga. Kia puta marama I tātou. Kia kaua tātou e kuhurā ki te pō. E whakararuraru ai. Nāri na kāmihi. 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 E mihi atu ana ki te ope nui nei I tuku na kia au tēnei honore. E whakawaha kōrero, kau tuai, ki ngā mihi. Nā reira tēnā nā koutu o kūwhanauma. E te kai whakawāma tua, o te kōti Māori, tēnā rā koe. Tēnā rā koe, me tō kāhui ko tai mai nei. Te tiro kauake I ngā kaupapa ka hora hia ki mua I te aroaro. Hei tiroanga, hei wānanga. Ko ia ko tai mai nei mātou. Ko nei au e kōrero ke atu ana e pēne ana waku whakaro. Ka tahi anō tētahi āhuatanga pō hau. O tōku ao, o te whitu te kaumarima tau iau e no ana ki runga ki te mato te whenua, ka tohia mai hau ki kone o tēnei kaupapa. E aroha atua nā au, ki o mātua, ki o mātu tupuna. Me o rātau kawenata, I tā moko tiai ki runga ki te kawenata tapu o te tiriti o Waitangi ki konei tātou e noho nei hei ti hai I ngā ki taurangi ao mātou tupu. Kātira. O te hia me te tūmanako e mihi atu ana kia koutou I te karaunga. Ko tai mai nei. Ki konei tātou. Hei tawhai. E rangi me tawhai I runga I te māramatanga. Kia kau e tino tō ngia tēnei kaupapa o te tiriti. Kia toi ai ki roto i te paru. Engari haro rangatiratia e tātou. Me pēhea tātou e tiro i te kaupapa nei. Ia whakatairangi i tia tonu tia te tiriti o Waitangi ko te kawenata ka whānau tia mai tātou i mea ti ai e kāwana hopihana hei witai tātou. Rapua nei tātou te kōtahitanga i roto i wā tātou whiriwhiri. Nā reira e kore tō kia roa aku mihi kia tātou. E rangi me pēnei te ki. E hari nei hau ko tai mai. A tia te matara, te haere mai. Kia tai mai, kia tia kina i tēnei kaupapa. Kariro mā tātou katoa, tēnā. E teki. Arira mā te atua tātou katoa e teki e mana ki atawhai, i ngā wā katoa. E mihi atu ana ki te hunga kāinga. A te ati awa. A toa rangatira. A ngāti rau kawa. E puri i te ana i te mana whenua. E teki ana i enei takiwā. Kia tae e tātou te iwi o te motu. Kia takahi haumaru ai. Ka mihi, ka mihi, ka mihi. O te raki o tātou ma te maha. Ko pīkauria mai e mātou. I o mātou kāinga maha ki runga i o mātou pokowhiwhi. O mātou ma te maha. I hinga mai rā, e hinga atu nei. Kia huia katoa tia ki roto i tēnei kaupapa. Kia hui tahi ti ai ki ngā mate maha. Nā koutou i tako. Nā koutou i tuku ki te kōpu o papa tuanuku. I ngā rangi kua taha kēnei. Kia ki ai te kōrero. Kā ea, kā ea. Kā ea atu kia rātou. Haere mai, haere koutou. Ko koutou rā ko ngā kai whati ki, kai whati kōrero. Ko te awea o te rangi, ko te awea o te whenua. Kia tū pia mai kia piri. Kia tū pia mai kia tata. Ka whiti rerea manu ki te pae. Ou enuku. Ka tahuri mai o koutou mā taki mutunga ki te ao mahua kene koutou. Ka wheriko. Ka nunumi ki tua. Haere au piki te atura te toi huarewa. I piki te atura tō koutou tupuna i a tāwhaki. Tāwhaki nui a hema. Putatara. I te whei au ki te ao marama. E moe mai rā koutou. Tā tira ka tihewa mauri ora. O ngā lālangi kōrera ka hoki mai kia tātou. E aku whanaunga, kia tau te marie, kia tau te aloha tātou kia tātou i roto i tō tātou huihuinga, te roa ngā ke o tēnei rā. Mā te atu anō tātou e teki e mana ki e atawhai, i te au i te pō, i ngā wā katoa. Mauri tū, mauri oho, mauri tau, mauri ora kia tātou katoa.
Ki te takau mā whā,
Kau te whakapono e ka tu te mātenga ka ti tiro ki o te kupu tēnei kei te rangi te atua me huri koutou me ti tiro ki reira Ka huri te mātenga ka titiro whakarao Ki te papa one i ao te aroa ke te whenona u e te kāwana Kuarino te whenua e te rera i te moana Ka tiki nā tu he kupu hakamutu ngā ke māku hei taumata kōrero. Ka tātai whetu ki te rangi mautonu. Tātai tāngata ki te whenua ngaro noa. Ko ngā rārangi maunga ka tū te ao, ka tū te pōko te rārangi tāngata ka heke kangaro. Kia ki hai hinga mai rā he te kura. Ko rātu maera he kura tangi hia he mai aroha ke rātu. Ara mai rā he te ko tātu hene ko ngā mahu e tanga iho o rātu mā. Ngā maramara i rui ia mai i rangi a tea. Ko tātu ano ko ngā urupā ko ngā pātaka kōrero. O rātu mā te kai tārai, te kai whakairo i te kōrero. E noho mai rā ki tua o Paranini. Nā reira kuri hora pai tō tātou whare. Ka maru nei a tātou i tēnei nohoanga. I aku whanaunga tēnā koutou. Tēnā koutou. Tēnā rā tātou katoa. Tēnā koutou.
Kua mutu. Ai, haere tonu. Tēnā koutou. Tēnā koe i te tuatahi tōku tuingane Dr. Monty. Nā te mea nāua no te mahi whakarite ki te atua i tēnei rangi. Kia au tātou ki te pono, ki te tika hoki, tēnā koe. O tira e tautoko ana a hau ngā mihi o te rangatira o te noata. Kevin, Prime, kia koutou. Ki te mana whenua hoki, koutou e koro ana mō ngā mana whenua hone koutou. E tika ana me mihi kia Te Atiawa, kia Ngāti Toa rātou ko Ngāti Raukawa tonu. Nā reira kia rātou, tēnā koutou. Kia koutou katoa, tēnā hoki koutou. Ngā rangatira, ngā mārei kura, ngā kaihautu o ia iwi i taimai konei, ngā kānohi o te karauna, ngā kaihautu o te karauna. Tēnā koutou, tēnā hoki koutou ngā roea, ngā kaikreme, me te hunga e whakarongo mai ana kia tātou katoa. Well, welcome to you all. Those who have come from afar, those who are representing their hapu and iwi or their organisation, claimants, lawyers, the representatives of the Crown. We welcome you here to the Waitangi Tribunal head office. I'm sorry about the cramped conditions. We're not used to having so many people for a hearing of this nature. It's wonderful to see you all here, however, and we'll try to accommodate you as best we can, both on this level and on level 7, where we have a room set up so that people can watch the live stream from that room. I just want to begin by introducing the panel that's sitting here today with me. As you'll see, it's one of the largest panels amassed for a tribunal inquiry. That was long before this particular issue emerged. It was part of the process leading into the constitutional inquiry, looking at broader issues concerning the Constitution. And as I've explained in my directions prior to this hearing, it was important that we bring back the entire panel so that we can not only investigate and inquire into this matter, but also to see it as an integral part of the next phase of the constitutional inquiry. I also will introduce each of them very quickly, not as I usually do, because we need to get on with the business at hand, but you all know Mr. Derek Fox at the end of the table. He was translating for the Crown because our translator was not advised that he had a booking today, and we finally got him online. So those of you who need to have translations, Alan, can we make sure all the Crown representatives have the little black boxes? Oh, good. And anybody else who needs them, please put up your hand and Alan will bring you one of those boxes, or Alan will be assisted by somebody else from staff who will bring those boxes to you. Then we have Mr. Professor David Williams, Emeritus Professor David Williams, who's sitting next to Derek Fox. And then we have Dr. Monty Suter, Dr. Grant Phillipson, Ms. Prue Kapua, and Mr. Kevin Prime. And as you've heard, I'm Chief Judge Karen Fox. We are supported today by our Senior Facilitator, Kyra Makizo, and Don Rowe. Both of them are supporting us today, and our Claims Manager, Heavenly Teofilo, who is they're going to put their hands up so you can see who they are. So Don and Kyra and Heavenly. If you need to see anybody about any of the arrangements today, please see any one of them. We also have the registrar represented here today by Sophie and Meg Russell, and report writing team, because we are already in the process of report writing after today, and that's those people here represented are Ariel Tracy and Judith Pryor, who's watching online. Our translator today is Paihiki Magavi. As I've said, he's just started back online. You should all have him in your ear if you're listening. And Mr. Alan Doyle's our person in charge of the technology. As you've heard, he's the boss of the proceedings. I can't start without him. So that's the team that's supporting our inquiry, and I just want to also note this is an inquiry looking in particular at the claims filed on behalf of the following people. It's the Gaiterangi Coalition Government Urgent Claim, the Te Reo Māori and Justice System Rāmika Claim, Constitutional Ruka Claim, the Constitutional Morgan and Galton Claim, the Constitutional Pōtiki Claim, the Constitutional Daily Paki Claim, the Constitutional Collier and Others Claim, and the Constitutional Mac Claim, and the Taumonu Land Claim. There are also a number of interested parties, approximately 10, who've been given interested party status, and there are about 25 lawyers represented here today who've responded as counsel. I don't intend to take appearances today. I'm just going to note we're going to add your names to the record of inquiry as being present. I will take further issues, however, before we begin. So if anyone has any further issues they want to raise with me after I go through this introduction, please put your hand up and we'll deal with them then. In terms of procedure, you would have got a late last-minute direction yesterday. Forgive me for that. That direction was sent out yesterday afternoon. There are a number of typos in it. If I could go through those with you. Do you have a copy of it there? I had my copy, but I managed to lose it. Here it is. So it set out the timetable. It indicated what witnesses we have questions of. And I want to thank all the witnesses who've provided briefs. I just note that some people haven't been asked to be present for questioning. It's not because your evidence isn't important, it's vitally important, all of it is. It's more because we wanted to use this time as much as possible on those points of clarification which we still need some information on. So you could take it one way, which is that everything we needed to know from you as a witness was provided, so that's the reason why we don't need you. And those who are giving evidence, your additional answers to the questions will be extremely helpful for the tribunal. If you note at paragraph 3, B, it should read due to limited time. I'm sure you all picked that up. And if you go to paragraph dealing with questioning of Crown witnesses, that one's okay. If we go straight to paragraph 15, and then 16D, leave is granted for Ms Sykes to question each witness. I didn't mean each witness. Ms Sykes was the only one who sought leave to question the Crown witnesses should lead counsel not ask all the questions she needed to have answered for her clients. That was granted because no other counsel requested the same thing. So that should read, leave is granted for Ms Sykes to question each Crown witness after the allocated lead counsel have completed their questions. So if you could make that amendment. And then in terms of the next point I wanted to make, paragraph 19, I grant claimant counsel's request for Mrs Kibble, White and Chana to be cross-examined separately. I also, after reflecting with the panel, we want to talk to Lillian Anderson and Mr Warren separately as well. And just more out of, it's paragraph 18. I note that time remains unallocated on Friday. However, I anticipate that this may be used for Crown cross-examination of claimant witnesses. Of course, we can't do that. It was rather that they should provide written questions in writing if you have any additional points you wish to seek clarity on from any of the witnesses. Okay, so we will send this out again with all these changes. And the final point I wanted to make is in terms of cross-examination of other claimant witnesses that are being led by counsel, there will be no cross-examination of those witnesses by any of the claimant counsel. So they'll be led by their own counsel, and they can be re-examined after the tribunal has asked questions, or the Crown if they need to ask anything quickly. Otherwise, the lead counsel will be the only person speaking to the witness after the tribunal finishes. Hope that's clear. All right. Now, the other point that was asked by counsel for the claimants was whether or not the tribunal was going to conduct this inquiry as an interim hearing. What we will require is that we'll consider the matter after we receive further information from the Crown, and so the direction is that the Crown is to file a copy of the relevant Cabinet paper no less than 24 hours after the Cabinet meeting where the decisions have been made that progress the furthering of this bill to either an exposure draft or to Parliament. And we also direct that Council provide an update on the statutory review of statutory enactments dealing with the principles of the treaty at the same time. And then we'll decide whether or not we convene. But at this stage, you will be expected as Claimant Council to file closing submissions by the end of next week, Friday next week. You will have the opportunity to provide further submissions once the Crown paper comes in. If we don't reconvene. And, well, the Crown closing won't come in until after the Cabinet pay. That's how I'd see it. There would be no point in receiving Crown closings until then. And then you'll have the right of reply. All right, so that's all the preliminary matters that I had. Does any council have anything they wish to raise?
Tēnā koe,
Ms Mason.
Ma'am. Just a couple of things in relation to the directions that came out last night. One
Yes,
of
I'm
them,
sorry about that. I was at another meeting and I only had my little phone, so I couldn't read it properly.
in paragraph 7, there was a request or a statement made about the claimant witnesses would have short opening statements. Paragraph 7 of the memorandum that we filed. So it was anticipated in the time that's set out in the timetable that the witnesses would provide 5 or 10 minutes of openings. And then if the claimant counsel cross-examination time is going, then that should afford enough time for that. But Your Honour has also clarified that counsel calling those witnesses can lead them as well, so that should cover that. And then there was some clarity around the request that had been made was for counsel, myself and Ms Sykes to have questions, to reserve leave for questions at the end. And that's set out in paragraph 3, but it might not have been so evident.
You mean leave to...
So leave to cross-examine at the end of the lead applicants. So where the memorandum has referred to Ms Sykes having leave to cross-examine Crown witnesses at the end of the lead claimant counsel, the request had been for myself and Ms Sykes.
Oh, yes. That's fine.
Yes.
If any other council feels that they need to ask a question that hasn't been covered well enough by lead counsel, they should indicate as such to me.
Thank
It's
you.
only I only had that one request. That's the only reason why it's been specifically acknowledged.
Thank you, sir. Thank you, ma'am. Yes, the request had said, it hadn't said Ms Mason, it had just said counsel and Ms Sykes, referring to myself, so that might have led to that. And there's just been another correction in paragraph 10 of the joint memorandum of counsel filed. It says that Ms Sykes was going to be lead counsel for Mr Chana, but it's actually Kaupare Law. That's set out in the timetable. It was just in the joint memorandum that was there. There's just also another request. The cabinet paper that the Crown filed last night says in confidence at the top of it, just checking with counsel for the Crown, that actually it can be distributed to everybody.
It's the document that we provided you this morning?
No, the one that was filed last night, the cabinet paper on supporting considered and coherent treaty provisions and legislation.
Yeah, I think that should be redacted
Crown,
that
can
ought
we have
to
the
be-
microphone on, please?
That should be available to be distributed as you've received it.
Right. All right, thank you. But the one that I've received this morning is redacted.
And then those redactions I expect to remain.
All right, can I just, Your Honour, I requested from my friend a copy of a paper that had been referred to in the briefing, one of the briefings, and that paper was the New Zealand Constitution, Democracy and Open Government briefing dated 28 November 2023, and that copy, and that was from Mr Chana, the Deputy Secretary. So Council received a copy of that, but it may well be that my friend for the Crown provides a redacted copy for the files that on the record for everyone. It's relevant to the inquiry.
We can do that, ma'am. If it's going to be referred to in cross-examination, then that does make sense for it to be more broadly circulated. And the only redaction to it would be required for personal particulars of the officials.
All right. Thank you. So could you send that to our registry now and then they'll distribute it on the list?
Thank you. And there was one further thing, Your Honour. Mr Sadler has appointments, has an important meeting tonight, and he is on the timetable for being on after the Crown witnesses. However, he needs to be leaving by 1:30, and would be very grateful to, depending on timing, be slotted in, if the Crown witnesses haven't been finished, be put in at 12 o'clock. He is,
We were told 3 o'clock.
yeah, his flight is at 3 o'clock, and so he'd need to leave here at 1:30 at the, well, 2 at the latest. But Mr. Sadler has requested 1:30, given his age and the stress of getting to the airport, Your Honour.
Let's see how we go.
Thank you. Thank you.
We'll try to accommodate you, Mr. Sadler. We definitely want to talk to you, so...
And then, Your Honour, just one final thing in relation to the request for an interim hearing. It was set out in the joint memorandum of council that wasn't agreed to by all parties.
I understood that.
Thank you, Ma'am. That's all that we have.
Tēnā koe te kaiwhakoa. Just one
Can
preliminary...
you give me your name when you speak so we've got it on record? Thanks.
Yes, Ms Cherrington from Tuco Law. Yesterday we filed a chronology on behalf of, with a number of claimant councils supporting, and that was at appellation number 3.1.82b. And Mr Heda has kindly printed copies of the documents that aren't on the record that are referred to in that chronology. So I just wanted to hand those forward to Your Honour.
How many copies have you got?
12.
Very
I
good.
understand.
Sophie, Crown first. There's 12 copies, so we need 7. Have you not seen these, Mr. Allen?
I haven't, no.
Your Honour, I will formally file them shortly, and we're just arranging that as well so that they can be put on the record with their own ROI numbers.
Why weren't they filed earlier?
They're referred to in the chronology, but they weren't filed separately, Your Honour. Our apologies for that. They are referred to and referenced in full, but just copies weren't provided with the chronology, which is what we now seek to do.
Mum, that might be my fault. I was on a plane and I was going to check the material that was in the chronology, and we only did that yesterday afternoon. Okay. And we found that those newspaper articles were identified but not on the record of inquiry.
All right, well, you can take the morning adjournment and look at them, and at that point we'll decide whether they go on the record. Thank you. All right, I think that brings us to the end of all...
I have a difficult question. I've listened to your ruling this morning that you don't want us to ask questions of clarification of other claimant witnesses. I have a different view that I'd like the tribunal to consider. There are 4 or 5 quite expert academic witnesses that make certain propositions that I had sought leave, for example, to put some propositions from Dr. Harris to witness Ms. Coates. And if you're not going to allow that because of the interest of time, could I do that in writing?
Yes.
Thank you.
Any counsel who has questions of other witnesses can put those in writing.
And it's only that limited.
We will timetable
Yeah.
that so that you get those in time to complete your closing submissions.
Thank you.
And Ma'am, I just have one matter. It doesn't relate to the procedure so much as the availability of claimant funding. And if it pleases you, I can just address...
I'm sure it'll please the claimants.
Thank you, Ma'am. Yes, it is just to confirm that funding is available through the Ministry to help claimants and their support people with the costs of attending this hearing. So that would be travel, parking, kai, accommodation, etc. Staff from the Ministry of Justice are present here today. They're currently in this little annex room here, but if you need assistance in that regard, then please feel free to introduce yourselves to them and they will take it further for you.
Thank you.
Thank you, Mark.
And I see Ms Mail has her hand up.
Kia ora, Ma'am. I'm just asking, as I'm not, I don't have a speaking role in this hearing, whether I could seek leave to follow along on the live stream rather than stay on the Zoom.
Oh yes, that's entirely over to you.
Thank you, Ma'am.
Tēnā koe te kaiwhakawa. Ko Mrs Tere Tipini tēnei. I'm sorry to hold up proceedings. I'm keen to get into the witnesses. I just noted one point that you made there at the when you were discussing the named claimants for the inquiry. I did note in your direction that you issued after the urgency hearing that we had that you outlined the various submissions and you have claimant submissions and Ngāti Hine were included in the claimant submissions. Instead of the interested party submissions, of that inference of inferred that Ngāti Hine were granted full applicant status in this inquiry. I just wanted to raise it with Your Honour to see whether that were the case and to get clarification on that matter. At your appellation 2.5.27.
Yes, we'll just check our records, but at the moment, either way, whether you're a claimant or an interested party, the evidence that you are tendering is coming onto the record.
Yes, absolutely. Just noting the importance of the opportunity to be considered a full applicant on behalf
yes,
of the
I'm pretty sure that we registered you as a full claimant, but it was a late registration.
I'm in a similar position for Ngā Toki Whakaruranga. There's 3 or 4 that you missed out in your opening comments this morning, but I thought that they had just not... I'm relying on the same direction. They had not been collated in a single place.
I'm sorry I don't have all my directions here, but it's either way, the evidence will be accepted onto the record. And it'll be clarified in directions following this conference, or hearing, sorry.
Oh, tēnā koe te kaiwhakawā, Ms Tūmai, Council, name's Ms Tūmai. I appear for several interested parties who haven't been confirmed that status either. We had raised it in a memorandum on the 18th of April. We've got an appellation 3.1.74. We've tried to just get some confirmation that we have 18 claimants seeking interested party status for this hearing, and we're just wanting to have that confirmed as well.
Okay, well, we'll get back to you on that. I'll have Sophie talk to you at the morning adjournment.
Thank you.
Anyone else? No. In that case, let's begin. Can we first of all hear from Ms Lillian Anderson.
Te kaiwhakawā tēnā koe, i ngā rangatiranga memo o te tribunara, tēnā koutou, e te pāpā hone, te rangatira e kipa, tēnā korua, kia koutou ngā roea, ngā mātā waka, no tēnā iwi, no tēnā hapori, no tēnā whārua, tēnā koutou, tēnā tātou katoa.
Kia ora. Well, welcome. Ngā mihi kia koe, o te rā me o Pukenga katoa o te ao kāwanatanga, tēnei te mihi atu kia koe. Let's begin with asking Mr Derek Fox if you have any questions. Professor Williams?
Thank you, Chief Judge. I've got three short questions. Professor Williams speaking. I've got 3 short questions for this witness. You refer in paragraphs 19 and 23 to the Treaty Provisions Oversight Group, and my question is, does that group continue to have the position that it had
since the 10th of April of this year?
Yes, it does.
Yes, it does. Thank you. In paragraph 21, you refer to the fact that the Minister for Treaty of Waitangi negotiations agreed to the direction that was given on the 18th of February 2024. The Minister for Crown Māori Relations considered but did not sign the briefing. As I understand it, that's his portfolio. Have you any explanation for the fact that it wasn't signed by Mr. Portaka?
No, I don't think it was around that time. I think there were a number of briefings that he would have read but didn't return. So I don't think that one was peculiar in any way.
Though it was in
But I don't. Yes, it was
his
him.
portfolio area.
Yes.
And it wasn't signed by him.
No.
Right. Paragraph 31. It's responding to the questions that the tribunal asked, and you say that the terms of the commitment are set in place. That's the coalition government commitment, set in place. But there are a range of options open to the ministers. Can you just explain what you mean by a range of options when the commitments are set in place?
Of course. So the direction in the coalition agreement was endorsed by Cabinet on the 28th of November 2023. Those set the terms in place, but I think as officials, our job is always to make sure that we offer advice and options to ministers about ways to execute those commitments or those priorities. And so that's what I was referring to then.
So, supplementary to that, I assume you take it as your role is not to question the policy, because you've said it's set in place. So your advice is only about how to implement it.
So the important distinguishing feature between ministers and officials is that ministers decide the direction of their portfolios, they decide the priorities for their portfolios, and government decides the targets for the government of the day. Agency's role is to provide free and frank advice about those targets and agreements and how to implement those, and to provide options on how ministers may wish to proceed.
Though normally in a policy development context, the government wouldn't have a predetermined set decision.
I think governments over the last 20 years have come into power with a set of things that they wanted to achieve. I think the difference here is that these are contained in the coalition government agreements that they've reached.
Thank you for that.
You're welcome.
Thank you very much, Lou.
You're welcome.
Dr. Suti.
Tēnā koe, Lou.
Tēnā koe.
Right. So in the weekly status reports that came in as part of your attachments.
Yes.
To the Minister for Māori Crown Relations regarding the proposed work around legislative references to principles of the Treaty of Waitangi, you advised that one of the key matters to consider is managing engagement with Māori.
Yes.
And so what did you mean by that, or can you clarify that?
As the tribunal would be aware, one of the really important roles that we play at Te Arawhiti is to provide advice to government on a few key matters, and I can outline those. Generally, it's about understanding of the treaty context, both historically and contemporarily. It's about advice on existing rights and interests wherever those may arise. And it's about appropriate levels of engagement with Māori. And so our reference in that weekly report was about the different options that ministers may wish to take in engaging with Māori on these important issues.
And you mentioned the Poutikanga of the National Iwi Chairs Forum.
Yes.
That they are showing interest in being involved in the revision. And in terms of your advice, is that who you mean by engaging Māori?
No, so our advice would range from, yes, the National Iwi Chairs Forum is an important forum for ministers. We lead that relationship, and they have a set of priorities that they agree with government that they will pursue together. But our advice is often wider in terms of how the proposals might affect post-settlement commitments, how they might affect takutai moana, how they might affect Māori more generally, hapu and iwi interests in Ngārohe. So we go to that extent.
Right. So I read the Building Closer Partnerships with Māori that Te Arawhiti has.
Yes.
And it says, well, you espouse your framework for building closer partnerships with Māori are to build the relationships before focusing on the work, to plan together from the start, to value each party's contribution, to share decision making, and in your guidelines for engagement with Māori, you say engage early, be inclusive, think broadly. Effective engagement with Māori is the key to producing better quality outcomes and realising Māori Crown partnerships. The risk to the partnership is noted in the advice to the ministers. So is this the sort of information you're giving them?
Yes, so the guidelines are a tool that we offer based on experience to public service agencies. They have been through Cabinet, agreed and approved, and so that is the nature of the engagement and partnership advice we offer, yes.
So you would agree then that the best outcome is if you talk to as many representative entities in Māoridom as possible?
That is consistently our advice.
Kia ora.
Dr. Phillipson.
Tēnā koe.
Tēnā koe, Dr. Phillipson.
I just have a couple of questions about the review of the treaty principles in the legislation.
Sure.
Do you know why the review was moved from Te Arawhiti to the Ministry of Justice?
I think since the coalition agreement, it had been unclear who would lead the work. We, as the chair of the Treaty Provisions Oversight Group, assumed it might be us. And so we proactively provided ministers with some of the work that we'd been doing over the course of the last government around treaty provisions proactively in December last year. At that point, we still assumed it was us. And then I think there was a discussion at a ministerial level of where the right place would be for that work to sit. And that became Minister Goldsmith. There was a discussion then about whether it would be the Ministry of Justice or Te Arawhiti that would lead that work, and the decision was made that it would be the Ministry of Justice supported by Te Arawhiti. And so that's the directive now.
Okay, thank you. And with that group you just mentioned, TPOG, I don't know if it's called that.
Yes, unfortunately.
What can you summarise the criteria used by that group for when a treaty clause is needed, or what kind of clause, a more general one or a more specific one?
So the process, and Warren will probably be able to explain this a lot better than me because he participates in the Treaty Provisions Oversight Group. But agencies come to the group when they are contemplating the use of a treaty clause or a treaty principles clause. They seek advice on the appropriateness of the clause, whether it's operative or non-operative, and whether or not, in fact, I think they need to implement a treaty clause. So there are judgments being made and advice being given about how they may wish to take that forward. At the end of the day, what they choose to do is up to that agency. So it is about looking for consistency. That was the whole aim of TPOG, and to make sure that agencies fully understand when they are including treaty clauses exactly what they are committing to.
And is that the reason it was set up? Because they weren't understanding, or?
I think it was purely to look at consistency across all of the different pieces of legislation that were being constructed at the time, and a desire from ministers and cabinet at that time to have some oversight over that consistency.
Thank you. And what do you see as the benefits for the Māori treaty partner of the review of treaty clauses?
I think the review in and of itself isn't damaging. I think it's the way that the review might be undertaken that Māori would be concerned about, and of course the end result of that review. But I think, as Ms Coates said in her evidence, in and of itself the review is not a bad thing. And I think Māori would be concerned about the process used to undertake the review, and any outcomes that might have.
And do you know if any consideration's been given to reviewing legislation that doesn't have a treaty clause to see if one needs to be added?
I think agencies are continually, as they look through their legislative program, agencies are continuing to consider how and when the treaty applies in that legislation. So I don't think any of that is stopped per se, but you might want to ask Warren about how busy TPOG are at the moment.
Okay, thank you. That's all my questions.
Ms Kapua?
Kia ora.
Ms Kapua.
I just had a couple of questions. Most have been answered. In the first paragraph, you talk about being operationally autonomous. What do you understand is meant by being operationally autonomous?
So Te Arawhiti has its own mandate through Cabinet in terms of what its role is. We have our own ministers that we report to. I'm a chief executive that sits in the public service leadership team, and I'm in charge of what happens in my organisation. There are matters for which, as a departmental agency, we work through and with the Ministry of Justice, things around the operation of our corporate functions, our risk and assurance and matters like that.
Okay. So when you then speak in paragraph 12 about the work that was undertaken by Te Arawhiti in relation to the government commitment contained in the coalition agreement, how does that desire to undertake work on the coalition agreement relate to you being operationally autonomous? How, if you're operationally autonomous and yet the work that you proactively undertook was about the coalition agreements, does that override the coalition agreements, override the being operationally autonomous?
So we are operationally autonomous from the Ministry of Justice is probably what that first sentence referred to, not from Parliament itself. However, when it comes to the coalition agreements, we, like every other agency, are there to serve the government of the day. We proactively provided that briefing for two reasons. One is because TPOG was an important part of our functions, and we were briefing our new ministers on all of the functions that we have. And secondly, given that commitment, we wanted to outline the work that had already been done.
And just in paragraph 14, I assume that's supposed to be the 4th of December 2023.
Yes,
right.
Yes, not future focused.
Not future focused.
That I'm aware of.
Right. And you've talked a little bit about the assumption. The paper that you've got that lists the legislation that you've identified.
Yes.
Is there any reason why the Resource Management Act wasn't included in that list?
I don't know. I'm sorry, I don't know the answer to that question, Ms Kapua. Mr Fraser may be able to help you.
Okay, thank you.
Sorry, Warren.
In terms of the TPOG, in relation to the recommendations, you there's a reference, I'm not sure if this should go to Mr Fraser, but
Probably.
of 22 bills.
Yes.
Are you familiar with the bills that TPOG advised on?
Not the detail, no.
Okay, I'll leave that for. The reference in your report, although most of it is redacted, but the reference in the report on the 1st to the 5th of April refers in paragraph 14, as you know, the Prime Minister's office has now been approached to clarify who will lead this commitment. Do you know who the Prime Minister's office was approached by?
No. No, all I know is that I think between ourselves and the Ministry of Justice, we were just seeking clarity on who would lead the work.
So
through our ministers.
So do I take it from that the approach came either from Te Arawhiti or Ministry of Justice?
No, it wouldn't have been directly through to PMO. It might have been through the ministers' offices. We wouldn't make that approach directly.
So as far as you know, it had somehow got to the Prime Minister's office, but you're not sure of the route by which it got there? Okay. Thank you. No further questions.
Well, I have a few questions, I'm afraid. Can you walk me through, because I haven't done an urgency for a while, as you could probably tell. Anyway, can you walk me through the policy process leading to a cabinet decision? What's the process from the beginning?
Oh, gee, I feel like this is another one I need to throw to Warren, but I'll have a good go. At the first instance, you have...
We can leave it to Warren.
Yeah, I think let's leave it to Warren.
Okay.
It's in his title that he's in charge of policy.
Okay. So, do you know, to what extent then do you know about the process of consultation leading to a draft cabinet paper?
Oh, so we are very regularly consulted on pretty much every cabinet paper that goes through to cabinet, particularly where those cabinet papers touch on treaty matters, rights and interests, and or engagement with Māori. We provide the same advice as Mr Suter pointed to in some of the guidance we give. So we are consulted first as an agency. That feedback is provided back through the agency that's leading that policy proposal. They will collate that, and often our comments will either appear separately as a Te Arawhiti comment, or it will appear as part of the agency's policy analysis. Once that paper goes to ministers, we then have an opportunity to give our minister advice on what he or she might offer into that policy proposal in a draft form. And then that's probably the two key areas of consultation during the policy process in a cabinet paper.
Okay, and you'd expect ministries who have some overlapping responsibility to be consulted?
Yes.
So in this case of the Treaty of Waitangi Principles Bill, there'd be Ministry of Justice, yourselves, TPK,
yes,
and who else?
I think Crown Law.
Crown Law, and that would be it?
I think at the moment, I think that was where it went, yes.
Okay. Do you expect the Parliamentary Council's office to be consulted at that point?
Not usually.
Why would they be consulted at the draft cabinet policy paper stage?
Because at that point it's not clear that there's legislative intent or that there's a legislative proposal that would need to go to cabinet. At that point you are simply coming up with the idea of what that legislation, what policies would form the basis of that legislation. So in my experience it would not be unusual for them not to be consulted.
Right. But you'd expect them to be consulted if there were a provisional text for a bill?
Yes, at some point, yes.
And that would happen for a draft cabinet paper?
If that cabinet paper was intending to be considered by the Cabinet Legislative Committee or something similar, then yes.
Right. So that's the Legislation Design and Advisory Committee?
That is a different group, but they are often consulted where there are proposals that are complex,
okay, so you've got
or
two.
where officials are seeking advice. Sorry,
Right.
no.
Well, page 9 of their guidelines for legislation design requires a few. Do you have Mr. Allen or Mr. Watson? Do you have a copy of that you can share with Ms. Anderson? Shall I just read it?
Yes, please, ma'am.
It says, legislation should be constitutionally sound. Legislation should be consistent with the Treaty of Waitangi and should reflect the fundamental values and principles of a democratic society, etc.
Yes.
So you'd expect to see in draft legislation consistency with the Treaty of Waitangi?
Yes.
Now, you were asked by Ms. Kapua about the transfer of responsibility from Te Arawhiti to the Ministry of Justice.
Yes.
That took place on the 10th of April.
Yes.
That was the day that urgency for this matter was granted. Is there any link?
No, not that I'm aware of.
Okay. In your weekly status reports to the Minister for Māori Crown Relations, dated 28th of March 2024, at paragraph 19, and the 5th of April 2024, paragraph 14, you mentioned the Prime Minister was approached to change the lead for the review.
I think the Prime Minister was actually asked for clarification on who it was intended would lead the review. So that had been unclear since the coalition came into power.
Yes, you answered that quite well, I thought.
Thank you.
I just wondered, though, if it didn't come from officials, the only other people it could have come from were ministers. Is that
Yes.
right? Is that what
So
I
I think-
take from your answer?
I don't think, there's nothing to hide here. What we were seeking clarification, both Andrew and I, from our respective and joint ministers about who was going to lead the work, because we wanted that clarity for our own work programs. And I think the ministers themselves weren't clear about who would lead that work. So they were going to meet to discuss it and seek clarification from the Prime Minister if needed.
Okay. So does that mean both the Minister of Justice and the Associate Minister of Justice are responsible now for the statutory review of enactments dealing with the principles of the treaty?
That's a question you'll need to ask Mr. Kibblewhite.
Well,
But
you
my
don't
understanding is it's the Minister of Justice.
Just the Minister of Justice?
That's my understanding, yes, ma'am.
Prior to the transfer of the lead role to the Ministry of Justice, had you done any work between December 2023 and April 10th, 2024? Or had you just let it lie?
We did a bit of work largely to try and come up with a framework that we would, if ministers directed us to lead this work, what is the framework we would put around the work to try and understand what ministers needed. So we sat down and tried to look at what would be the scope. These are questions I think we were wanting to ask ministers when we did engage on the work. What was going to be the scope of the work in terms of the review? What were their priority pieces of legislation that they wanted to look at? What approach did they want to take across the whole or just a few pieces of those legislation. How would we manage the fact that each piece of legislation was owned by an agency that is not us, and they own that legislation, as does the minister? What were ministers' preferences on engagement with Māori, were some of the questions we were going to pose, and then of course was there any interaction with the Treaty Principles Bill. So we never developed that work. These were the framing questions we were going to put to ministers were we to lead the work.
So you did no briefings to Minister Pōtaka?
No.
After December?
No.
And the documents you were talking about, the framing of questions, are they recorded anywhere?
I think only through the weekly report we might have referred to some of them. In our officials meeting, we would have covered those off whenever we met with him in terms of these are the questions we want to put to you. The issue he had was he wasn't sure if he was leading it either.
I see. And why did it take so long, do you think, for there to be clarity around that?
I think there was a lot happening at the time. For instance, we were right in the middle of Waitangi preparations and all of that sort of activity. And I think, I'm not sure why it took so long. It's not unusual for a decision like that to take some time.
Right. Now, paragraph 31 of your brief, if you just have a look at it. Just remind yourself of it. Is your answer there to our questions? And by the way, thank you for the answers. They were very helpful. Of course. So, is your answer, though, quite consistent with the Cabinet Office circular dated 25 March 2024 relating to the coalition agreements?
I think it will be. I will just have to have a look. I hope so. Yes, I believe so, Ma'am.
You think so? So, paragraph 32, did you lead the work on the following documents? And they're the documents that I put on the record of inquiry 2 days ago?
Yes.
And they were all drawn up by your office except for 2 of the cabinet papers that were also in that list. 3 of them, including the cabinet paper of 25th March 2024.
So the ones authored
I
or
think
worked
Dr.
on...
Monti's already taken you through one.
Yes. So it would be the 2 cabinet circulars on Treaty of Waitangi guidance, coordination
Yes.
of Treaty of
2019, those 2 documents are.
So the exception to that, obviously, is the coalition.
Right. So you
cabinet.
had something to do with the drafting of all those other documents.
Yes.
Ma'am, I'm hesitant to interrupt, but could you please refer to document numbers so that if in our submissions we can have them?
Well, my document number is the brief, the memo that went out 2 days ago.
At 6.2.4 and to 6.
Oh, I'll get that to you.
Yeah, thank you.
So, if you are involved in all of the development of all those documents, is it surprising to you then that because of the coalition agreement commitments, that it wouldn't matter what you advised, it's going to be ignored in favour of pursuing and giving effect to the coalition agreement?
I think, Mum, we take our responsibility very seriously, and so we would continue to offer that advice to the highest levels of government. Whether or not ministers choose to take that advice is up to them. And we do all we can, whether it's through briefings, through cabinet papers, through face-to-face meetings, to relay the same advice that I talked about earlier in terms of understanding the treaty context, rights and interests, and engagement with Māori.
Right. So if I could just, like Dr. Monti, take you to the March 22 document, which is providing for Treaty of Waitangi and legislation and supporting policy decisions.
Yes.
And it's paragraph 15, page 4.
Sorry, which one was it?
6.2.3, and it's the document providing for the Treaty of Waitangi and legislation and supporting policy design, questions for policymakers. March 2022.
Oh, yes. Yes, we have it.
And at page 4, it says, Te Ara Whiti, the Office for Māori Crown Relations, is an agency dedicated to making the Crown a better treaty partner through fostering strong, ongoing and effective relationships with Māori across government and bringing the treaty and Te Ao Māori to the heart of government policy.
Yes.
So, if that is your mission, doesn't your mission go beyond just advising?
We're a public service agency, Mum, and like every public service agency, our role is to serve the government of the day and to provide them with the best advice that we can. And that's what we do. We try to look to put treaty matters right into the heart of policy and legislation within the Crown, but decisions ultimately lie with ministers about how far they will take that.
Right. Yes, well, I accept that, but you certainly have a very important role.
Thank you.
So if that's your role, then how is it consistent with complying with the Cabinet Office circular dated 25 March 2024 at paragraph 4.3?
So it is consistent in my view. So as a public service chief executive, I must know what the government's priorities are, whether they're contained in the coalition agreements, whether they are targets announced by government, or whether they are priorities set by my respective ministers. And it's my job to offer them advice on those priorities, and then once they make decisions on those priorities, to implement those.
Right, but they've already made the decision.
We're at a stage where the decisions haven't been finalised. And
it says all ministers, parliamentary undersecretaries, chief executives and their respective officers need to be familiar with the two agreements and ensure that they have processes in place to implement them.
I understand that, but within that framing, there is the ability for ministers to, and they have, and continue to, seek advice on how best to implement the coalition agreements. They are open to options about how to pursue those agreements and advice on the treaty implications of pursuing things. And that's the role that we play.
I see. So how do you provide advice in that context on the Treaty Principles Bill?
So we have the mechanisms of consultation when there are draft papers. We have the mechanism of when our minister receives those draft papers, providing him advice that he can offer to his colleagues and to Cabinet, and that is the key extent of our ability to influence.
Okay. All right. So it's more let's help Minister Pōtaka get ready to go to Cabinet, and let's talk to him about what he can discuss in terms of consultation with Te Ao Māori.
And it would also apply to Minister Goldsmith as our other reporting minister, different depending on the portfolios, but yes.
Okay. Thank you, that's very helpful.
You're welcome.
And I hope we haven't kept you too long from your holiday. Is it a holiday or is it work?
How do you know about that?
We were advised.
You were unavailable.
No, you haven't.
And if you wouldn't mind answering questions now from Council.
Of course.
Tēnā koe, Mum. I'm actually happy to ask my questions to them both as a panel. Kei te pai, so you could move to your next witness. Kei te pai.
We do. All right, Mr. Fox, do you have any questions of our next witness, Mr. Warren Fraser?
Ma'am, I have some questions for Ms. Anderson.
Separate?
Yes.
Or do you want to wait until we finish this now?
Yeah, I just know that, I just want to say that I have some questions for her, especially in light of the questioning from the panel.
All right, well, you may wish to wait for the questions from lead counsel first. All right, Mr. Fraser? Mr. Fox? No questions? Professor Williams?
Yes, Tēnā koe. Thank you for your evidence.
Tēnā koe.
I'll push the button. Tēnā koe, thank you for your evidence. Question I didn't ask Ms. Anderson relates to paragraph 10. And I'm just wondering whether your reading of the grammar of the coalition agreement is the same as mine in relation to the comprehensive review of all legislation with principles in. And it says at the end of the quotation on that in your paragraph 12, and replace all such references with specific words relating to the relevance and application of the treaty, or repeal the references. So is my understanding of the grammar of that is that whichever option is taken, whether you replace or completely repeal, there will be no reference whatsoever to the expression principles of the Treaty of Waitangi or principles of Te Tiriti or Waitangi. Is that your understanding of those words?
No, sir. I think that especially in the words around replace all such references with specific words relevant to relating to the relevance and application of the treaty, I can conceive of clauses that we already have on the statute books that talk about the principles of the treaty, to give effect to the principles of the Treaty of Waitangi. This Act does X, Y, and Z. So I can absolutely imagine within that framing that references to the principles of the Treaty of Waitangi would remain on the statute books.
Right. Okay. Just a clarification from my colleague, Ms. Kapua's question. I think she asked about the Resource Management Act. Am I correct that your paper of the 4th of December was in that brief period when there was no Resource Management Act before it revived itself?
Well, actually, it carried on in effect when the Natural and Built Environments Act was passed. So I am astonished that our search did not pick up the Resource Management Act. But clearly that has references in it. Oh, it did? Forgive me, I think we know that the Resource Management Act does contain provisions that reference to the principles of the Treaty of Waitangi. Our briefing did note the way that we had conducted the search, that it was of the legislation website. And as everyone will know, the terms of your search can sometimes limit the results you get. But this was preliminary and initial advice designed to try and give ministers an idea of what they might be biting off in terms of the commitment to review all such clauses, and to know that, well, we might be talking about 40-odd of them. 40-odd of those statutes, and that's a number to get through. How you tackle that would be a question for the incoming government. I'm just being handed that actually it is, the Resource Management Act is listed on page 4. It's number 10 in the list appended to the briefing in Appendix B.
Thank you. Can I just ask, this is a joint brief of evidence, so can I ask you the same question I asked Ms. Anderson about paragraph 31? Because I'm struggling to understand how you can give advice about a range of options when there is a predetermined commitment set in place?
Well, I think I think we need to think about the coalition agreements. What are they? They're an agreement between political parties to form a government. And so they're a clear indication from those coalition partners about their direction of travel, what they agree on, where they want to go. I think it falls into the realm for officials in their public service role to give free and frank advice to ministers once they're in government about their direction of travel and the things that they might want to consider as they go down that path. So I think that gives scope for officials to provide advice on the range of matters that they should consider.
Okay, thank you.
Well, this might have been more appropriate for the tumu whakarai, but I'll ask it anyway. You attend all the weekly briefings too?
With ministers? Usually, yes.
So do you think you've conveyed advice to the ministers sufficiently for them to understand the potential consequences for and adverse impacts on Crown Māori relations? They fully understand the impacts that the work might have on Crown Māori relations.
Of a review of treaty clauses and legislation?
Yes.
The review hasn't been, the scope of the review, the conduct of the review has not yet been determined. The fact of having a review, I don't think we would say that there is a major impact on Māori Crown relations. It would be how that review is conducted.
Thank you.
Sorry, can I ask a supplementary to that? If the review's purpose is to amend legislation that's already settled or repeal it, why do you think there won't be an impact on Crown Māori relations?
Well, I think that the conduct of a review is a process. So I think the conduct of a review, and on the basis of advice that we would typically give, based on the documents you were referring to earlier with Lil.
It's not the conduct of the review I'm particularly noting. It's the fact that the review's purpose is for a stated reason.
Well, I think we would always allow for outcomes to change on the basis of the process. The government in its coalition agreement has certainly given indication of the direction of travel, and the kind of advice we've outlined in our weekly reports to say, look, there are a number of matters that you're going to need to consider, or even in our initial brief to ask about the scope. The coalition commitment in the New Zealand First agreement talks about clauses that need more description, and there are, in our initial analysis, a number of such provisions that already have that description. It would be a question, I think, for that review to ask, are those in scope or not? And that's why leadership of the review, which minister's in charge, and further direction from government about how to conduct the review, the scope of it, what engagement would happen with Māori, when that would happen, which agencies would lead, would there be a review, a role for the Treaty Provisions Oversight Group? Those are all outstanding questions yet to be answered.
Right, thank you.
Can I just ask again, that advice and your sense that there is won't be any significant impact to Crown Māori relations, is that based on just your experience, expertise, or have you gauged the feel of Māori out there in in the country.
No, I'm not saying that there's no impact on the Māori Crown relationship. Clearly there's concern through this hearing with the words in the coalition agreement. All I'm saying is that the fact of a review on its own, announcing that there will be a review on its own, would not of itself impact the Māori Crown relationship.
And I'm asking, how do you know that if you haven't spoken to Māori about that?
I take your point, and I don't want to discount the concern that's evident in this room. What I'm trying to get at is that as the terms of a review get put in place and decided, we will be advising government to undertake a process that would be treaty compliant.
Tēnā koe, Mr. Fraser. I understand your point about how a review itself might not disturb the relationship. It might be the outcomes of the review. But my questions go back to the kind of principles on which a review might be conducted. And so I'm wondering, in the work that, so this is the same question I asked Lil, the work that TPOG has done, have you developed criteria for when it's more appropriate to have a general reference, such as give effect to the provisions of the to the principles of the treaty, or a more specific wording as to that first one you mentioned? So, for example, what's in the Heritage New Zealand Act, where it says the Crown will the treaty principles will be given effect by doing X, Y, and Z. Do you have criteria for when one is more appropriate than the other, or how do you decide when you're advising agencies which kind of provision they should use?
I think, strictly speaking, the answer is no. We don't have set criteria. The guidance that TPOG that was issued along with the creation of the Treaty Provisions Oversight Group talks about needing to be context specific, and that the role of the group is to be advisory and to be facilitative of the sponsoring agency's process. So an agency contemplating legislation in their portfolio area and thinking about the treaty relationship and how to provide for it. What TPOG exists for is to have an open conversation with that agency to help them in their policy thinking and what might be the right way to provide for the relationship. I know that in the abstract that's quite difficult, and but if I may, I might try and give you an example that in preparation I was trying to think how could I explain this. If take emergency management. Recently, we've experienced Cyclone Gabrielle and all the effects of that and severe weather events in the North Island. And one of the and forgive me, this is not an area that I'm an expert in, so this is just a thought about it. Please don't take my evidence as expert on emergency management. But to look at that system, there have been reviews of how well did the system perform, and could we do better, and what role can Māori play in emergency management. And then the range of questions in relation to that last question could start from a treaty lens about, say, a partnership with Māori, or it could be about the role of marae as emergency headquarters. It could relate to participation in the preparation for future emergencies and the design of systems. If the policy department looking at developing that is thinking about how to provide for that relationship, then there's a range of options that they might consider, whether it be in legislation or in participation in systems or bodies or on-the-ground cooperation, some of which may be relevant or suitable for legislation, others that may not be. And that's the kind of conversation that we would have with an agency to explore what their policy is trying to achieve.
I see. That's quite different than how I'd imagined it. So, just briefly, then, what is the consistency that that body was set up to achieve? What is it trying to make consistent?
I think consistencies are kind of a subset. What ministers were concerned about at the time was the range of provisions, and there's a nice graph that shows over time the growth in the number of references to treaty principles or the treaty in legislation. And it also shows the range of references and the subtle wording differences on the statute book. And each time you create a new set of words, there's give effect to, there's have regard to the principles, there's honour the treaty, there's a range that's set out in that guidance. But every time you have a new reference, I think the courts are entitled to wonder, did Parliament mean something different here in this instance from the last time that this phrase was used, compared to other different references? And if so, what is that difference?
So that leads me back to the criteria of how you advise what kind of reference should be used. So would it help if I put that question in writing, and you could have some time to think about that and maybe consult the other members of that group?
Sure.
Yeah, okay. That's all. Thank you.
Ms. Kapua?
Thank you, ma'am. Mr. Fraser, just to follow on from Dr. Phillipson's question, in the supplementary briefing that was attached with the evidence under, whatever it is, A22A, you talk about why the Treaty Provisions Oversize Group was established, and it says we are seeing an over-reliance on treaty clauses. What do you mean by an over-reliance on treaty clauses?
I think the observation was that sometimes a treaty clause was being put into legislation without a lot of thought. And the treaty provisions oversight, and this was an observation of ministers, and that the Treaty Provisions Oversight Group was asked or created to ensure that if that was an agency was thinking about putting a treaty provision into legislation, that it was the right vehicle to give effect to the relationship in the way that I was trying to describe in relation to emergency management.
Right, so it's slightly different than consistency.
Well, in that investigation, if the intent was the same or very similar to the intent of other pieces of legislation, then I think we'd be recommending that they use the same words so that there isn't an unnecessary variation on the statute book that gives rise to the potential for different interpretation.
Right. So, and this was when the group was established in 2022. When abouts in 2022 was it established?
After consideration of after Cabinet's agreement, the group was formed relatively soon afterwards.
So what kind of month, time of the year in 2022 are we talking?
Forgive me, I can't remember the date of the cabinet paper, but my recollection is that it was mid-year or so.
Mid-year. So, and that came from a concern raised by ministers. So were those the ministers that you were reporting to at that time?
Yes.
Right. So Minister for Māori Development and Minister of Justice?
Yes, the Attorney-General also. I think the cabinet paper went up in the names of the Attorney-General, the Minister for Māori Crown Relations and the Minister for Treaty of Waitangi negotiations.
Okay.
Sorry, can I just ask a point of clarification? All Labour ministers at the time?
At the time, that was, yes.
So in that same supplementary briefing in paragraph 12, you say that during that period of time from mid-2022 until December, I think, of 2023, the group had provided advice on 22 bills or legislative proposals over that 14 months. Is that correct?
Sorry, ma'am, I'm not with you on which paper we're looking at.
The supplementary briefing paper, that is A22A. The supplementary briefing that's at the end of all the table of treaty provisions.
After your colourful graph.
Yes.
And it's Appendix D.
Thank you. And sorry, ma'am, your paragraph reference
Is
now?
12, the last paragraph. So,
oh, yes, right.
Provided on 22 bills or legislative proposals over 14 months.
Right.
In the, and I'm sorry to be taking you back and forward here, but in the actual full briefing paper, so that's the briefing paper on the 4th of December 2023, which was the full references to the treaty principles and legislation. And there you refer to the, in paragraph 13, to notably the three most recent clauses all adopt the higher weighting of give effect, showing some standardisation. Is that correct?
Yes.
So that would have been based on the advice or input of the Treaty Provisions Oversight Group?
Yes, those bills should have come through that group, yes.
Do you know what, well, it's got the list of the bills down there,
In the
so
footnote, yes.
those three bills all went through? Are you aware of whether they went through?
I would need to check. In that supplementary briefing paper on the group itself, you refer in paragraph 9 that proposals to reflect the treaty and legislation did not appear to be based on robust treaty and policy analysis, which gave rise to the establishment of the group. Who was providing the policy and treaty analysis prior to the group being established? I think we'd say that it's the responsibility of every government agency to provide treaty analysis on the proposals that it was putting forward. So in the absence of the Treaty Provisions Oversight Group, it's things like the legislation design and advisory group's guidelines that were cited earlier. And it's things like being the guidance that we provide in the Cabinet Office circular about being able to identify and work with Māori on what rights and interests might be applicable to a particular policy, and then to be working those matters through into policy proposals and ultimately, if it's legislation, legislative proposals.
Would Te Arawhiti have been giving treaty and policy analysis prior to the establishment of the group?
Yes, to the extent that we can. Government is a very busy place. We can't advise on every single policy or bill going forward.
So would that reference have been to the fact that perhaps there was a perception that the treaty and policy analysis being given wasn't robust enough that gave rise to the group being established?
Yes, I think that's fair. I think it would be fair to say that the Crown's capability is still developing in this space.
Okay. And just one final question in the briefing paper, and actually I should have asked it of the Tumu Whakarai, but in the briefing paper it says in paragraph 21 provides the possibility of further steps, one of which is to invite the Law Commission to undertake a review of references to treaty principles. Are you aware of whether there's been any reaction in relation to that briefing paper as to the suggestion of a referral to the Law Commission?
No.
Okay. Thank you. Thank you.
Mr. Prime?
No.
Well, I had that general question that I asked earlier. Can you step us step by step through the policy process?
Raj can help me out too. Generally, a policy process will start with trying to identify what's the problem that we're trying to solve. And we'll spend a bit of time on that to sometimes weed your way through some symptoms of a problem to get to the nut of a problem. Problem definition helps focus what you're doing and then be able to generate options for how you might address that problem. You typically work through what options might address the problem best. Think about the pros and cons of those, the costs, other criteria that you might develop to weigh which particular option might be better. Generally, put those options to decision makers for guidance. And
you mean ministers?
Yes, and trying to relate it to the things before the tribunal today. Cabinet will there'll be a policy decision at Cabinet. And the policy decision might include, yes, we want to develop some legislation, and permission then to develop the legislation would then start the process of working with the Parliamentary Council Office.
Right. So the Parliamentary Council Office would come after the Cabinet decision?
Usually that's right.
Thank you. And the consultation process would include overlapping ministries that have an interest in the subject matter?
Yes, I mean, again, developing policy, good policy will engage the people it affects. So a good policy process will usually involve public consultation, and where particular interests are identified, it will include those groups, and treaty partners are typically one of those groups.
Right. And what Cabinet or other committees such as TPOG, what other committees would be consulted?
I'm not sure if it's quite a consultation that the process in developing policy. If there is other agencies with agency and portfolio interests in the matter, yes, they should be invited to see the development of the work, typically in a draft Cabinet paper, so that they can comment. If the issues are very closely related, you might expect an agency to be setting up working groups of combined agencies so that all of those things can be taken into account before the policy paper is written.
Okay. Does the Cabinet Māori Crown Relations Te Arawhiti Committee, MCR, still exist?
No.
So that's been taken over by TPOG?
No. TPOG is only a senior officials group.
Right.
It's not made up of ministers. It's an officials group.
Okay, so there's no Cabinet Committee now charged with the same responsibility that the Cabinet Māori Crown Relations Te Arawhiti Committee had
Each government
under the
determines,
previous government.
Each government determines which cabinet committees, how they will organise themselves with cabinet committees, and the portfolio responsibilities that used to be considered by that committee now come under the Social Outcomes Committee.
Social Outcomes Committee. So you'd expect that any draft cabinet paper dealing with the review would go to the Social Outcomes Committee.
That's right.
And who sits on the Social Outcomes Committee?
Oh, forgive me, ma'am. The membership is published, but I don't have it. We can provide the list.
Thank you, that would be helpful. Well, that was very helpful for me. And I'm sorry that I begin at this process always at base one, so I know how we work through it. Do you think that the Cabinet Minute or Circular of March 2024, which I referred Ms Anderson to, which deals with the coalition agreements.
Yes.
Is that consistent with the mission of Te Arawhiti?
I don't think that the purpose of the circular, or the authors of the circular, would have been thinking about the mission of Te Arawhiti in organising it. This is...
Well, that's fine, but do you think it's consistent with it?
It can be read so, yes.
How?
I think you're referring to, well, how
Well,
do
I refer to that paragraph 4.3 that I referred Ms Anderson to. Oh, sorry, 4.3. Is it 4.3?
Yes, the chief executives and their officers need to be familiar with the coalition agreements and ensure they have processes in place to implement them. Yes, ma'am, in as much as the coalition agreements, as I said before, are direction setting of where this government intends to go. That doesn't mean that it doesn't take advice. The 4.5 of that same circular talks about ministers are expected to consult other relevant portfolio ministers.
Yes.
And that in the way that we're describing would include the scope for advice from the Māori Crown Relations portfolio on matters that go to Cabinet impacting on that portfolio.
Right. So is then the Treaty Principles Bill, as it's reflected in the ACT policy document, which is now part of the coalition agreement, which this Cabinet circular gives effect to, is that text of the Treaty Principles Bill, in your opinion, as the lead policy manager for Te Arawhiti, consistent with the Crown's obligations under the Treaty of Waitangi?
No.
So, what is the status of the Cabinet circulars dated 2nd of April 2019 and later of the same year? Are they superseded now by the March 2024 circular?
No, ma'am, they exist together. And I think it's about their application. I think the 25 March 2024 one is about how the coalition government will work, and that aspect I referred to about advice from other ministers and their agencies. Well, the way it would tie in, I think, for the Cabinet Office circulars that we have been part of drafting is that when you think about issues that impact on the Māori Crown relationship, here's the way that we would hope you would be thinking about them, expect that you would be thinking about them, and that the advice developed for Cabinet would be consistent with them.
Thank you. And the 5th of April 2024 weekly report to the Minister, to your Minister, Minister Pōtaka, has redacted versions on the basis of legal privilege. What would be so important that it would have to be redacted on the basis of legal advice?
I'm sorry, Mum, I don't know what that paragraph said. I can see 2 paragraphs must be missing.
Well, did you do the report?
Well, members of my team will have drafted things.
And you would have seen it?
Yes.
Is there anything that you submitted to the Minister of Treaty Relations that was, in your opinion, legal advice?
I can't recall, Mum. I don't know what those paragraphs would have said.
All right. Well, thank you very much, Mr. Fraser. That's been very helpful. We're going to take the morning adjournment and then come back and finish both of you. And then I know Mr. Kibblewhite's very busy, so can I get an indication from Mr. Allen whether or not Mr. Kibblewhite would object to us dealing with Mr. Sadlier before he comes on the stand? Thank you. All right, we'll take 15 minutes for the morning adjournment. Can you all note that there is morning tea provided for all of you? If you come into this level here, those of you on level 7, outside. While we're waiting for Mr. Allen and Mr. Watson to come back, can I just hand the mic over to Heavenly and Sophie, who are going to talk to you about some of the health and safety issues that we're currently facing.
Kia ora, can we just have, it's a bit of a health and safety issue with everyone in the way of the lifts and the doors. Could we have an overflow room up on level 7 that has access for everyone, there's seating and tea up there. Could we have approximately 20 people please go upstairs so that we have full use of the doors and the lifts? Thank you.
That relates to everybody out in the foyer area around here. So, all right, Mr. Fraser. Mr. Lambert.
Tēnā koe, Mam. Tēnā korua, ko Newton Lambert taku ingoa. No Ngāti Ruapare ngai tūhoi me Ngāti Kahungunu Ahau, nō reira tēnei te mihi kia korua. My name is Newton Lambert. I am doing cross-examination on behalf of the claimants. I'd like to thank you both for fronting up. We really appreciate you taking the time, especially you, Ms. Anderson. I didn't realise you're on holiday. Oh, well. But yes, thanks again, and thanks for providing the brief. At the start of my questions, the tribunal did actually traverse a lot of the questions and themes that I was going to touch on. So if I do bring up those same themes, it's going to be a little bit more narrowed down because it's going to be based on the fact that you've already answered some of those questions. So just paragraph 18 of the brief, this is the one where you state that Te Arawhiti proactively provided a briefing. So what I get from this is that you volunteered to do that work?
So we had, I think what it reflects is we'd already been doing that work under the previous government. We had been conducting a stock take and looking across all of the different pieces of legislation as part of our TPOG mandate. And it reflected that when a new minister comes in, our job is to brief him on, or her, on all of the functions of our agency. One of those functions was the Treaty Provisions Oversight Group.
Okay, so just touching on that, so you're saying that under the previous government there was a direction for you to already do a stock take of that legislation?
We had started looking across all the different pieces of legislation that talked about the treaty and treaty principles as part of our work as the Treaty Provisions Oversight Group.
Okay, that probably clarifies another question I had, because you did say that you already assumed you're going to be taking on that mahi. So once the coalition agreements were made, you just assumed that you'd continue with it, so you carried on with that work? Yeah,
we understood it might be us. So it might have been us, or it could have been the Ministry of Justice, but because we are the the chairs of the Treaty Provisions Oversight Group, we thought that work would fall to us.
Ka pai. Sorry, I didn't make it clear from the outset. I'm happy for either of you to answer the questions.
We've got an agreed strategy where if I can't answer, I flick him the microphone.
Kei te pai, we can continue with that.
And also who you asked at the time, so that it's in the transcript.
Sorry, will do, Mum.
Ka pai. So just a quick question. I'm wondering if you can give us an indication of whether you made any projections on how much this work would cost.
No, we did not.
Okay. Why wouldn't that be in your reasoning for taking on mahi to do with treaty clauses, etc.?
We weren't sure, firstly, what the intent was, how big it was going to be. What we did tell ministers is here's how many resources we have that work on Treaty Provisions Oversight Group at this point, but we don't, and we still don't know how much it will cost and how many resources it will take, because the scope hasn't been agreed and none of the factors that would tell us what the cost would be have been agreed.
Mr. Fraser?
That's not our strategy.
Trying to help Lil out. Remember that the initial view was, well, there are 40-odd references on the books currently. Those references are all administered by different government agencies responsible for that legislation. And so what we could see in a review of all of those clauses, that you might need some kind of coordination, and that's one of the reasons why the Treaty Provisions Oversight Group, who has a mandate to do similar work, to be thinking about providing for the treaty in legislation, might have a role, and that was part of it. And to your point about costs, I guess that was part of the signalling to government that you're talking about a large number of pieces of legislation, and how you decide to go about it there'll be a cost factor that will be attached to it. Do you conduct one review of everything involving all of those agencies? Do you take each clause as the legislation comes up for amendment? How do you go about it? And none of those questions have yet been answered.
Okay then, thanks for that. So one of the other things, and the tribunal did touch on some of the guiding principles of Te Arawhiti. One of the ones that I wanted to turn your attention to was the concept of whakatipu, which is enhancing the Māori-Crown relationship. I was just wondering how in your mind is the treaty clause review enhancing the Māori-Crown relationship?
So, as I've already said, the fact in and of itself, the review, while it does have an impact on the Māori-Crown relationship, it is unclear what that impact is at this point. At the point at which, although it is very clear how strongly people feel about the review, and we've heard that, and we provide that to ministers in our advice. We make sure that ministers are aware of the concerns that we are hearing. But I think the review in and of itself does not, at this point, raise detrimental impact on the Māori-Crown relationship. Depending on how the review is undertaken, its scope and its outcomes, that would be the impact on the Māori-Crown relationship, and no, that would not be consistent with our whakatipu po, which is about growing and enhancing the Māori-Crown relationship.
Okay, but the thing is Māori didn't ask for this review, did they?
No.
No. So this was already a decision that was made behind closed doors during the coalition agreement negotiations. You'd agree with that?
It's in the coalition agreement, yes.
Yeah, and you've already just discussed your points of view on the fact that you don't think the process itself is damaging to Māori relationships. I'm sure you've read the evidence of the claimants for this week, and just like to get your thoughts on that. We're going to delve in a bit deeper when we get into more of the process stuff that I wanted to explore with you. Just wanted to get your general thoughts on some of the issues that have been raised by the claimants, because they have a differing view to yours.
I understand, and I know that the coalition agreement announcement around the review, along with other announcements in the coalition agreement, have caused great distress in Māori communities. That is very clear to me. I think what we're trying to offer is the fact that there has been no decisions about what the process looks like or what its outcomes will be. We still feel as though we have a role to play in trying to influence that process and trying to influence those outcomes so that they do not damage the Māori-Crown relationship further.
Okay, I think we'll probably explore it a little bit more when we get to my next line of questioning, which we're going to do now. So I'm just going to ask a few clarifying questions before we move into the key theme. Just wondering, how big is the team at Te Arawhiti that would be undertaking this mahi?
So our mahi now, as it stands, is to support the Ministry of Justice, who are leading the work. We haven't scoped out yet what that work looks like, so we don't know how many people how many resources we would put towards the review. In terms of what we're already putting into it, it would be...
What you've already done?
What would you say?
Well, for the initial advice that we provided, that was the work of one or two people doing. I would have said it would have taken a day or a day to three to put together.
Okay, and those one or two people, what are their positions in the agency?
So they would be analysts in our policy team, or senior analysts. There would also be the ability, so what you would also count is the fact that Warren would be reviewing. I review pretty much everything that goes out the door.
The buck stops with you, basically?
Yep.
Better make that a week.
Kapa, so, that's not in my view, it doesn't seem like a very large group. I mean, we've got one or two people doing the analysis, and then yourselves doing the reviewing. Is that a
we don't
fair
have a
way
large agency, and a lot of our resources are put towards treaty settlements, takutai moana.
And that would include people resources?
Yes, and also post-settlement commitments.
Okay. So one of the things I want to touch on is when you were doing the mahi for the treaty clauses review, I was wondering, like within your team, did you guys wānanga on some of the issues you would think that would affect Māori?
Are you talking about the stock take that went to ministers late last year? Because that's the work that we've done.
Sure. I do get the work that you've done, but I was just trying to get an understanding of your internal processes, whether, I guess, people are siloed, here's your mahi, go ahead and do it, or whether you have robust wānanga within your organisation about...
No, we talk across Te Arawhiti a lot, because we have people that are working directly with Māori communities daily. We have others who are based in Wellington who are writing policy, and we try and make sure that we approach issues like this together.
Kapai, so can you perhaps talk about some of the issues that were raised in some of those conversations?
I just need to be clear if you're referring to the gathering of the stock take, which was last year.
Sure,
Yeah,
we can
so
say that.
a lot of that information already existed, and it was a matter of pulling it together in a briefing for ministers and talking about what it was we were offering them. And so the wānanga would have been about, what is it we're asking ministers to do with this information? At that point, we still weren't clear whether or not we were leading the work or whether the minister was leading the work. So we were offering it up as this is work we've already done.
Okay, so I just want to be clear in my own mind. So in terms of the scope of the work you did for the stock take, you didn't really go outside of that scope and think about general issues around whether Māori need to be more engaged on these issues, or the potential impacts or the optics of what a review would do to the Māori Crown relationship, that kind of stuff. It was more about the mahi.
So in all of our subsequent advice, we have done that, yes.
Okay. So in terms of the subsequent advice, I'm assuming you also wānanga on that as well. Could you perhaps talk about some of the issues that arose in those conversations?
So I referred to it when I was answering questions from the tribunal, but post the stock take, the real focus of the work has been to identify what are the questions we need to ask ministers before we can start giving advice on that. And I covered off some of that. That was around what is the scope of this review going to be? Is it going to be one act, all acts? How involved will agencies be in terms of every piece of legislation is owned by an agency that is not us. Are they going to be involved in the review? What role do ministers see Te Arawhiti playing if we are to play a role? What approach do ministers want to take? Are they looking to look across all pieces of legislation or certain pieces of legislation? So we needed clarity on that before we could go any further. At the point at which we probably would have started to seek that clarity, we got clarity that we weren't the lead agency and that the Ministry of Justice would lead it.
Okay, so just to summarise the way I'm understanding it, it was more about making it clear in your own minds the work that you had to do to assist the ministry.
We were trying to understand what ministers wanted before we go off and prepare advice.
Alrighty, so you completed the treaty clauses review. Did you actually have any plans or projections that you might be doing it beyond the completion of that review, and you might be carrying on with that mahi? Or did you just do it as it came and you waited for confirmation?
Yeah, so we provided the work in December, the stock take. We started internally thinking about the questions that we would need clarification on, and that would have been between the period of January and April. Thinking about what are the questions we need clarity on, who are the ministers that would be involved in the review. It wouldn't just be limited to one minister. And we started forming up those questions, and at the same time we were seeking clarification from ministers about who would be the lead minister and who would be the lead agency, and that became clear on the 10th of April.
On the 10th of April. Right, I was just wondering if we could turn to your document. It is A22B. It's the 1 to 5 April briefing. And page 4, please. So you see paragraph 13 there?
I do.
That's key matters include, correct? And I mean, the way I was reading it, and excuse me, I mean, what's come up a few times by yourself and Mr. Fraser is that you like to give full and frank advice. That's part of the role, correct? I was just looking through the advice provided. It doesn't seem to really cut to the key issues, in my view. I'm going to, of course, get your thoughts on it as well. we can have a cordial about it. So to me, like the key matters include that stuff there. It was almost to me like the advice was more about how the government can achieve what they want to achieve, rather than saying, you know, maybe you shouldn't go down this route or whatever. And I'm wondering if it's because the decision's already made. It's been touched on a few times. The decision was already made in the coalition agreements, and it's kind of influencing the way that you've been approaching the advice that you've been providing.
I can assure you that it certainly has not influenced the way that we are providing the advice. What you're looking at is an excerpt from a weekly report. So this is something we offer to ministers every week. It covers all of the key topics that are arising in that week. So this is not our substantive advice that we would give a minister on this topic. That would be in the nature of a separate briefing, which we never got to because the lead role changed and we didn't get to that briefing.
Okay. Did you have anything to add, Mr. Fraser? Oh, okay, so just my understanding then, this is more of a prima facie.
Yeah.
There's a more in-depth sort of analysis behind this briefing.
Yeah, so there would have been had we continued.
But it just
to lead
never
the
happened.
work. Yeah.
Okay.
So this is just giving the minister, the point of a weekly report is to say, here's a snippet of what we're talking to you about at the moment and where we might be taking those discussions next. It's something we produce every week for both ministers.
Okay, but you never got to it. Okay. Yeah, I just want to touch a little bit on engagement,
Sure.
Māori engagement
Of course.
specifically. I was just wondering, like, during the review or in your discussions amongst yourselves or whatever, I was just wondering what kind of strategies you guys have in terms of trying to be as transparent as possible, around transparency and inclusivity.
So there's a couple of things. So our briefings to incoming government were made publicly available. We talk constantly with Māori in different shapes and forms, whether it is through our negotiations process, whether it is through Takutai Moana, whether it is through the National Iwi Chairs, whether it is through visits that we are conducting throughout the country. We are talking to people constantly, and these issues are coming up in those conversations. We're really clear about, we don't know if we're the lead agency on this piece of work at the moment. So we are letting people know what it is that our role is as far as we understand it. And we are reflecting their views when we're talking to ministers and reporting back on those hui.
Okay, so that level of engagement was done during this whole process?
It's been ongoing since the government came into power.
Yeah, I'm referring specifically to the mahi that we're talking about today.
So we're not talking to people about the review.
For the record, can you be more specific about what mahi you're referring to?
Sorry, the review of the treaty clauses mahi.
Yes, so because it's been unclear whether we've been leading the process and there's been actually nothing to lead at the moment, we have not engaged with Māori on this topic other than what they have offered to us as their concerns, their questions, as we've gone around the country.
Ka pai, thank you for clarifying that. And you did mention these issues are coming up. Just wondering what issues are coming up in those discussions?
So the legislative references to the principles of the treaty, the review that was announced in the coalition agreement, some of the matters, I mean all of the matters in front of the tribunal at the moment come up in those discussions.
Ka pai. Okay, I just wanted to change my line of questioning.
Sure.
And it is about the treaty clauses themselves. So what in your mind is the reason treaty clauses put in legislation in the first place?
I hope that it is to reflect that agencies, that ministers, that regime's commitment to the treaty. I hope it is to reflect the duties owed by that partner to its Māori treaty partner. And I would hope that is the reason that most treaty clauses are provided in legislation.
You say you hope. Are you not that confident about that?
I can't speak for every piece of legislation and how well it's understood by those who administer them, what those clauses mean.
Ka pai. Would you accept also that the treaty clauses are put in there to hold those agencies or the government accountable to the treaty as well?
Absolutely.
Ka pai. So I was just wondering, and maybe you didn't really get to think about this more deeper due to the fact that the mahi's been moved on. I was just wondering, in your opinion, around this mahi, what would it take then, in your view, to have to repeal a treaty clause?
It would take a specific priority being identified by a minister or a problem being identified by a ministry or an administrator of that legislation, or in fact a problem being identified by Māori in terms of the operation of that clause. If you think about the Conservation Act, Māori raised concerns about the application of that clause in their everyday dealings with the Crown. So if a concern of that nature was raised, you would think there would then be a review of that and options on whether it needed to be changed, not changed, or completely replaced. So those would be the circumstances that I would say it would apply in, I think. Sounds about right.
Yeah, I guess what I was really, I guess the real knuckle of my question was, what would you think would be like, you'd have the rubber stamp to say, okay, this needs to be taken out?
I think you would have had to have gone through a really good policy process to establish that it indeed was the only decision that could be made, that there weren't other options that met the need at the time, that you had engaged sufficiently with people to make sure that this is something that even if they don't agree on, they are aware of, and then that decision would be made by Cabinet.
Do you?
Yeah, good process.
Okay, so the process, right. But then, as we already sort of discussed, I mean, the treaty clauses are also there to hold the government accountable to the principles and to the treaty. So would you accept too then that repealing of a treaty clause, there is the risk or the potential that those accountabilities might be weakened?
Yes, if there were no other mechanisms to hold the Crown to account other than those clauses, then I would see that, yes.
Ka pai. I just want to speak briefly on, and it's paragraph 19 of the brief. It's TPOG. I was actually in my mind saying the whole word, but everyone's been saying TPOG, so I'm just using TPOG. So TPOG is made up of Te Arawhiti, the Department of the Prime Minister and Cabinet, Crown Law, the Parliamentary Council Office, the Ministry of Justice and Te Puni Kōkiri.
Yes, that's right. And I might get Warren, depending on the question, Warren
Okay,
might take
te pai.
over here. He knows the details.
Senior officials from those agencies, that's right.
Sure. So senior officials representing those agencies.
Yes.
Ka pai. And you're on TPOG as the chair?
No, that's not correct. I was involved in the establishment of TPOG and the thinking behind it and the cabinet paper and the guidance that came with it. And I chaired TPOG for its initial meetings. It is now chaired between our chief legal advisor and the director who report to me.
Ka pai. So you can correct me if I'm wrong, the mahi of that particular committee is to provide advice around the treaty clauses in legislation?
Yes, it's to help agencies in their thinking about how to give effect to the government's treaty obligations.
Okay, so I was just wondering, is there anything within the scope of TPOG to engage with Māori as well? Because as I look at it, it's a group set up by the Crown, made up of agencies that are set up by the Crown.
Yes, that's right. A key part of what TPOG would be testing with agencies is the extent to which they've engaged with Māori on the policy they're trying to put in place.
Okay, so how do you go about doing that?
We ask them.
So
okay.
the process is they literally come into a room with the committee, and the committee is able to, the oversight group, and the oversight group is able to question them on their understanding of the clause, what engagement they've had, because that engagement, the duty to engage does not sit with TPOG. It sits with those agencies who are
Sure.
responsible under that Act. And so there is questioning around how much have you engaged. There is often advice about who they should engage with, if they haven't already, as well as other questions about the clause itself.
Okay, that clears that up for me. I don't have many more questions. I do know that some of my colleagues have some follow-up after me.
I didn't want to interrupt you again, but you're forgetting to say who's speaking.
Oh, sorry.
I mean, the people who are taking the transcript will understand that.
Geez, as I was going through some of my questions, they were answered by the tribunal. I do have a couple left. One is at your paragraph 33. Have you got that there?
I do. Lil Anderson, I do.
Ka pai.
Oh, that sounded like a wedding.
So it's the paragraph there is an answer to a question asked by the tribunal.
Yes.
Why is Te Arawhiti not leading the review? Is your agency still involved, and how?
Yes.
I actually didn't find the paragraph answered the question.
Okay.
It's asking why is Te Arawhiti not leading the review?
So the decision has been made by ministers that we're not leading the review.
So you don't know?
No.
Why?
No, I think they, in their view, it is best sitting with the Ministry of Justice, largely because of the ministry's role in constitutional matters, would be the reason. And then I think an understanding that we continue to support that through our role in TPOG and as an independent agency.
Tēnā koe, Your Honour. That actually ends my questions. I want to thank you both for engaging in the conversation with myself today. Tēnā koe.
Mr. Lambert. Thank you.
Thank you, Mr. Lambert. Now, I don't want everybody to rush and put up their hand. I only want questions that you need to address on behalf of your clients.
Tēnā koe te kaiwhakawā. On the timetable, because there were two witnesses and they were initially split, Mr. Lambert and I, Mr. Lambert was leading out and I was to follow after him.
Well, he didn't indicate that. He said he's happy to deal with both.
Both witnesses,
and
that's right.
I've only got Mr. Lambert as the lead and Tuko Law.
Yes.
Yes, sorry.
That's okay. I can indicate that I only have about 10 minutes worth of questions. And
Okay,
they are
that'll
quite
be great.
separate.
Thank you.
Kia ora, ma'am. Tēnā kōrua.
Kia ora.
My name is Mrs. Tere Tipene, and I act on behalf of Te Runanga o Ngāti Hine and Te Kapotai to hapu up in Te Taitukero. Ms. Anderson, it's lovely to see you again, having been amongst these traps many times
Kia ora.
before.
Great to see you too.
And Mr. Fraser, we haven't met, but it was lovely to meet you in person.
Tēnā koe.
I've kind of got three strands of questions, and they actually come off some of the conversations that you've had with both the panel and Mr. Lambert. And it is referenced in your evidence at paragraph 31, and you talk about the range of options that you provide to ministers. And what I'm interested to understand is that, is it the case that when you're providing those range of options, that essentially those options still have to go to the policy imperative? So if the policy imperative is we're going to review the treaty principal provisions to either amend or repeal, that those options must go to that imperative?
Yes, that's right. And you can also provide an outline of the risks of each of those options, the risks of the outcomes themselves, as well as if there are any benefits. But yes, that's right.
So if the policy imperative challenges treaty obligations or the treaty partnership, do you still offer options towards the policy imperative, notwithstanding the intent behind what it's trying to achieve?
So, Lil Anderson, sorry, I'm getting better. So usually we would upfront talk about the treaty obligations, the treaty compliant process, and then we would go into, if you were wanting to run a treaty compliant process, it would look like this. Then we would say, in the way that you are proposing to do it, or in these other options, here are some of the things you could do to make these things more treaty compliant. So that's the way we would normally give advice. That's about right, isn't it? Anything to add?
Warren Fraser, I think was referenced in our briefing from 4 December. Paragraph 18, where we said, look, our quick search has identified 40-odd acts that reference the principles of the Treaty of Waitangi. The coalition agreement talks about better defining the clauses or repealing them. And so questions of scope for the review, we said, well, look, there are a number of descriptive type treaty clauses already on the books. You may want to consider those out of scope. It would be part of understanding what the government was trying to achieve. That's why the initial advice is kind of pitched at those kinds of questions.
Kapai, so when you say, if they would like to take a treaty compliant approach, this is what it would look like. Ultimately, as I've seen in your evidence, you can only offer the option, and then essentially it's for the minister to decide whether they want to take that approach or not.
Lila Anderson, yes, absolutely.
And so, I mean, I'm conscious in the discussion that you had that, your Te Arawhiti's role, you're mindful that you don't want to destroy the Crown-Māori relationship any further. But a policy imperative that is going to replace or repeal, and as you've said to Mr. Lambert, it's not something that Māori asked for. What mechanisms or tools do you have in place to keep that Māori-Crown relationship safe? When you say you don't want to destroy it, well, what do you do to avoid that?
Yeah, that's a great question. I think there's a couple of things. Firstly, we continue to make sure that ministers, including not just our own but others, are aware of the impacts of these courses on the Māori-Crown relationship. We are very clear and we are very explicit about that. We would then, I think, look to minimise, either offer alternative options that offer no damage to the Māori-Crown relationship, or look to minimise any harm to the Māori-Crown relationship through the processes that government uses. So those would be the way we would approach matters like this. We also have a duty to, I think, offer advice to ministers on the directive they have sought. So we can't just say, no, don't do that, do this. We have to, we must offer advice on the course that they wish to take. That's our job. And we do so with care to make sure that the implications and the risks are very clear. And so using those 3 sets of tools as an agency is the way we would normally approach any piece of work that touched on treaty matters and or rights and interests of Māori.
I'm quite green on the process of how cabinet decision making goes from start to end, but I suppose my question is are there instances where ministers don't ask for advice, or they don't want advice, they know the direction that they want to go in and they just want to know how they're going to achieve their objective?
I've never seen an instance like that, and I think there was reference to the coalition circular where ministers are actually told to seek advice from their agencies and other agencies on matters. There may have been instances where ministers have not sought that advice, but in my experience that advice has always been sought. Our advice is being sought on all of these matters, or most of these matters. Some have not yet come up. So,
fine, thank you. Just going on to another line of questioning, and it is around the change of lead for the review of the treaty principal provisions, and I can see that you've got a chronology there where on the 10th of April it transitions over to the Ministry of Justice. and then you say that Te Arawhiti officials ceased working on the review. And I know this isn't in your brief, but in Mr. Chana's and Mr. Kibblewhite's brief, they talk about how they haven't picked that work up. And so I'm just trying to understand, because I know that you are still taking a supporting role in that work. Is it the case that you're waiting for the Ministry of Justice to pick that work stream up again and then give Te Arawhiti some direction about what the next steps are? Is that how you see the next step happening from, so basically you're waiting for the Ministry of Justice?
So the next step would be to make sure that we handed over any of the materials that we had that we were working on, although the ministry's part of TPOG, so they would have a lot of them. So we would just make sure that the ministry had everything that we had when we were looking to lead this work, and then we would await their direction as to what was next.
And so have you been given any, sorry, were you?
I think there's something that, sorry, Warren Fraser, something that might help, that the government's reasonably new, and you've all heard about the government's 100-day priorities and everything that it wanted to do, and that's and a number of those I know my justice colleagues needed to deliver. So there is a capacity issue about how much government agencies and ministers and cabinet can get done, and it's why priorities around this piece of work or that piece of work need to be set. It's why there was a lot of focus in this area. We were anxious to know, gee, are we leading this? If we are leading this, what resource will we need to dedicate to it? How are we going to go about achieving it? And critically, gee, when does the government want this done? And it's part of the reason of saying, giving some initial advice that says, gee, you're talking about quite a lot of legislation, government, and quite a lot of process that would go with any change that you wanted to make. So don't underestimate how big this thing could be.
I want to pick up there, because that's actually something that kind of struck me, and it has been touched on the periphery, but it is a big piece of work, and I'm interested to know how that big piece of work aligns or overlaps with the treaty principles bill, because they seem to be in some capacity overlapping in quite a large way, and whether you have any views in relation to the level of that overlap. And I know that there's been comments about that the review of that impact hasn't been undertaken yet, but certainly interested in your perspective in relation to that.
Given the subject of both of those pieces of work are around the treaty, are around the principles, are around the use of those in legislation, there is most certainly an overlap. I think we just don't know what yet. There's no timing around the review of legislation, and we don't know yet if the processes will overlap, and so that really is a question at the moment.
A question for the Ministry of Justice?
I think it's for ministers as well, not just for the ministry or for Te Arawhiti. I think it's a question for ministers as well.
Ka pai. I'm just moving on to my last kind of line of questions, and it is in relation to you talking at your paragraph 23 about Te Arawhiti having an advisory role to ensure that there are clear understandings of Māori rights and interests in policy processes. And I'm interested to understand Te Arawhiti's understandings of Māori interests, or how Te Arawhiti build its te tiriti and cultural competency, I should say. So where do you get that advice from when we're talking about te tiriti, principles, obligations, interpretations? Where does that advice come from?
So it's a really good question and a fair one. So I think a lot of that will come with the experience we've had as an organisation over 25 years in dealing with matters relating to the treaty and dealing with matters relating to rights and interests, and that has been in the form of all of the different functions that we've got. It will be often consulting experts both in Te Ao Māori and also academic experts where there are questions that we do not understand. Like any agency within the public service, we're working really hard to make sure that cultural competency is something that flows throughout our entire organisation and that our people have a very clear understanding of Te Tiriti, of the obligations it puts upon us as Crown agents, also about the history of our country. All of those sorts of things figure in the way that we want Te Arawhiti to give this advice. So we gather all of those things together and try and make it relevant to whatever the context is. Sometimes it relates to, it could relate to the fast track bill, sometimes it could relate to matters like these, and we bring to bear that knowledge and experience as much as we can. We're very clear to say that we do not speak for Māori, but that these are our understandings of the rights and interests, and I feel like Warren's leaning forward to say something.
Warren Fraser, just to say, of course, it's the 50 years of jurisprudence we've had from the tribunal and everything that's gone alongside it in the courts about what has been said about the treaty and the principles of the Treaty of Waitangi.
I can say from my client's perspective that they would be pleased to hear that tribunal reports are an informative part of that, because from their perspective that there's a lot in there around the Crown Māori relationship, if not entirely. And I
think I'm just conscious that it's 12:20 and Mr. Sadlier has to go at 1.
Yes, I've got one last question.
Okay, thank you.
My last question was actually something that you had noted, Ms. Anderson, and that was in relation to experts in Te Ao Māori. When you say experts in Te Ao Māori, are they Māori?
Yes.
And are they chosen? I don't mean to be facetious. I just the detail is helpful. And when you choose these experts, are they independent of the ministry and the Crown? Are they po tikanga people you go out into the community to
Yes.
engage? Ka pai. Thank you both of you for your time. I appreciate it.
Thank you very much.
Thank you, Mark.
I'm going to try and draw some threads together because you've said a lot to a lot of different people. But my first is to both of you, and it's, I think, first of all, Annette Sykes for a number of applicants and 2 interested parties. And it's been a long time, Lol. I hope you had a good holiday and that you've come back after your leave refreshed to confront, which is one of the, I think, most significant issues since you've taken your role.
Kia ora, I understand.
But I do have some issues I want to explore, particularly in the timeline from December to April and the roles of different ministers and yourselves. And I felt that there was a little bit of a conflict between your propositions, put to questions from the panel, Ms. Anderson, and then some of the things that you said, Mr. Fraser. So I just want to clarify those matters. Mr. Fraser, you said to Doctor the treaty clauses were not yet underway, so you had put that aside. And then, Ms. Anderson, to contrast that, you said that you put together the stocktake to proactively work and in a way to acknowledge work that had been undertaken for some significant period and to give that as a springboard to facilitate any review scope and understanding. You see the difference in your answers? I actually want to know whether or not it would have been important, because of the nature of the review, to principles of Te Tiriti and Te Tiriti of Waitangi, that you needed to take a proactive position, which was beyond just a review question, much broader. And I'd like to hear that. In light of the fact you're proactive, You're not actually limited to a nascent policy whose destination's not known, but you're proactive to facilitate the policy thinker, and what would be the implications of that in the longer term?
Kia ora, Ms Sykes. I'll make a start on that. And firstly, I just note I haven't been on holiday yet.
Oh.
But I might need one. No. I head away shortly. I can understand why you see the conflict in those two responses, and, you know, that was not supposed to be the case. And I can also see your perspective of why, and I think this is the root of your question, and please tell me if I'm wrong, like you always do, is the 4 December briefing, in your view, was probably the opportunity for us to offer advice on whether or not the government should pursue that. So I can see why you would say that. And, you know, in our view, we still had time to do that. We were still scoping out whether, in fact, this was our minister, whether it was, in fact, going to be his lead at all, whether, in fact, they wanted us to do any work on it. And then we would have offered, had there been briefings, we would have offered the kind of advice that you were talking about. But I can see your perspective that that should have been done in that first briefing, and I acknowledge that.
And that, and following on from the other questions, that would have been consistent with your mission.
Yes.
And so that was certainly something that is contemplated as part of policy process to meet Te Tiriti standard. Would you agree?
Yes.
Mr. Fraser, why do you take a different view?
I'm sorry, I'm getting a little bit lost about
Okay, so you said that you were wait and see, if I can use that as a summary, and because I've only got a little bit of time, and because you weren't too sure of the policy destination, and you wanted to actually see where the scope of the review was. But I'm saying to facilitate the scope, you actually need to take a much more proactive position. As you've just heard from Mr. Anderson in previous questions, 25 years. You are the agency with equivalent experience perhaps to the other Crown Māori agency, Te Puni Kokiri, to lead on a Māori perspective. So that anticipatory impact of a policy is within the purview of your institutional knowledge. So why do this wait and see?
Why do, sorry?
The wait and see.
The wait and see.
Wait and see to where what the scope is, where the policy trajectory might take you. Why? Because you're 25 years in the game. You are the best placed ministry to give that advice.
Well, I think you can see in some of the things that we did say, some probing around the question of really, do you mean a review of all of those clauses? So I come back to some of the points we made about whether all of those will be in scope. One of the things that we said in our weekly report was around, can we find out from you, ministers, whether you've got a particular concern about some particular references, because we were probing for the problem that they were trying to get at.
But isn't there also an obligation on the omissions not to look at the implications of a proposal? Because policy may be entrenched by way of a principles in a legislation, or may be given effect by consequences of that legislation being implemented. And I'll give the RMA so everyone knows this, or DOC. You have a treaty clause, but what flows from that is relationship agreements with hapu, not treaties, post-settlement governance entities that are not under settlement arrangements, but are enforceable agreements. So those kind of risk assessments are in the purview of your understanding. Surely that should have assisted in actually working towards a scope that wasn't actually going to undermine obligations that were enforceable.
Well, I think you might have touched on the possibility of opportunity in the review. You just cited the Conservation Act, and Lil talked about well-known concerns with how that provision operates. The opportunity in a review of a general clause like that to better define what does it actually mean, how should it actually apply, how can it give effect to the treaty that underpins that clause. There's room for that too in this review.
But can I say it's, and I'll go back to you again, Mr. Anderson, you said the fact of a review is not concerning. That's what you said. But isn't it concerning? This isn't just a normal review. We're talking about Te Tiriti o Waitangi, the constitutional baseline of the relationship between Māori and Crown, which is your mission. So it's not just a review, is it?
No, I hear what you're saying. I think what I was trying to say was, the review in some ways not supports, but I have a growing concern about the understanding that we have across the public service in these treaty clauses, and making sure that everybody knows what they mean, making sure that everybody understands the responsibilities it puts upon them as Crown agents in their interaction with Māori. That is the thing that has been gnawing away at me. And so the review in and of itself, and I think what you're saying is, however, this review already has a destination.
Oh, it's more than a destination.
That's right.
It has a objective of replacing and then repealing. I'm not going to repeat the questions you were taking there.
Yeah.
So it's more than a destination. It's about obliteration and erasure of our te tiriti in the statutes of this country. So as a pre-stoltate, surely that should have actually alerted impact, prejudice. I must let my official colleagues, the leadership of all these departments, know that we are aware of this, and we need to take immediate policy action to make this constitutional issue weighted with importance.
Yes, and while I should assure you that while that advice was not in the proactive briefing to the supplementary briefing, it is advice we have offered to the Minister since.
Okay, so let's go. I'm struggling with this timeline with the Minister, and I want to go to some of the documents. So if we go to document A22A, and that's from Arawhiti to Minister Pōtaka and Māori Crown Relations Minister Goldsmith as treaty negotiations.
Yes.
It's dated the 4th of December, and it's a document that's had a little bit of discussion today. I want a real basic question. How do you see the relationship between the principles of the treaty and Te Tiriti and the treaty? This is really important. It's not clarified in that document. So how do you see them? Are they interchangeable? Are they incorporating principles within the understandings of Te Tiriti and its tenets? And are we using that to give legal effect? And I ask you, in considering your answer, did you consider some of the proclamations coming out of the Supreme Court, for example, in Trans-Tasman and other cases, that have made it quite clear that even where there's no reference of the principles of Te Tiriti, the Tiriti and its context itself is relevant in the application of statutory duty. So what are you referring to when you talk about principles of the treaty?
Warren Fraser. Well, I think we know that the first reference to the principles of the Treaty of Waitangi is in the 1975 Act that creates this tribunal. And that Act sets out the tribunal's jurisdiction and the reasons why the principles are there to give practical application to the treaty. So there is a difference.
So can we just say, I always call Te Tiriti, there's a big debate about this, and it's an academic one. We've got 5 or 6 briefs coming up on it. Do you see that it's reductive if you only use the English version to the treaty? And isn't that a fundamental flaw in the policy advice already?
Yeah, I do understand what you're saying. I'm referencing the Treaty of Waitangi Act and the terms that it is spelt out. I take your point, and I don't mean to be reductive, but it goes to the question you are asking about why have we got principles and how are they different to the treaty and Te Tiriti, the texts themselves being different.
But some of the provisions now in the legislation, we've had 40 years of learning decolonisation, are now using Te Tiriti. Section 14 of the Education and Training Act, for example, in the proposed bill for the NBA and SBA and MBE, National Built Environment Act, and spatial planning that you and I were working on, it went further than Te Tiriti. We started to get into tikanga, didn't it? So is this term, the principles of the treaty, going to be interchangeable for that wide-ranging policy development?
I don't know if that's what's going to be the case, but that example that you're citing is, and that variation in the reference to the treaty or te tiriti, or to honouring te tiriti, or to giving effect to the treaty, all of those variations on the statute book were the cause for concern that led to the creation of the Treaty Provisions Oversight Group, as we were discussing before. So where that goes, I'm not sure, but the observation that the coalition agreement with the ACT Party is making is that the treaty principles have never been defined in legislation. They've been left for discernment by the tribunal and by the courts.
Is it right, though? Is your purview of that understanding right? What about Section 7AA of the Oranga Tamariki Act and the 40 references in that bill following this inquiry and this tribunal stage 1, which actually I think, steps out to facilitate an understanding. So that carte blanche statement you say is not actually one that's applicable, is it?
Well, I mean, that's a good example, I think, of why we would look at the review as allowing for opportunity as well. That the Oranga Tamariki Act and all of the provisions that 7AA and the other, well, there's a lot of other supporting provisions in that Act, help those who need to, those using the Act, those affected by the Act, to understand what how Parliament has given effect to the Crown's obligations under the treaty in a much more defined way than a simple reference, a single line reference, say, which is the case for other acts, to the principles of the Treaty of Waitangi.
And I'm going to leave this point, but I have to ask this last question though. In the same document, you mentioned, and everybody has 22 acts referenced the treaty and or te treaty. How have you interpreted, or did you consider offering this pre-advice or consistent advice, interpreting the coalition agreement commitment relating to those? You know, that broad scope? Have you given advice? Because I think that certain policy may be framed on an institutional ignorance of the development of decolonisation, influence of the Waitangi Tribunal recommendation, but also the judiciary in educating communities of the importance of the treaty obligations and the practical lives of citizens of this country. So did you consider that would be the advice you should be giving? Because frankly, when I've listened to you this morning, it's like you said, 23rd of December, I waited till the 10th of April, 4 months passed, nothing's come from the ministers, nothing's happening. Everything in the media is happening. The Māori world is happening around us, and you're doing nothing. I need you to answer that, because that is a real concern for my claimants. You are the agency they look to intimate early there is trouble on the horizon, and its constitutional dimension could sever the relationship between the Crown and Māori forever. So how did you deal with that?
I don't think it's fair to say we were doing nothing. As you can imagine, there is a lot happening in this space, and we, as a very small agency, are trying to get across all of it. We are trying to make sure that we are in the right places, in the right policies, to say the right things in relation to the treaty and in relation to rights and interests. And we feel confident that we have been able to do that to the best of our ability. What you are pointing to, however, is the need for us to front foot that view, and we should have, in your view, from the 23rd of December, and I accept there should have been that advice. We have continued to offer that advice to our Minister, and I know the Ministry of Justice, the point you make about the differences between the treaty and te treaty, those will form parts of our advice and the Ministry of Justice's as this work goes forward. You have my assurance on that.
But we're faced now with an urgent crisis that we have parliamentary intervention of a kind that may prevent appropriate analysis of the kind to capture the Māori sentiment, the rangatiratanga dimension of it. Would you agree?
I understand that it depends what course ministers take, and they haven't outlined what they want to do in this space yet.
So going back to this paragraph 31, which everybody's been worried about, you talked about options there. Can you please outline the options you've been considering? That's of your main brief.
Sorry. Oh, so as I said, it would really depend on what the scope is. So we would offer advice as to how limited the scope could be. It could be simply to clarify that agencies understand all of the legislation that they are responsible for. So that could be one option, right through to the full review of all of the clauses.
So can I pause you there, because I just want to take you to parts of your brief which really puzzled me. So you go to paragraph 32 and 33.
Yes.
The tribunal asked you how the statutory review relates to your mission, and you said your role was to advise the ministers, and you were likely to continue being involved in that review.
Yes.
But then go back to paragraph 25, please. You said you have ceased working on the review, so that does not seem to be consistent with your role. I'm struggling. You're either working on it or you haven't, or you aren't.
So once we handed the role over to the Ministry of Justice on the 10th of April, as I pointed out earlier, we need to make sure that we give them all of the documentation that we have gathered. We will sit down with the Ministry as their support agency. We will develop up what the next steps look like. We will develop advice and talk to ministers. But that has not, so there has been no work on that at this point in time. Once that work picks up, we will heartily take up the role you have described.
In your past experience, have you put up options where you say what you're doing is not consistent with Te Tiriti at all? Any of the options that have been put up?
Absolutely.
In what context?
A number of them. Whether it has been legislative reform, whether it has been different policy proposals, we do not hesitate to give that advice.
Okay. Ma'am, I know I've got Mr. Sadler, I've got about another 10 minutes. I would pause and maybe do the questions in writing. That might be an option that I'm thinking. I've got not too many, but I really want to make sure the Kroa has his obligations to his people met today. Kia ora.
Mum, I also have a couple of questions, so I just think if Mr. Sadler could go now, that would be helpful. Yeah.
We can accommodate, Mum. We can accommodate.
Richard or John to come back? I just need clarity.
Mr. Sadler?
Because there were two suggestions.
Yeah, shall I go?
You both have to stay, I'm afraid. Thank you.
Tēnā koe, Mr. Sadler.
Tēnā koe.
Can you confirm that you provided some evidence dated the 30th of April 2024?
Yes, I did.
Okay. And Mr. Sadler, you've got a short presentation that you'd like to make. Would you continue with that, please?
Okay. I think in terms of the pūrongo, I'll take that as read. But I've just had some to go through the David Seymour's explanations around the principles. And I just want to talk to some of those in regard to my interpretation and to give some more views on what people have seen. I am very supportive of the brief that Sir Patu Hohepa had given, and I just want to go now to my interpretation of the articles. And I've translated them, and I think that they follow the same. But this is my view. The rangatira of the Assembly and all the other rangatira who didn't join in that aforementioned assemblage, Confederation of Chiefs, will give unencumbered to the Queen of England forever the complete governorship over their land. And going through and analysing, I looked and made this conclusion that kihei is not the appropriate word from my perspective in that interpretation that has been given, but I would say that ka hore anō kia, that would have been more appropriate, meaning have not yet joined. So, in terms of, if I read that out, the rangatira of the Confederation of Chiefs and all the other rangatira who have not yet joined the aforementioned Confederation of Chiefs will give unencumbered to the Queen of England forever the complete governorship over their land. Number one. Number two, the complete governorship over their land, and there in this context is critical. As the rangatira agreed that the governorship was not to be over the land that they, was to be over the land that they, the Pākehā, the Queen's people, have already acquired. In David Seymour's principles, the kawanatanga katoa o rātou whenua, he interprets that as the New Zealand government has right to govern all New Zealanders. The rangatira signed up agreeing to te treaty, and they welcomed this article as they could envisage that their lives will become easier as the troublesome Pākehā will no longer be their worry, as the tangata tutu hakararuraru will be fettered by their own. So in his interpretation that the New Zealand government has the right to govern all New Zealanders is not in tune with the intent of te tiriti. And beyond that, in terms of the Paparahi o Teraki findings of the Tribunal's 1040 report, that Ngāpuhi did not cede its mana. And so therefore, to say that the New Zealand government has the right to govern all New Zealanders, we're yet to find out what that means. And we've been waiting for a number of years for that to be addressed as to what the Crown is interpreting that issue that was in the report. And certainly from our perspective, it doesn't say that it gives a kawanatanga katoa over Ngāpuhi without our consent. Ko te tuarua, and my English translation is this: the Queen of England will arrange and agree with rangatira, with the hapu and all the people of New Zealand, their chieftainship over their lands, their villages and all their valued possessions. In exchange, the rangatira of the assemblage or the assembly or confederation of chiefs and all other rangatira will give the Queen the opportunity to buy those sections of land that people can prove ownership to at an agreed price between them and the buyer which the Queen has appointed as her agent. There is a reciprocity in this article, and that is to fulfill the initial part of the article of honouring their chieftainship over their lands, their villages and their taonga. They must honour preemption, and that is that all excess lands were to be sold to the Crown at an agreed price. This article was never upheld as we entered the 21st century. Māori are almost landless. And so the interpretation in the Article 2 of David Seymour's Principles, ki ngā tāngata katoa ni tire ni te tino rangatiratanga o rātou whenua, o rātou kāinga, me o rātou taonga katoa, the New Zealand government will honour all New Zealanders in the chieftainship of their land and their property. In fact, when the article was signed, the treaty was signed, the people that are recognised in that signing are Māori, because others have not yet arrived. E ko te tuatoru, as a consequence of the agreement to the governorship of the Queen of England will extend her protection to all Māori of New Zealand and offers them the same rights and privileges as the people of England. This is in terms of the principles from David Seymour, a rātou ngā tikanga katoa rite tahi. This is taken completely out of context. And again, this article was consequential if Māori were to receive the same rights and privileges. This cutting and pasting exercise of the Treaty of Waitangi demeans, debases and trivialises our founding document as a nation and disparages and denigrates Ngāpuhi, the guardian of these sacred covenants. It really has no base nor merit for engagement in any academic or practical debate or discourse. I have never bothered to engage in any debate, or for that matter discussion on treaty principles, as they are contrived, out of context, and with another agenda. It's a pity that Eruera Pare Hongi, the writer of He Whakaputanga, in both Māori and Pākehā versions, died prematurely. Maybe he would have set the record right. So that's my conclusion thus far.
Mr. Fox, do you have any questions?
Hara tēnei te pātai, engari kei te mihi au kia koe. Mō kōrero, mārama, koe nā tō painga, mārama koe mena kei te kōrero koe te reo Māori, te reo Pākehā rane. No reira, tēnā koe mō kōrero, kia mātou, kia tātou, i te rānei. Kia ora.
Tēnā koe e kara. I'd just like you to help me with the way we refer to he whakaputanga and anything we write coming out of this inquiry. So you attach the evidence of the late Patu Hohepa, and it was my privilege to be at his tangi for a couple of days. And so moi mai rā, he patu moi mai rā ki te moi ngā roa. At paragraphs 89, 90 and 91 and 92 of Patu's evidence, the point is made, so in paragraph 90, so we need to ask again, independence from what or whom? A declaration of New Zealand's Māori sovereignty would have been a more accurate English translation, with the Māori defining what sovereignty meant. Because, of course, normally a declaration of his independence is a declaration of independence from someone. Well, there was no other someone here at the time, I think was what Patu was saying. So it's almost always, when there's reference to he whakaputanga, which I know that Ngāpuhi wishes us to observe as the tuakana, should
or
we
more than
just forget...
tuakana, may I add, as the matua.
The matua. And so should we just avoid using that English term Declaration of Independence, 1835, altogether, or just use the Māori text, or do you want us to use the Patu's suggestion of Declaration of New Zealand's Māori sovereignty if we're going to use any English words?
I would prefer the Māori because there is no, the nuance when you translate from one language to the other, the full nuance doesn't come across because they come out of two cultural contexts, two different cultural contexts. And so what was meant in Te Ao Māori, I think I have an idea of what was the intent because I have a cultural history to that. But if it was in English, then given the fortune that I have of being brought up in that kind of context, I'll understand it as well. But I think so that there is no mistake around what the intent was. I think if we take the idea of contra preferentum as being a imperative, that we make no mistake.
That Latin is another cultural context. But I think your preference would be to follow Tā Patu, formal Ngāpuhi idiolect, or te mita o te reo a Ngāpuhi. That's what you prefer. Is that
Certainly,
correct?
yes.
Kia ora. Thank you.
Dr. Suter with his Ngāti Pro and Ngāti Awa hat on.
Mihi kau atu ana ki a koe hone. Tēnā koe e mau nā koe I ngā kororo tuku iho ao koutou tipunu. Me te mihi anō ki a koe mō ngā kupu a tāhua tēnei ata. I'll get straight to the point because you're an expert in te reo, Pone, and because the dialect of the treaty is in the language of the North, I look at the ACT Party principles, and I was confused because anybody with a good knowledge of the language cannot see how you could get this English translation out of those words. And then when you take them out of the context of the treaty and put them up like Article 3, a rātou ngā tikanga katoa ri te tai. If you don't know where that comes from, that doesn't make any sense. Am I correct?
Certainly. If it's taken out of context.
Your cut and paste way of explaining this, is it your opinion that whoever did this doesn't understand the language?
Certainly. Without doubt.
Tēnā koe.
Tēnā koe, Mr. Sadler. Can you just clarify, please, what your issue was with the translation of Article 3?
Can you enlighten me on?
Well, you don't agree with the translation of Article 3 that's being put forward to go into the Treaty Principles Bill. What is the substance of your disagreement with that? I understand what you disagree with in terms of Article 1 and 2, but I'm not clear on Article 3.
Rātou ngā taonga katoa rite tahi.
Ngā tikanga.
O rātou ngā tikanga katoa rite tahi. Well, my concern is that when this is a cut and paste job. So ngā tikanga was between Māori, who at the time, and I made my calculation on the basis, and I'm talking about the number of Māori that were here at the time of the signing of Te Tiriti. I see Patu Hohepa has made 100,000, and I guess he's based that on Captain Cook's number who he thought were here at that time. And given that Captain Cook only did a coastal survey and not an inland, where quite large numbers of people lived in villages. So I based my calculation on the population of Hawaii at the same time in 1840, and their population was 800,000. And given that Māori have occupied by that time almost 1,000 years in Aotearoa, that our numbers would be quite higher than 100,000. And so my calculation is around 400 or 500,000, 500,000 at that time. So, and if we take that into context, we could have told the English at the time to get the hell out of here. But we didn't. And the reason we didn't was because we wanted trade. We were a trade people. And so in the context of how this article or principle written by David Seymour doesn't take that into account.
I see. So that's the context. And is it also the omission of the Queen's offer of protection to all Māori that you...
Yeah, and the Queen's offer.
So, I see. Thank
But
you.
that was contingent on, and as I said, that there were consequences that needed to be met by Māori before that kicked into place.
I see. Yes. Thank you. I understand what you're saying now. Thank you.
Oh, no question.
The questions I had have been asked, and I just want to thank you for bringing your expertise in te reo Māori, tikanga Māori, to this tribunal so that we get the benefit of your knowledge. I'm very pleased you came. Thank you very much.
Thank you.
And the all right, I'm going to ask Ms. Sykes to finish her questions, because if we can avoid having to do everything in writing, we should.
So if I can get back to the timeline. So I've gone through the 4 months. And we're at paragraph 23 of your main brief of evidence. Why did it take 4 months to decide who would have the responsibility for the statutory review? Are you able to help the tribunal?
There didn't seem to be any undue delays. I think ministers were, firstly Minister Pōtaka thought it was his lead, and so that was settled. Then it became clear that that wasn't the case. So there was going to be a meeting between himself and Minister Goldsmith, and that couldn't be arranged for some time. And then I think throughout that time we were seeking some clarification, and it was at that point it was decided that they would seek clarification from the PM. So other than ministerial diaries and the ability to get together to discuss it, I don't know the other reasons, Ms. Sykes.
At paragraph 25, you say Te Arawhiti ceased providing advice after that and was not working on the review. Why is that are you supposed to just, I'm just struggling, you know, because of your mission. Do you play a supporting role, or did that transfer to Te Puni Kōkiri, or did it go just to Justice?
It just transferred to Justice. However, until the Minister gives us direction, we weren't sure which pathway he wanted to take. And so at that point, other than the thinking that we were doing internally, we weren't sure what advice he was seeking from us and whether he in fact wanted advice. So he was still thinking about the direction he wanted to go in, the scope and things like that, and we simply had no other reason to brief him because he had not sought it.
So which Crown agencies are providing input, or Crown Māori agencies, I think for my clients, I have to be specific, are providing input to that review, if not yourself?
It will be us. It will be us and Te Puni Kōkiri. However, that work hasn't started again since it was transferred to the Ministry of Justice.
Okay. So then what is the role of Minister Goldsmith as the Minister for Crown Māori Relationships? What's his role?
So you mean Minister Pōtaka?
Sorry, Minister Pōtaka, sorry.
So he will support Minister Goldsmith as the lead minister, as will, I understand, the Attorney General. So as a group of ministers, they will work collectively across this, as will the agencies of the Ministry of Justice, ourselves and the Crown Law Office.
At paragraph 16, you say that the draft cabinet paper is being prepared. When is this now due?
Is this on the Treaty Principles Bill?
Yes.
Right. That is the evidence of the Ministry of Justice. I'm not sure of the timelines around the cabinet paper, Ms.
So there's no liaison at all around when they, you know, given them 100 days we've heard about, the focus on Māori policy, surely you should be pre-planning what kind of advice on a paper of this would be significant. So you would be asking timelines so that you could prepare yourself. You'd agree with that? That would be normal policy preparation?
Yes.
So you would be having some indication of when that paper would be due, surely?
So we reviewed the draft cabinet paper on the 27th of March. And we provided those comments to the Ministry of Justice, who are leading that work. We then relayed the comments to both of our ministers through our weekly reports. We discussed those with Minister Pōtaka at our April officials meeting, and that has been the extent of it. As we understand it, the paper is going through consultation at the moment, and I'm put in?
The indication was the end of May.
Oh, the indication was the end of May.
End of May, thank you.
Yeah, I just didn't have that timeline in my head, sorry.
So you say at 26 in your brief, the process for the bill is the same as for the statute review, led by Ministry of Justice and supported by Te Arawhiti. It seems you're more actively involved, and I especially feel that from the evidence today, with that than with the statutory review, at least in your weekly reports. Why is that? Because I see them allied, kaupapa, and I'm struggling why one is being prioritised by yourselves.
So
is there a reason for that?
We have a formal role in the treaty review process, in the treaty legislation review process. We have been formally asked to play a role, whereas in the role with the Treaty Principles Bill, we are being consulted as an agency alongside other agencies, so we are not co-leading or supporting that work.
You say at paragraph 27 that the Minister for Crown Māori Relations received further advice from the officials on the 8th of April and noted there were further steps he wished to take. What were those further steps?
So that was in relation to the draft cabinet paper that is confidential.
What were the steps? I'm not asking about the paper. What were the further steps he had to take?
His steps were in relation to the cabinet paper. That's confidential.
Okay. If I can go to a couple of questions again on the treaty principles, Te Tiriti and the other matters. In the December memo, you raised the option that TPOG or another cross-agency group be given the responsibility to lead on this policy, or that it be referred to the Law Commission.
Yes.
And you've taken that question from one of the panel members, Ms. Kapua. What was decided about that? Do you know?
We continue to lead that work on TPOG, that is.
And I asked this question because Law Commission had a significant paper on tikanga out last year, and I'm wondering whether or not there was any weight to giving them a special role on this matter because of that.
Do you want to answer that?
Well, Warren Fraser, I think that was why we were making these kinds of suggestions for a review of the size, scope, with things that might be in common. Then a body like the Law Commission could be an option for doing the work.
And that's not happening? Why? This is. I'm sorry that that's my question. It just troubles me that you've got all these specialist groups, well resourced, that have got significant work done in this area, and many of us in this room, yourselves included, Crown and advisors to our people, have worked with the Law Commission for over 50 years to get to where we are now. So why are we not going there? And
Lily Anderson, I think ministers haven't made final decisions yet, Ms Sykes, about whether or not the Law Commission might get involved. We haven't received any direction on whether they want them to or not want them to. But as Warren said, our suggestion in the briefing was to reflect what you've been saying about the importance of the Law Commission playing a role.
No, I want to go to, and we're in the same document that my friend Mr. Newton Lambert took you to, A22B, and I'm looking at page 4, paragraphs 11 to 19, and I'm starting at paragraph 13. Can you take yourselves to that document, please?
Sorry, Ms Sykes, we just don't have document numbers, but that's the weekly report.
Arawhiti to Minister Pōtaka, Māori Crown Relations,
I've got that.
To 5th of April. And for the record, it's A22B, and I'm at paragraphs 11 to 19, page 4. And I want to start at 13. And my friend took you to matters discussed with the TPOG group. It is clear who's in charge. Is it clear who's in charge? You've just clarified that. I'm wondering why lawyers become in charge of this and not you. I have to ask that. TPOG.
Well, to clarify, I said it had been led by our Chief Legal Advisor and our Director of Strategy and Policy, and that was largely because there was a period when the latter role was not occupied.
Oh, okay. Thank you. Problems getting people to work for Te Arawhiti Kura, okay.
I wouldn't say that.
13B suggests the aim to review one by one and prioritise. Presumably officials will advise ministers in making that decision. Is that correct? And what's proposed there? Paragraph 13B. And on what criteria would legislation be prioritised if you are, with that objective in mind, by whom, and what is the role of Māori?
Sorry, both of us thought the other was answering the question.
Okay, I thought we'd gone to Mr. Fraser, but that's where my friend took you to, Kilda.
Forgive me, can you repeat your question, please?
Okay, so if we go to paragraph 13, and I don't want to repeat he went to the why of that, but I want to go to the specifics, 13B and 13E. It suggests the aim in 13B is to review one by one and prioritise, and I'm asking, presumably, officials will advise ministers in that decision. And I'm saying how, on what criteria would legislation be prioritised, with what objective in mind, by whom, and what role for Māori? Is that thinking got that far?
No, and the 13B, understanding whether ministers see particular provisions as priorities for review. We're probing here to try and understand the problem.
Yeah, but in understanding the problem, given our earlier discussion, which I don't want, surely there must be a Māori somewhere in there that's not ground connected to understand the problem for problem definition. Otherwise, you're actually advising yourself about a problem you may not know.
Well, with all due respect, the coalition agreement was between those parties and the government ministers now looking to lead that work. We're trying to probe with those ministers how they want to conduct the review that they've agreed to undertake.
And it's a similar query on my part for 13E. It raises the interaction between the review work and the Treaty Principles Bill, which we've been talking, a lot of us, about the interconnection. What is the understanding of that interaction following your discussion with TPOG, and what understanding you have been working on in providing your advice to the Minister? You know, how do they knit? Or do they knit?
We've asked the question of ministers, but pointed out that, well, there are two different commitments into the two coalition government agreements that have a relationship, and we are saying that, well, you'll need to resolve that relationship about how the two things work together. That's one of the key matters that will need to be resolved.
And if I understand from our questions today, the Minister of Justice or his associate will be in charge of the bill, and your minister will be in charge of this one. Is that correct?
The Associate Minister of Justice leads the Treaty Principles Bill. That's Minister Seymour. The Minister of Justice, Minister Goldsmith, has been confirmed as the lead for the review of treaty clauses.
And so where is the Māori ministers involved in this, just as a theoretical proposition? So when do they become involved? They don't get it till Cabinet?
We have a supporting role.
Ms Sykes, I'm conscious that it's 1:15.
Two more questions, ma'am.
And David Seymour is Māori.
Oh, no, okay. I borrow up, but I'm talking about ministers with responsibility for Māori portfolios. I should be more express. But then you're right, Minister of Justice, all the prisoners are Māori, so you're quite right. So I hope I didn't, I'm not trying to raise that ethnic thing, but I see the main portfolios for Māori are Te Puni Kōkiri and your one. So what is when do they come in?
The main lead minister, so when there are issues that traverse a few portfolios, often there will be a lead minister with supporting ministers. In this case, the lead minister is Minister Goldsmith. This is on the review of legislation. Minister Pōtaka is the Minister for Māori Crown Relations, is the supporting minister, as is the Attorney General. But that is not the same structure as what happens in the Treaty Principles Bill.
And my last question is a big one. You've gone to iwi chairs, but you keep forgetting about hapu, unsettled groups, New Zealand Māori Council, Māori Women's Welfare League, Federation of Māori Authorities, whānau hapu caregivers who look after children. Why do you constantly go to the elites of the Māori society to get a common view about what is actually implied by the application of the treaty, especially in the context of this revolutionary policy?
I think you probably know better than anyone, Ms Sykes, that they are not the only people that I talk to, that I am very conscious of the need to engage with hapu and iwi and whānau, that I am also very familiar with the important roles that the Federation of Māori Authorities and the New Zealand Māori Council play. We continue to advocate for wider engagement. Why I refer to the iwi chairs is they have a statement of engagement agreed with the government on a set of priorities, and that's where I was last Thursday, and so that was the reference in my head. They are not the only people.
But New Zealand Māori Council has a statutory responsibility for all Māori. The Māori Women's Welfare League has a particular obligation to all Māori women. Do you see your policy as needing to be reviewed in light of the fact of Te Tiriti terms itself?
Which policy, sorry?
About engagement. So you're prioritising because the government has said we want to give a priority effectively to treaty settlement groups, post-settlement governance entities. Yes. I won't even describe them as iwi. It's post-settlement governance entities that they want. But you know, as an organisation, that there is a much broader obligation by virtue of the terms of the relationship itself. So that engagement itself is inconsistent with the treaty, wouldn't you agree?
We do, but we also have Te Puni Kōkiri, who are also working with those same groups to make, and between us we are able to advise ministers. So they have a role through the Minister of Māori Development, which just also is the Minister for Māori Crown Relations. We make sure that the advice that we are giving to him is coordinated. But I'm very aware of the groups you are talking about. Whenever we are talking about engagement, we talk about all whānau hapua niwi, and we go very wide and very inclusive. When it comes to engagement with those specific groups, it depends on the nature of the issue. So you would have seen through RMA, through Fast Track, the groupings were quite different. It wasn't just iwi chairs.
Yeah, but this isn't that kind of policy. I
Yes.
thought we'd agree to that.
Yes.
So you would have at the outset known that it needed a much broader constituency and input to gather a understanding of the impacts or the potential impacts of what has been proposed or will be developed.
We
so accept
do
that
know.
proposition, it's still in development.
Yeah, and we do know, and that is the work you would expect to be undertaken in the nature of this work, but it hasn't been yet because that work hasn't been done yet.
Because my clients say they haven't been engaged with, so they have been asking to be engaged with,
Yes.
and they keep feeling that the elites of the world, Māori world, get engaged with at the expense of the common Māori individual who has the same rights.
I understand that view, and I can say that, you know, the nature of this work is there is nothing to engage on yet because we don't know where ministers are taking this work. We don't know how they want to approach it. But when we are asked for our advice about who should be engaged with, you can be guaranteed that we will be inclusive about who that is.
I have to ask this question. I thought you'd conceded that it would be a proactive view to actually start engaging in pre-policy with these kind of groups to give a heads up, a good jump start to any minister involved in this.
I think the issue for me is we need to have something to engage on. Our people don't, Māori do not like it when the Crown goes in and says, oh, we're here for a chat. They really want something concrete to engage with, and at the moment, other than what is in the coalition agreements, there is nothing to engage with.
Thank you. I have no further questions.
Listen, we're only going to go, you said 10 minutes. We're only going to go to 1:30 and then we're breaking for lunch.
Thank you, Mum. I might even be less than 10 minutes. Tēnā koe, Ms Anderson, Mr Fraser. I have a question for you based on document number 6.2.4, which is the Cabinet Office circular dated 22 October 2019, specifically on page 4. Okay, so you'll see there that that's prior to this coalition government coming in, and there's a description of Article 1, where you say, put simply, by Article 1, the government gained the right to govern. Now, you've heard Mr Sadler's evidence just now about Article 1 and about the Waitangi Tribunal report, which came out in 2014. Why has that interpretation not been factored into this paper?
So this paper was put through Cabinet under the last government, as you say. We are very well aware of Mr Sadler's and Ngāpuhi's clear view on these matters. However, there's been no agreement to make those changes to the circular.
All right, so, and also just add, and the tribunal's decision on that.
Yes, there's
so
been no agreement to make changes to the circular.
Okay, so was that put to the previous government?
No, it was not. Okay. We will address those matters in our discussions with Ngāpuhi.
All right. So why was it not put to government when this cabinet circular was being drafted?
I don't think the tribunal report was out at that point.
Well, I just pointed out the date of the tribunal report was 2014, and this circular is 2019, so 4 years later.
I can't tell you why it wasn't included, Ms Mason.
Okay, all right.
Possibly because government has a different view.
Right, all right. Now, I had another question, and this relates to your evidence at paragraph 12. And you've already had some questions, and this is probably a question for Mr Fraser.
Excellent.
So, Mr Fraser, you were asked earlier about whether you thought that the coalition policy was harmful for Māori, basically, and you said, well, there wasn't really anything there, it was neutral. Have I got that correct?
No, I did acknowledge that this very hearing is an indication of Māori concern. We've heard Māori concern at Waitangi, we've heard Māori concern through the Kingitanga and all the hui that have happened leading up to this point.
Okay, all right, but the coalition agreement, when it says conduct a comprehensive review that includes the principles of the treaty and replace all such references with specific words relating to the relevance and application of the treaty, or repeal the references, you would agree that that itself indicates that Māori treaty rights will be diminished. Do you accept that?
No, not necessarily. I mean, we talked earlier about provisions that are on the statute books. It doesn't mean they're all good ones. And the process that the tribunal undertakes can help us understand sometimes whether legislation is in fact good. I was thinking about the Pai Ora Healthy Futures Act, which was enacted off the basis of tribunal findings about what principles should apply in that context. So there are some really great provisions on the statute books and some that aren't so good and could result in improvements.
But would you accept that the 1986 state-owned enterprises version of a treaty provision and then the next year the Conservation Act's versions of the treaty set this much higher standard than any of the ones that tried to narrow the treaty, the application of the principles? Would you agree to that?
No, I'm not sure that I'd accept that either, in as much as what I take the coalition government commitment quoted there, the New Zealand First one in paragraph 12, to mean, and again, it needs exploring with ministers, is that some general references, like the ones that you're suggesting, citing there, may not be entirely clear about what Parliament was intending.
But isn't this fundamentally the point? The point is that since those two principles, subsequent ones have been intended to curtail the power that the courts have to make government and government agencies accountable. That's the point. Do you accept that?
No, I don't think. We had some court cases cited earlier about the place of the treaty, and even when a statute doesn't reference the treaty, does it still operate? That's a question in the law and in our constitutional system. So when you say that some provisions on the books that give particular description about how the Crown's treaty obligations might be given effect to, and we talked about the Oranga Tamariki Act earlier, not all of them are terrible provisions that are designed to curtail, but perhaps to explain and give direction and clarity about what is intended.
Well, that's debatable, but the proposition really is that since those two very wide-reaching provisions, subsequent governments have done their best to reduce the power which the courts have. And as the department or person responsible for all of this, would you accept that?
No. Our report observed that the most recent of the treaty principles that we could find all used what's commonly referred to as the highest protection, give effect to. Those three acts had all taken that formulation.
Yeah, so except for those recent ones, but since that long period of time from 1987.
No, I still
that's
would not accept that. Ms Sykes cited Ona Te Tiriti in the education context.
Yeah.
And it's that variation in terms and whether that's a stronger commitment than give effect to the principles of the Treaty of Waitangi. I agree, that's open to debate.
All right, and just one final question. Is it the view of officials that if the bill is not passed, will the review still continue?
If the Treaty Principles Bill is
not passed, so, yes.
Will the review continue?
That's right.
I don't know. I think I assume so because they're two different commitments, but there is a question about how they relate.
Okay, all right. Thank you for your answers.
Kia ora.
Thank you. It's a good time to stop and take the luncheon break for half an hour. Well, until 2 o'clock, so that's 35 minutes. Before we finish, though, I just want to thank you both. It's been a long morning for you, and longer than we expected because the tribunal took so long. We're just so interested in what your ministry does and how that can inform the inquiry. So thank you for your assistance today, both of you.
Tēnā koe.
Kia ora.
No. I sent her the first one. That's the second. Who? Yes. No. Oh yeah. Like she should. No, I sent her. But yeah, like you should. You should. Yeah. Well, because I thought that was what was supposed to be done. That it was supposed to be. Well, I just want to know, like, where did she get that from? Because I don't even think we've gone a prophetic transcript for the second one. That's why I'm like, did you just leave it transcript? Okay, so I'll show you. I don't know if it's in this one. I found it yesterday. So they've only given us that. So, and then Yeah. So this is what she sent me. And it says right here, Tuesday, 30th of June. So this is the first one. So this is how I sent it to her. So I don't know who put it. I think she put the cover page in there because when did I send this? Judge Williams just emailed and said that from here.
Well, thank you, everybody. Let's start again. First of all, I want to apologise to Mr Kibblewhite. I know that you thought you might be over and done with by now, but we had too many questions of your colleagues. And you'll probably find we've got lots of questions for you as well. So welcome to the tribunal. I understand this is your first time appearing as a witness, and we're very happy that you've managed to find the time to come. Ngā mihi. So haro mai.
Mauri ora ki te whare e te tepu, koutou e te tarapiunara. Tēnei taku mihi ki a koutou. E tautoko ana ngā mihi, e tāpiri atu ngā mihi, kua mihia i mua. Nō reira, tēnā koutou, tēnā tātou katoa. Ko Andrew Kibblewhite tōku ingoa, ko tōku tūranga, ko te pau whakarai mo te tāhu o te ture. I'm Andrew Kibblewhite, Secretary for Justice. Here, ready to answer questions.
Yes, thank you. So we're going to begin at the other end, just to give us all a different perspective. Mr. Kevin Prime. No questions? Ms. Kapua.
Kia ora, Mr. Kibblewhite. Right, I've got a few questions. I guess the question was asked this morning about the decision to move from Te Arawhiti to the Ministry of Justice. And I just wonder whether you were able to shed any light on the basis for moving the issue from Te Arawhiti to the Ministry of Justice.
Thank you. Yes, perhaps just a little. It's one of those issues that could easily have been led by either of our agencies. Ms Anderson and I were talking about who we thought the right lead would be, and I think ministers were having a similar conversation. The discussion we've had is that whoever was going to lead it, the other one would be in very close support. We've got slightly different perspectives, obviously, on these issues. At the end of the day, I don't think ministers were clear, and so it was simply a question of clarifying where the accountability was. There was no deeper dialogue or discussion that we were involved in that led to that. It was just, there was always an open question about where it would sit, and it took a while to resolve that.
So within the Ministry of Justice, what team or what group are leading this work now?
We have two teams that are relevant to this work, and it's the same for the broader work that we're doing on the Treaty Principles Bill. We see this fundamentally as the lead for us is in the team that works on constitutional issues. It's a team in the policy group that Raj Chana leads. We do have another group in the ministry, Aotea Arangi, which is a group that has brought a Māori perspective to issues, and they've been closely involved in and across all of this work. So we see a lead through the policy stream, through the constitutional stream, but we're working collectively across the ministry, including with the Aotea Arangi team.
Can you just elaborate a little bit about who comprises or what the mandate is, if you like, for the Aotea Arangi team?
Aotea Arangi has a range of different responsibilities. They are where we lead much of our specific relationship with Māori and iwi, and actually with groups beyond Māori and iwi as well. They have a small policy capability in Aotea Arangi, and they involve themselves across the ministry, whether it's the work we do in support of the courts, so the work of Te Ao Marama that people may be familiar with in the district court, they're involved in that. They're involved in our policy work as well, and we will have a conversation within the ministry so that we speak as one voice, but as one voice that brings together those different strands.
So apart from having discussions with Ms Anderson and the team in Te Arawhiti, are they actively involved with either of your groups in terms of the policy or the Aotea Arangi? The relationships are strong and frequent. Obviously, we're all in the same building.
With the treaty references work, as was explained this morning, we haven't, we've got, it'll be the same people we have working on it, so we haven't put a lot of time and effort into that work simply because it's a sequential thing. We're working through the treaty principles matters that have been obviously very actively being pursued at the moment. So we're leading on that, and that work, Te Arawhiti is one of the agencies that we would consult. They will bring advice and support to it, along with other agencies mentioned this morning, plus one or two others like Department of Prime Minister and Cabinet or Ministry of Foreign Affairs and the like. With the treaty references work, I would expect that we would work very closely with Te Arawhiti as we take that forward, and with Te Puna Kokiri and Crown Law and a few other agencies also.
Okay. Now, in your brief of evidence, you state in paragraph 25 that Cabinet decisions on the policy and process for the bill are yet to be made. Are you referring to decisions of the ministers, or are you referring to the full decisions of the Cabinet?
We've been engaging with the Associate Minister on this bill. He's given us some direction and guidance as to the Cabinet paper that he wants to take to his colleagues. This is talking about the Cabinet decisions. There haven't been specific Cabinet decisions on the Treaty Principles Bill as yet.
So looking at paragraph 28, where you've outlined some of the options, do you have any indication from the Minister as to what his preferred options would be moving forward to a Cabinet paper?
We have had in the 14 December paper, which is referred to 28, and then there was a subsequent paper in March where we did seek feedback from the Minister as to what he would propose in relation to those options about public engagement or engagement with Māori.
And so in terms of the 28.1, 28.2 and 28.3 options, did he express a particular preference for any of those options?
So that's part of what will still be discussed in the Cabinet process. So that part of the exercises will end up being decided by Cabinet at the end. The Minister will obviously make a set of recommendations about it.
Okay. In 28.2, where you set out the option of targeted engagement, which you say was the option that the Ministry recommended to the Minister, are you saying that the Minister hasn't said, yes, that's the way we're going to go, or hasn't yet decided?
I think the Minister, in relation to that one, is, I mean, there will still be decisions taken by Cabinet as to the specific form of consultation that will happen.
The issue about an exposure draft you've included in your evidence and in the papers that we've seen there, some of which make it look as if there is going to be an exposure draft, and others which say it's under consideration. Do you have any indication of what the Minister's view is about an exposure draft?
We do. The Minister's intention is that there will be an exposure draft.
And so when you are talking here about an exposure draft, what do you mean by an exposure draft? Is it a draft that goes out prior to introduction? Is it a draft?
That's correct. It would be a draft that would essentially look like what the eventual bill would look like, but it would be put out into the public domain, and there would be a discussion and a consultation on it.
Well, it's an interesting thought. It will look like what the final bill will look like.
Subject to the consultation that will occur.
So,
with the point of an exposure draft is to get feedback that you would obviously then expect to get taken into account before a final draft was provided.
So there is a possibility, presumably, that during the consultation and following the consultation there will be changes.
Absolutely.
The discussion about the matter being referred to the Prime Minister's office.
This is the matter of who was the lead on the treaty
lead.
references.
Were you involved in the discussions in relation to that?
Only in discussions with my minister, which was the importance of getting clarification as to who was going to be in the lead. My minister indicated, as I think he did to Lilware in his different hat, and as Minister Potaka mentioned, that they would seek guidance from the Prime Minister on that question. So we weren't involved in the discussions with the Prime Minister or his office.
So the decision, are you aware whether the reference to the Prime Minister's office came from specific ministers or ministers jointly?
My broad understanding is that both ministers were keen to have resolution of the issue, and between them they sought that clarification.
So by both ministers you mean the Minister of Justice and the Minister for Māori Crown Relations?
Yes. I don't have specific visibility on how those conversations occurred, but I know from discussions with my minister and discussions with Lil that both of us and both ministers were looking for clarification on it, and it just took a little bit of time for that to happen.
I just noticed in the briefing that was done for the incoming Associate Minister of Justice when the Honourable David Seymour was tasked with responsibility. Who drafted that briefing?
We would have drafted that in the ministry. It would have come out of the policy group primarily.
I was just interested that you referred to the Minister for Māori Affairs in that document.
Did we?
Is that oversight on your
That would be.
part? Right.
I'll have to talk to the Deputy Secretary about that.
Right. Now, one of the issues raised has been the issue raised by Te Arawhiti in one of their papers, which was about a reference to the Law Commission. Have you, in your discussions to date over the review, and I note that you comment that not a lot of work has happened in the last month on that, but have you had any discussion or indication in relation to whether there is an appetite for a reference to the Law Commission?
We have not had any substantive conversations with ministers about the treaty references work as yet.
Has the ministry itself done any work in relation to that?
Not of any real consequence. As I noted earlier, the people we would have working on this are the same. There's a sequence for us, and so we've been working on draft cabinet papers and advice on the Treaty Principles Bill at this stage. And
I guess just the last question, I note in your state in your brief of evidence at 28.2, you refer to option 1, which was to forego any external engagement, as a potential failure to meet the Crown's treaty obligations. I think it's a potential failure, or is it an actual failure?
I think our advice is clear. We don't think that would be consistent with the Crown's obligations.
So it's not a potential failure, it would be a failure to follow option 1.
I think that's probably fair.
Right, thank you. I have no further questions.
Tēnā koe, Mr Kibblewhite. I just have one question, which is about the regulatory impact statement on the Treaty Principles Bill. Will that be ready at the same time as the Cabinet paper?
It will be, yes.
Yes. So when the Cabinet paper we've asked a copy for, we would also like a copy of the RIS.
Understood. Yep.
Thank you.
Dr. Suter.
Kia ora, Andrew.
Kia ora.
I'm just referring to your 14th of December briefing to the Minister, A8, and your key message, number 3, states that the bill is to create certainty about the treaty principles, about what they are and how they apply to New Zealand law. But you say at point 4 of that briefing, there's already a degree of certainty, and we had some discussion about this morning, but in your opinion, is there evidence of any uncertainty?
I think that, as was noted in the evidence from Te Arawhiti, there is clearly a range of different treaty references, and we know from general public discussion that there is a range of interpretations of that. So I think there is, the understanding of the treaty is an always evolving thing, and as it's always evolving, there is always some uncertainty. So I think there is some uncertainty for sure.
And you provided independent analysis and free and frank advice about the pathway to the Treaty Principles Bill.
We have.
Much of which is about risk, in my reading of it. Would that be fair to say?
There's certainly risks identified throughout our advice.
Is that normal? Do you usually give the pros and cons?
Yes, I think our advice will basically reflect the subject matter that it's been advised on, and it'll depend what the question is that's been asked of us. It'll depend whether it's advice that we are coming up with off our own bat, if you like, or whether we are responding to a question, or in this case, responding to a proposal that has come to us through the coalition agreements.
And do you see positive aspects about the bill going forward?
Well, I think that remains to be seen as to how it has done. You would note, I think, in some of the advice that we gave to ministers, the Ministry of Justice has absolutely been of the view that there is value in a conversation, a wider, broader New Zealand conversation about the Constitution and how that works. We've referenced the kaupapa inquiry that the tribunal is doing, and we've referenced other, even the work of the Constitutional Panel of some 10 years ago. So our advice has been that there is value in a conversation. It is conceivable that this discussion could be framed, subject to ministerial decisions, in a way that you would find some value in it.
Okay. And just in that 14 December briefing...
Sorry, can I do a supplementary on that? Are you suggesting that the context for what is likely to be proposed if you follow the Act policy, as you're required to do in the March 2024 document circular, the Cabinet circular, that there's an opportunity to provide the full context of
That would
of the
depend.
treaty and how it was signed and who it was signed with and the years of jurisprudence that's since taken place?
That would depend on what it was in the end that was consulted upon. I think you would have seen in our advice we've encouraged the Minister to take advantage of expert advice, and that would all be with a view to consulting on some principles that might enable a broader conversation.
Yes, and going back to the 14 December briefing, your advice to ministers is that progressing the bill is likely to induce and cause social disruption. 5 months on, is that still your view?
Again, it will depend on the nature of what Cabinet decides on. I stand by the advice in these papers that relate to the Act policy as it was as a starting point, absolutely.
Right. And by social disruption on the 14th of December, what did you actually mean?
It's a broad general description. I wouldn't want to go into the specifics of what that might look like, but it's clear that there'll be a lot of controversy and discontent in relation to the, as we've already seen, in relation to the bill as it's described in the Act policy, and I think it would be a series of versions of that.
You heard me discussing with Mr. Hone Sadler this morning about the principles, ex-principles being a deliberate mistranslation of the te reo text of the Treaty of Waitangi and taken out of historical context. First question is, do you agree with what he said? And he's an expert. And if so, why haven't you provided that advice to the Minister?
Well, the advice we've provided on the policy as drafted is quite strong and quite clear. I think we note that it's a novel interpretation of Article 2, that there's no support for it in legislation, judicial interpretation or expert opinion. So we've provided quite, I think, strong and clear advice on what we understand that, and I don't think my advice is inconsistent with what Mr. Sadler said this morning.
Okay. So you do agree?
Well, the advice we have given ministers is absolutely that the way particularly Article 2 is interpreted is quite novel and not supported by legislation, judicial interpretation or expert opinion.
Thank you. Kia ora.
Professor Williams.
Tēnā koe, thank you for coming along and representing the government at the senior level for this important inquiry. You've had some questions from my colleague Ms Kapua about option 2 in 28.2, and your answer referred to an exposure draft bill. Prior to this hearing, I've been engaged in this process. My only knowledge of exposure bills was from what I knew of the Cabinet Manual 2023, where it's very clear that bills remain confidential and the confidential constraints continue even if an exposure draft is thought to be a good idea. There has to be the approval of the Minister and perhaps the Attorney General. So that looked like a different sort of a kettle of fish from what you're talking about. You're talking about some limited targeted engagement with iwi and hapu, and that can't be on a confidential basis. So you have those various processes already been implemented? No. Essentially the way the consultation occurs, I don't think doesn't match any of the specific proposals we've put forward. What has been agreed by the Minister, and would still need to be subject to Cabinet decision making down the track, as that there would be an exposure draft, and that would be then consulted broadly with the public, including. So it is a different process than the one that we've described, I think, in the paper. Right, but so why are you calling it an exposure draft when an exposure draft must not be discussed with individuals or organisation outside government? Well, because it can be if Cabinet decides and if the Attorney General gives her permission. Right. And that would be what I would expect would happen after the Cabinet.
So the cabinet, I think the likely intent, and it would be subject to cabinet confirmation of this, there would be an exposure draft that would be consulted. But I stress that these are the nature of the decisions that an associate minister and directions that he has given to us. There's still a cabinet process ahead that will decide all of those specifics.
Okay, thank you. So paragraph 30 is the reference to the Prime Minister assigning responsibility for the Treaty Principles Bill to Minister Seymour as Associate Minister for Justice. And then in paragraph 33, we read that the Minister of Justice lodged the legislation bid for the Treaty Principles Bill. So, and it said that that's the Minister of Justice, has kept responsibility for all legislation bids, regardless of the delegation to the Associate Minister. So do you have the wording available for the Tribunal as to what exactly the delegation from the Prime Minister is to Associate Minister Seymour?
I don't have that specific word in here, but I can be clear on what it is. The delegation is for matters in relation to the Treaty Principles Bill. The reason the Minister of Justice is taking the legislation bid is the Primary Minister will take the legislation bids on behalf of all of the legislation in that portfolio. That will be the Associate Minister that would be the lead on this particular proposal.
It would be helpful to me, I don't know whether other members of the Tribunal agree, but it would be helpful to me actually see the delegation.
I think that's published.
That's not confidential, is it?
I don't think so. I think that's all published in public, and that can be made available, I think.
Thank you. And then paragraphs 53 and 66. So this is your functions as civil servants, providing free and frank advice to support ministerial decision-making, is what it says in 53. And in 66, ministers decide the direction and priorities for the agencies for which they hold portfolio responsibilities. Agencies provide free and frank advice to support ministerial decision-making. So just a comment on how it is you support ministerial decision-making when it seems evident from the public arena that the ministers have already made up their minds.
Well, there's lots of different levels of decision-making. I think what we have in the coalition agreements is a clear decision that there will, that a bill will be supported to select committee based on the Act policy. But so we know that's on the work program, and that's what the coalition agreement and the cabinet decisions on the basis of that provide. Underneath that, there's lots of different ways that can be done, and as I've said, we've already advised the Minister there'll be value in bringing expert opinion, and that there is opportunity to vary from the specific word. Based on gives quite a lot of room. You can start at that space, and then you can have quite a broad discussion about what the actual bill might carry. So we've given, as is evident in the advice you have in front of you, we've given quite a lot of free and frank advice about the way that could be carried forward.
So I do have a couple of questions about the brief to the incoming minister. Would it be more appropriate to ask?
You can try with me, and if I get stuck, then Raj can carry on later.
Also, in that brief to the incoming ministers, you speak of the importance for the Ministry of Justice of, quote, our constitutional arrangements.
Yes.
But in your briefing to Honourable Mr Seymour as the new Associate Minister, you make no reference to the place of the Treaty of Waitangi as part of our constitutional arrangements, although there's a considerable amount on that in the Cabinet Manual introduction from Sir Kenneth Keith. You do make a mention of the New Zealand Bill of Rights Act vetting of legislation, but you don't mention the Cabinet Office Circular from 2019, the legislation guidelines from 2021, and other matters that are specific to the Treaty of Waitangi. So, so when you're talking about our constitutional foundations to this newly appointed, newly delegated minister, why are those sorts of documents not referred to?
This is intended to be a very short introductory piece, just explaining who we are at the Ministry of Justice. This is an unusual Associate Minister delegation. There's one specific responsibility with it, and we were fundamentally looking to get on and engage there. This was a very quick and short intro to who we are as a Ministry of Justice. With the many things we wouldn't have mentioned in this, it's not a thorough guide to how we do policy or anything of that nature.
But given that it's specific to the Treaty Principles Bill, surely something about the treaty might have been in here.
Well, I think at the same time we put this up, we were putting other advice up. I think we provided the December briefing that had gone to Minister Goldsmith, and you'd have seen extensive discussion of the treaty in that paper.
Thank you.
Mr. Fox.
Kia ora, Mr. Kibblewhite.
Kia ora.
My hearing's not that great, so if I got this wrong, tell me. But I think when you were speaking to Dr. Suter, one of the comments you made was that the treaty is still evolving. How is it evolving? How do you alter a treaty?
Well, I think the treaty is what it is. It's a foundational document. I think the treaty is, you can see over its, over its history, there have been new court cases. I think the courts are interpreting it and they are explaining it. The Waitangi Tribunal has had a series of hearings over time which have added to our understanding of it. So that's all I'm referring to. Our understanding has evolved with the passage of time.
You heard Mr. Sadler earlier on talking about his view on the 3 articles that are involved in the Act proposed bill, as we've seen it so far. And you yourself have referred to some comment that you made to the Act party people about Article 2, but Article 3 is a complete nonsense, their interpretation of Article 3. It doesn't mean anything in Māori terms. Now, as the lead agency in dealing with this, is it your responsibility or whose responsibility is to point this out to the proposed legislators?
We will absolutely be pointing out as we go through the course of preparing the cabinet paper and any subsequent exposure draft, and including with reliance on expert opinion, there'll be quite a thorough analysis of what's proposed.
Okay, thank you.
Well, thank you for those answers so far. So what is your understanding of the impact of the Cabinet Circular dated 25 March 2023, paragraph 4.3?
Let me just find the reference to that document.
Yes, it's 6.
It's 6.2.
So which was the paragraph?
6.2.6 on our record. 4.3?
4.3. So you're talking sorry, I might be in the wrong cabinet circular.
Is this the one acknowledging?
This is the circular dated 25 March 2024, National Act in New Zealand First Coalition Government Consultation and Operating Arrangements.
So this is that all ministers, parliamentary undersecretaries, chief executives and their respective officers need to be familiar with the 2 agreements that reference?
Yes, correct.
No? So my understanding of that is that...
well, it finishes, they must ensure that they have processes in place to implement them.
Indeed. So the instruction that provides to me is to understand what's in the bill, to identify where we might be involved in its implementation and then to proceed on that basis. So that's what we are currently doing in relation to the Treaty Principles Bill. We're providing advice to ministers as to how they can, or to the Associate Minister of Justice, as to how that commitment can be given effect to.
Right, but the position is that you have no choice but to give effect to them.
Oh, no, that's right. Our role is to support the government of the day. We advise.
Yes, thank you. That was clear in your brief. Is the Prime Minister's Department consulted on policy proposals? Because the Prime Minister oh, well, this particular policy proposal, the Treaty Principles Bill, is it because he's the Prime Minister or is it because he's the leader of the National Party?
The Prime Minister's Department gets informed of all papers because of the Prime Ministerial and not the party leader capacity.
Okay. So when you say in your brief that the leader of the National Party has said regularly in the media that there is no intention to support this bill beyond select committee, Christopher Luxon, the Honourable Christopher Luxon, is talking not as the Prime Minister but as the leader of the National Party. Do you make that distinction because it's required by this circular?
Yes, the way we resolve that, because it's a slightly unorthodox arrangement, is that we work to the Associate Minister in relation to this bill. If the Associate Minister will then have conversations with other ministers around the Cabinet table as to what should happen next. So obviously we're mindful of Mr Luxon's comments, but in relation to this bill, we're working to the Associate Minister.
Right, but when you consult the Department of the Prime Minister, you're consulting on the basis that that department is the Prime Minister's department.
That's correct.
So there's no guarantee, is there, that for Te Ao Māori that even the commitment made as the leader of the National Party won't change because of the Prime Minister's role being distinct from the leader of the National Party?
Well, that's not something I can comment on, really. I mean,
well, you've raised it in your brief.
Well, no, I mean, we are aware of those comments. We're working to the Associate Minister. The Associate Minister's obviously aware of those comments, and he wears that hat as well as the leader of the ACT Party's hat. There will be discussions at the political level. There will be discussions at the Cabinet level,
Yes,
none of which I'll be privy to.
Yes, sorry to interrupt. I was just about to clarify. When the Honourable Christopher Luxon speaks as the leader of the National Party, even in this circular, there's a distinction made between what he's saying as the leader of the National Party and what he's obliged to do as the Prime Minister. You'd agree?
He speaks in a number of capacities, yes.
The circular talks about ministerial consultation at paragraphs 17 to 20, and at 20 it says, when a minister from another party is being consulted, it is important to identify the capacity in which the consultation is taking place. It should be clear to all involved whether the minister's views are being sought as a portfolio minister or as a representative of their party. That's very important, I would have thought. Do you keep a record when you talk to ministers from other coalition partner parties about what they're saying and how and what hat they're wearing at the time they give you their answers?
Well, we wouldn't do much of that discussion with those ministers. So this would be guidance equally for how the different ministers will engage with each other. We're in different hats. We engage. We're creatures of the Cabinet Manual, and we report to our minister. The ministers then have conversation around the Cabinet. We follow Cabinet minutes, which this one clearly does. It would be very unusual for me to go and talk to a minister in a political capacity. I would talk to them in their ministerial capacity.
Right, all right. So to what extent do you think this policy paper, the Cabinet Circular dated 25 March 2023, has changed the way that you develop policy?
So you're 25 March 2024?
Oh, sorry, 2024.
Yeah.
Oh, sorry.
We still produce policy the same way we always have. This provides a context as to what the policy agenda is, essentially. It sets out a list of things that are going to be implemented by this government, and my role as a public servant is to give my free and frank advice on the best way of doing that, including highlighting some of the risks of it and what are the mitigations of some of those things.
Right. Do you consult with anyone other than Cabinet Ministers about the development of policy papers?
We do. It'll depend. It'll be very context specific. We will. Our primary consultation will be with other agencies, but we will also consult with Māori or with community or with industry groups. Depending on the issue, we will give our minister advice as to consulting with other ministers. So the short answer, perhaps the long answer is it varies. Short answer is it varies a lot.
So on this particular policy, who have you consulted with other than ministers?
On this policy, we've consulted.
We
with
know
other,
about TPOG.
Yes, well, we've consulted with the other departments. So I think the departments we've consulted with have been Te Arawhiti, as you've heard, Te Puna Kōkiri, Crown Law, Department of the Prime Minister and Cabinet, Ministry of Foreign Affairs, and PCO.
The Ministry of Foreign Affairs?
In case there are issues in relation to international treaties and the like, they don't think they had a lot to add to the thing at this point.
Okay, thank you. Are you particularly concerned about the impact in the UN with the United Nations Declaration on the Rights of Indigenous Peoples?
I think we were seeing them as a relevant agency, and so we sought their advice on it.
On the
UNDRIP. It would have been whether they thought
on UNDRIP.
You might, and specifically what we talked to them about, I'll get you to talk to my colleague, Mr. Chana, about, but I would expect them to raise those sorts of issues. If they thought there were particular concerns about it, I would absolutely expect them to raise those sorts of issues.
Right, thank you. How far in advance Cabinet dates for considering Cabinet papers set?
So how far in advance of
yes.
I think the specific timetable, normally a deadline for us to get a paper into the Cabinet system for the Minister to sign it in its final form into the Cabinet system is typically Thursday, the week before the Cabinet Committee. Prior to that, there will be some weeks at which point the Minister is consulting the paper with his or her colleague. Prior to that, there will be a period where officials are consulting the paper amongst officials. So there's actually, it's quite a long process to get a policy idea finally into the Cabinet.
And Cabinet committees that are consulted before it goes to Cabinet?
The Thursday deadline I referred to is the week before the Cabinet Committee typically, and so you would put the paper up, the Cabinet Committee would then have a conversation about it. And then typically, I mean, a number of things can happen at that point. The paper may be referred back for more work, or it may be agreed by the committee to be a recommendation then to Cabinet, and then the Cabinet, which might be the following Monday or at some Cabinet later, would confirm it, and at that point it would become a Cabinet decision.
Yep. So which Cabinet committee will take this paper before it goes to Cabinet?
It's the Social Outcomes
Social Outcomes
Committee.
Do you know who's on that committee?
Yes, I think it's already been. I think that's publicly available. In fact, I'm sure it is, and I think Te Arawhiti already undertook to make sure that was available. That list was available.
So you don't know offhand?
It's probably 2/3 of the Cabinet. So I could run off a whole lot of people who would be on it, but I would miss one. So
okay.
Yeah, yeah.
All right. So there's no longer a Cabinet committee dealing with treaty policy?
Not specifically.
Can I go to the briefing that you provided to the Minister on the 12th of March 2024?
Indeed.
Can you tell me where did he agree to seek Cabinet approval of the policy? Well, he must have, because...
Yes.
So did he agree that the principles that have to be applied are those that assist with the interpretation of acts that refer directly to the principles?
What he agreed in that space was that the policy would be based on the Act policy document and other sources.
That's not what your question says at the end of the briefing.
I'm just looking at the
agree to the principles being applied so that either they assist with the interpretation
On
of
that-
acts that
sorry.
refer directly to the principles, or, and then the other two options. So I'm asking you, did he agree to 5.1 in that paper?
Yes, he did. But I would just note that these are in the context. I know, I think the Crown had suggested these decisions would be confidential, but Your Honour has...
I ruled against that.
You ruled against that.
So we don't
so
need
I
to
would just
carry
note
on on that
but I
discussion.
would note, I mean, which is why I'm very happy to talk about them. I would note this is at a point in time, and there's still an ongoing cabinet discussion of which it's obviously still subject to the confidentiality. So there is still uncertainty as to the final shape of the cabinet paper, because they have not been resolved and gone through cabinet yet.
No, I appreciate that from your perspective. Did he agree to the bill stating that it does not alter the text or meaning of the treaty Te Tiriti?
Indeed, yes.
Did he authorise you as officials to engage with constitutional experts during the development of the exposure bill?
Yes, he did.
And have you got a list of people you're considering using?
We will have a list. I don't have that with me.
Well, you
at
must
the
have a
moment.
list by now, because you're going to give Cabinet your advice soon.
Indeed, the exposure draft would, based on this timetable, would come after the first cabinet paper was considered. But absolutely, we have a list of people that we would be looking to engage with.
So who's on your list?
I don't have that with me. Sorry.
Can you provide me with a list, please?
I'm sure we can. You may be able to ask Mr. Chan. No, okay, we'll be able to provide to the tribunal how we'll be approaching that.
Okay, thank you. Well, you've answered my question about binding referendum, so thank you for that. And did he agree to officials drafting a cabinet paper? Yes, he did. And the briefing was forwarded to the Minister of Māori Crown Relations. Was
That's
that correct?
Yes.
Now, going back to your brief at paragraph 59.
This is our
joint brief
to the tribunal.
Yes,
Yep.
thanks. And thank you for answering the questions we had in advance, but then we found all this other materials that we had to ask further questions about. So paragraph 59, what is the policy problem that can only be solved by this bill? And what you've done is you've referred us to the rhetoric of the ACT document, coalition agreement.
Sorry, yes, we have. We answered that question simply by noting we haven't articulated the problem that this bill is trying to solve. We're basing it on what you see there.
Yes, so this isn't your perspective, this is what's in the coalition agreement.
That's correct.
So, do you have a view of what policy problem this proposal is attempting to address beyond what is said here?
The only comment I would make to that is to refer back to a more general view that we have as the ministry, which is that there is value in New Zealand having a conversation in a measured and appropriate way about our constitutional situation. We obviously, as I've noted earlier, we would note the constitutional kaupapa inquiry we see as part of that conversation, and but I think, as you have seen in our advice, that problem doesn't necessarily lead you to the solution that the Treaty Principles Bill is offering.
So, given your position, if you didn't have the coalition agreement, what is the policy problem that you would hope to identify which would need a bill of this type?
I don't have a policy problem that would need a bill of this type to finish.
With the current arrangements. And I'm talking about the current constitutional arrangements dealing with the principles of the Treaty of Waitangi.
No, other than the general view that I've articulated, that we think there is value in a broader conversation around the treaty and what it means for New Zealand. That would be as far as our problem definition would go, and that's what we've articulated in our briefings to the incoming ministers that I think have been made available to the tribunal.
Thank you. Well, thank you very much. I'm going to now hand it over to Lead Counsel, Ms. Mason. Oh, there's a supplementary from Ms Kapua.
Timetable says we do both of them and then they ask.
Oh, yes. Okay, let's do that then. Where's my, have you got this? Oh, yes, it does. Mr Chana, we're going to ask Mr Chana questions and then, unless you have to go, in which case we
No,
can do
I'm at your disposal for as long as you need me.
Okay, that's wonderful. Thank you. Mr Chana. Kevin? No questions?
Kia ora.
Kia ora.
I'm just going to ask you a couple of questions about the documents, 3.1.62, the briefing documents, which I see you've signed. So hence why my questions are being directed to you. The first one I want to just ask you about is relating to the one that of 14th of December 2023 that went to the Minister of Justice. And we've already had the discussion that there's an agreement from the Associate Minister on an exposure draft. Does that mean that the option 3, which was a discussion document, is essentially not an option now that there's an exposure draft being put forward? Are they an either or?
I suppose it's kind of the evolution of the decision-making and the advice. So the 14 December briefing was our initial advice, which went to the Minister of Justice, but it was then copied to the Associate Minister in January once he took over the portfolio, and that we'd suggested that with those three broad approaches, I suppose options might not be the best terminology in hindsight, and one was a very fast one was sort of having some capacity for some engagement, and the third, which reflected what Mr Kibble was talking about, was having a broader constitutional conversation type approach. Then following discussions with Minister Seymour, that was when we discussed and landed upon an exposure draft option, which in part I suppose sits inside the broad range of possibilities of an option 2 approach of having some targeted engagement.
So in terms of those particular options that you've set out there, that 7.2, which appears to be the allegedly preferred option at the moment, limited engagement with the iwi and hapu as we develop policy advice on the bill. Just wonder if you can explain to me why in paragraph 9 below you recommend an approach based on option 2 because it would enable meaningful engagement with the treaty partners and the rest of New Zealand. Who's the rest of New Zealand?
So in that context, I suppose that's kind of the summary and the key messages. If I refer to the sort of more detailed discussion of the options on page, or starting at paragraph 39, what we were thinking about, depending on how much time that we would have in that broad approach of having some target engagement, we would have some opportunity to have a wider engagement beyond iwi hapu whānau, but we'd be able to have some broader engagement with potentially experts or others. So at that stage we were just opening up possibilities for discussion.
So it's not actually describing 7.2 option, it's 7.2 plus, is that?
Well, so 7.2 being our key messages, we were trying to be succinct and kind of draw the Minister's attentions to the sort of broad things we were talking about, and then we expand on those as we go into the body of the briefing, which we start sort of in paragraph 36, which we've titled "You have choices about the process for developing the bill," and then we run through the 3 options in much more detail with potential timetables as well, or illustrative timetables.
So when you're saying you're expanding on that, does the rest of New Zealand, does that just include Māori?
No, in our minds, where it could, that's why we'd use the term rest of New Zealand to be able to suggest that there might be value in having a broader engagement, not just with Māori at that stage, if that was a possibility.
So it's not really an explanation of 7.2, because 7.2 is quite specific about engagement with iwi and hapu.
Yeah, so we're talking about target. So in terms of the expansion, we're talking about target engagement. Yes. Yeah.
So which one did you recommend? Option 2 with targeted for iwi and hapu, or option 2 with iwi, hapu, and the rest of New Zealand?
I suppose I can see you're reading it quite specifically, and maybe potentially as one might draft a legal document. In this context, when we were recommending targeted engagement was sort of the broad approach. We weren't sort of being very specific at this stage of the briefing process as to what exactly that might entail. If you read sort of at the earlier paragraph 36, we were talking about we've considered 3 different approaches, and as I said, options may not have been the best word in hindsight to use to describe the 3 approaches. But we were trying to tease out from the Minister that was there appetite for some engagement, and if it's in that time period, then it would need to be targeted engagement. And then the next question is about how broad could you make that targeted engagement?
So in terms of your targeted engagement with iwi and hapu, which you continue on from paragraph 46, and in 49 you set out a timing. I assume that in the first line that's supposed to be December 2023. I presume you're not going to engage with iwi chairs after the bill?
Of course, no, that should be 23.
So in terms of that, your engagement with iwi and hapu is purely with iwi chairs, is that correct?
As I say, it's an illustrative timetable, and so we just said that if it was going to be that targeted, iwi chairs would be the starting point. But then there's possibilities of going further if we should have additional time.
So we're in that time frame from December 2023. Were you intending to insert engagement with iwi and hapu or te ao Māori generally?
I think what we would, as we were moving our way through this briefing, what we were doing is, as I said, there's sort of those scope and timing issues about how far you could go and who you can go with. Getting to this stage of the briefing, what we were showing that, and I probably should add the extra bit of context, is that because the commitment was the coalition agreement is to introduce a bill as soon as practicable, and discussions with the Minister as soon as practicable had the colour of introduction in 2024. And so in developing these illustrative timetables, we had that in mind, and hence the two illustrative timetables for the first 2 options are all designed to fit inside that 2024 timetable. And once we get to this part of the briefing, if you are to achieve introduction by the end of 24 and towards the end of 24 and in referral to a select committee by that stage, we were demonstrating what little time there would be in terms of taking out any engagement. Hence, in this particular illustration, we've said, well, in that particular time, it would be iwi chairs would be probably the most feasible option given the limited time that's available from February to April.
So in paragraph 47, where you say there would remain a risk that we could not achieve a high level of consensus in the time available, it would appear you would have an extremely high level of risk, because according to this you'd really only have engaged with iwi chairs.
Yes, and that is why we've said what we've said in paragraph 47 about the high level of risk involved given the time that would be available to achieve or carry out any consultation.
And just a question, in paragraph 22 of that same paper, you refer to the, as is the case with any legislation, it would still be a responsibility of the courts and the Waitangi Tribunal to interpret and apply the treaty principles in their new form. The Treaty Principles Bill, as we've heard, is informed by Act policy, as included in the coalition agreements. And in the information provided by Act on why they are advancing a Treaty Principles Bill, they state that they don't want the task of interpretation to be left to the unelected judiciary to interpret the principles in an ad hoc manner without input from New Zealanders. Would you see your statement in paragraph 22 as something that does not support the Act basis for introducing the Treaty Principles Bill?
No, I think what we were trying to elicit through the points we're making in the heading is that it's not clear how the new principles would be applied by the courts and the tribunal. And in our reading of what was provided in the Act material, it wasn't clear to us there was any articulation of how the principles would operate, and hence that's why in the 12 March briefing we went to go on and ask the 3 questions about how do you see those being applied. Would it be to the interpretation of existing principles, to all enactments, or a more broader application? So this was our first, I suppose, attempt at providing some advice about, we don't believe that's been addressed in the policy that you've put forward. This creates a risk about how it might operate, and then that is something that needs to be considered and worked through, and a number of questions to be addressed.
So in your view, is the proposal that the Treaty Principles Bill removes from the unelected judiciary the opportunity to interpret the principles, in your view, is that an appropriate policy base for a bill?
I'm not sure I understand what you're asking there.
If the purpose, based on the Act reasons for having the Treaty Principles Bill, is to remove the interpretation of the principles, to remove it from the courts, from the unelected judiciary and so on. In your statement in paragraph 22, you're essentially saying that the courts will still be interpreting however a Treaty Principles Bill looks. It will be up to the courts to interpret. Do you agree with that, or do you agree with the Act basis that that one of the important things is to remove it from interpretation by the courts?
Oh, I see. So what we're saying at paragraph 22 is that any statutory provision will always be interpreted by the courts, because that is standard orthodoxy, that Parliament will enact a statute and the courts will then be required to interpret that statute and apply it to individual circumstances. So I suppose the Act document is a political party manifesto statement, and what we were trying to highlight there is that we don't think what you've got in your policy statement as the Act party addresses this particular challenge is about how do you see that working, and that was what we went on to explore further in the March briefing about trying to elicit a response to the question about how do you see it working, because then that would be what we would need to consider when developing the policy, and then ultimately the draft bill is about how should we be articulating what approach the courts or tribunal should take to the principles that are drafted.
Right. So I take it from that your position is there will still be statutory interpretation irrespective. So why is that not recorded as the position of, in your briefing paper, to make very clear that irrespective of what the Act party thingamabob does here, puts on there as the basis for the bill, irrespective of that, why is your advice not that that will not be something that will occur because there will always be statutory interpretation?
Well, okay, so the commitment is to develop a bill based on the ACT Party policy, and in my view what we've highlighted in paragraph 22 is to say, well, yes, we've got your policy prescription from the ACT Party, and this is one area we're highlighting that while it may be based on that, this is an outstanding risk or something that must be addressed in considering the proposal to Cabinet.
Instead of saying it can't be done, you're saying we're going to look at ways in which perhaps we can carry out the ACT Party policy.
Well, our obligation is to implement the we serve the government of the day and our minister who's directing us in this work, and so if I could look at the Cabinet Office circular at paragraph 3, it does say that the coalition agreements are the foundation for government, and at paragraph 4.3 the Chief Executive and hence myself are required to look at do what we can to implement those policies. And so the advice we're presenting in this paper and the March paper is going through that, highlighting the risks, issues and approaches. And while it says, and for us it says based on, and then in the March briefing I think we highlight that the Associate Minister was comfortable in receiving advice on how that could be further developed beyond what it's based on.
So the carrying out the coalition agreement implementation overrides the free and frank advice on statutory interpretation?
No, it doesn't. It sits alongside.
Thank you.
Tēnā koe. Thank you for this. Can I just ask, so with an exposure bill, what kind of material or information is usually supplied with it so that the public, in considering it, can make informed decisions about it?
There's no set prescription, but based on past experience of doing exposure drafts or releasing drafted provisions for consultation, typically what I've done in the past and what my experience in the past is the draft that's presented may not be fully formed and complete, but large chunks, well, the key provisions would be the ones maybe potentially drafted without necessarily worrying too much about some detailed operative provisions or consequential amendments. And then we would have alongside that a bit of a discussion document or an explanatory document which highlights what is the policy that's seeking to be achieved, what is the basis for the drafting, what considerations went into the drafting, given that the exposure draft process is largely about usually checking whether the policy as stated has been accurately transcribed into the legislation. Do people see any disjunct or failure to sort of implement the policy through that? So that would be the basic kind of approach we would adopt in presenting it to the public.
I see. And so where do the constitutions,
and that they then authorise the instructing of Parliamentary Council to draft, we would seek the input of the experts at that phase in terms of preparing the material that would be finalised and seeking Cabinet approval to release publicly.
So you mean the provisions of the exposure draft or the explanatory material?
Typically, it's just presented as one package to the Cabinet. When you're looking at discussion documents of any form, it's usually I seek approval to release this publicly and here's my timetable would what be sought from Cabinet.
I'm not clear though. So if you have an exposure draft and then explanatory material about that draft, is the intention for the constitutional experts to contribute to the explanatory material or to the provisions of the exposure draft?
I suspect we would ask them to contribute to both, as it's one package of material to be released to the public. It wouldn't make sense in my mind to not have them engaged on both. But I suppose at this stage of planning, I haven't actually given any detailed thought or talked to my team precisely about how we might construct that, as we're still awaiting final decisions about the approach and the timing of that.
And then before that's released, that goes back to Cabinet for approval.
Yeah, so if I just draw your eyes to the March 12 briefing, we've tried to articulate that for the Minister, and I think that might be a useful guide from paragraph 6, where we kind of set out, or from paragraph 3, we're kind of setting out the sequence of decision making at Cabinet. So step 1, we would go and get at paragraph 5, we've highlighted what we'd need to get approval for at that stage, which would then give us the authority and ability to draft exposure draft and related material. Second Cabinet paper, that paragraph 6 we describe, but in essence saying, well, we'll take that back. And then Professor Williams referring to your quoting of the Cabinet manual, that's through that process that we would seek the authorisation of the Attorney-General to waive the legal professional privilege that resides in anything drafted by Parliamentary Council Officer. It's a bit bureaucratic, but those are sort of the steps that we'd go through. So we'd capture that in the second paper that we refer to at paragraph 6. And sort of that early July kind of indicative time frame, and then we would release that and have that out, and then there'd be a third Cabinet paper, which we would go back with, saying we've considered all the feedback that we've got on the exposure draft. Here's any changes or amendments that need to be made to the form of the bill that would then be finally introduced to the House with all the processes that are associated with finalising that approval.
I see. And as part of the public consultation, will there be specific hui and consultation with iwi and hapu?
We haven't gone down to that level of planning yet about exactly what form that would take, and in part that will be informed by what Cabinet decides, and then what's the timeframes that are finally confirmed and other matters like that.
I see.
Yeah.
And I did have another question, but I've forgotten what it was. So if I remember, I'll put it in writing. Thank you.
Kia ora, thank you for coming and giving evidence. I'm just trying to find something which no one else has asked a question about. And it's the regulatory impact analysis,
yes,
which is referred to in paragraph 39 of your joint evidence. I see the Electoral Commission as one of the people consulted, presumably about the binding referendum aspect of things.
Yes.
Once Cabinet decision comes out, will the regulatory impact analysis be something that will be available to the tribunal?
Yes, so it's... oh no. I'm afraid it's not a question that's been not asked. It's submitted at the same time as we submit the Cabinet paper, and both documents are considered and would be available after the Cabinet has considered both.
Right. Sorry, thank you.
Have you read the briefs of evidence that have... Oh, and thank you for coming. I forget my manners. It's good to see you here because of the important role you hold in New Zealand's constitutional arrangements. So, have you read the briefs from the experts who filed in this inquiry, i.e. Mr. Max Harris and Professor Giddies and Natalie Coates and Jane Kelsey?
I have read them, but in the limited time available, in terms of digesting them and having a great deal of thought about them, it's somewhat limited.
Right. Well, obviously they have their perspective about what the Principles Bill may or may not do. So in providing advice to the ministers and to potentially in a Cabinet paper, are you going to mention those briefs? Are you going to look at what was said in those briefs and explain them as at least one point of view about this very important constitutional topic?
Timely question, as I asked my team who's drafting the Cabinet paper that very question last night, saying, I've just read these and finished reading them. What do you think we could do with them in the time available in terms of informing the Cabinet paper? So we're certainly turning our minds to it. We were wondering, though, what is the status of these? Are they available for us to be referred to, given they're part of a tribunal hearing? So that was my other question to them to clarify before we went forward on that.
Yes, well, that's a good question, but certainly, well, yes, you can refer to them.
In these constrained times, oh dear. Yeah.
Now, the PCO has been consulted already.
Mm-hmm.
Is that unusual to be consulting at this stage? Because you haven't even got a high-level approval
No, so
cabinet paper
we're
yet.
probably slightly different to most other agencies in terms of how often we talk to Parliamentary Council, and I can explain it like this. At any given time, the Ministry of Justice will have 30 to 40 different bills in various states of development, whether they be a twinkling in the eye of a minister or sort of making their way through the final stages of the parliamentary process. And so we would be one of the highest users or demanding users of the Parliamentary Council's time. So most other departments would have their interactions with Parliamentary Council through the legislation program setting process, where you saw the thing that's been provided, the legislation bid that's in our evidence. Given that we have such a high volume, we've developed over many numbers of years, or even before I was in the role, was just to be able to inform them of what is coming up, and then also for them to be able to have an appreciation of what the size and weight and complexity of the legislation that may result should Cabinet approve it. So for us, the engagement is about making sure we have a good relationship with our colleagues there to be able to triage, prioritise. It helps our colleagues in Parliamentary Council Office think about which is the drafter that they might assign and when they're becoming available. So at one level, the consultation with Parliamentary Council Office at that early stage for us anyway is a much more practical and prosaic level of consultation.
Oh, that might explain it, but you already have words for a bill. So have Parliamentary Council Office reviewed those words?
No, they haven't reviewed those words, because the instructions for them to actually carry out any work would come from the Cabinet policy decision that is made, and that is the way that is done in terms of them being able to actually apply substantive resource to the problem.
Thank you for telling me that. And the Attorney General's involvement is she's already been a participant in the consultation round. Is that right?
The Crown Law Office has, and I'm afraid the Minister has circulated, the Associate Minister has circulated the paper for consultation with ministerial colleagues, and I believe the Attorney General has been provided a copy as part of that process, but I haven't seen any feedback provided by her or her office at this stage.
Right. Thank you. Can you tell me why the Cabinet date for this paper is so uncertain? We've got a nebulous, it might be the end of the month, it may change, it may be earlier, maybe later. Why is it so uncertain? Surely you can predict, given your experience, exactly how long it's going to take to get this through.
My experience tells me that it's very difficult to predict exactly when a Cabinet paper might be finalised and submitted to Cabinet. There's a number of steps I think that Andrew outlined. One is that I can usually be pretty certain about when we will complete our departmental processes and have a paper available to provide to the Minister I'm responsible to circulate for ministerial consultation, because that's kind of within my teams and my responsibility to set timetables, demand things of other departments and manage consultation processes to ensure things are done at a particular time. After that, it goes into that ministerial consultation, and some of that depends on when a key minister, the key minister that you need to talk to is overseas, so it just doesn't work. Sometimes it's like, a minister wants to have a greater understanding, so there's just more time needed for them able to do that. Alternatively, there might be substantive issues that have been highlighted between ministers, therefore there needs to be a substantive discussion, and we might be asked by our minister to prepare supplementary material to be able to assist in some of those discussions. So in terms of that phase of it, I'm never certain as to when it might actually finally land at the Cabinet Office's inbox.
Okay, thank you. We were originally told that the Cabinet was going to look at this on the 3rd of May.
Yes.
So that was optimistic?
Yeah, optimistic was one. Well, in hindsight, yes, that was optimistic, yes.
Did that advice come from you?
No, I think it was probably more of an evolution than an advisory piece, that we had, as you'd see in the brief of
Crown
evidence.
Law got it from somewhere. Where would they have got it from?
Oh, they would have got the 3rd of May from us, definitely. Yes. But in terms of then why it changed, you'll probably see in the brief that the timeline of events, we've had various discussions and still working our way through some of the issues with the Minister.
Okay. Well, thank you. That's been extremely helpful. It certainly helped clarify issues for myself. and I'm sure the tribunal panel will join me in thanking you very much.
My pleasure.
And now I'm going to give it over to Ms Mason for 10 minutes, then we'll break for a cup of tea and then we'll come back and you can carry on.
Thank you.
I'm aware that we've got witnesses waiting, so can council confer over the break to see who absolutely needs to provide evidence today before they return back to their home base? I know, for example, Mr Munro's come all the way from the north.
And Your Honour, Mr Tipeni can only appear in between 4 and 5.
Yes, so...
Today.
All right. So how long do you think you'll be?
I would say half an hour.
Half an hour. And Ms Sykes?
Ma'am, I have 3 questions arising from the panel at the moment, but that's all.
Okay. So we should be able to get everybody in if we sit a bit longer?
Yes, Your Honour.
And Kaupare, which one of you is going to?
Tēnā koe te kaipakawa. We also have some pātai for
How
Mr.
many?
Chana.
How long?
Probably about 20 minutes.
20 minutes.
In light of
Okay.
that may be refined as well, depending on the questions of my friend.
Did you confer with, I mean, why am I being told lead counsel is going to lead on most of the...
There's one each.
Oh, I see.
Yes, Your Honour, is one each.
Oh, yes, that's right.
Yeah.
Okay. All right. Well, let's see how we go. We will take the break at 3:30 for a quarter of an hour, and then you can confer and tell me afterwards how we're going to manage everybody. And Mr. Allen, you can let me know exactly what is happening with your 2 witnesses to see whether or not they can stay much longer. All right. Thank you.
Tēnā koe, Mr Kibblewhite, I've got questions for you. So my questions are, I'll go through your brief first, and then go through a couple of the briefings. So that's the order. So council's name is Mason, and I act for 6 of the claimants, applicants. In paragraph 15 of your brief of evidence, and you've been asked this question a number of times, and it's about the interrelationship between what's seen as the direction from the coalition agreement and this idea that in New Zealand we follow a system of government where the public service is neutral. And you say in paragraph 15.1 that agencies can also give advice on the direction and priorities of the portfolio. Should that not be a should, not a can, but a must? Isn't it mandatory?
Oftentimes, yes. I absolutely think that agencies, as part of their stewardship responsibilities, should have views on the issues that the government should be progressing. And so I agree with you. I think that's a mandatory responsibility on me. It's part of my stewardship responsibilities. In addition to that, though, sometimes our policy is responding to a direction, which is also a totally legitimate thing. If a minister says, this is what I'm going to do, then our advice will probably have the opportunity to say whether we think it's a good idea or not, but having given that free and frank advice, our responsibility is to advise on how best to implement it.
Okay. Did you have a prior step where you said, I'm sorry, this is your policy, but this actually breaches a number of constitutional conventions, a number of procedural requirements? Did you say that in writing or in person to the relevant ministers?
I think you can see that line of argument in a number of places through our advice. I would say you can see it in some of our briefings to the incoming minister. You can see it in the December briefing and in the March briefing, where we highlight the concerns we have about some of either the approaches to engagement or the content of the starting point for the bill being what was in the Act policy statement.
Yes, I saw that, but it seemed quite weak there was not any statement that ever said this actually breaches the Cabinet Manual or this actually breaches the Public Service Act. I didn't. It just looked so weak. Sorry.
Well, I'm sorry you read it that way.
Well, isn't that just a matter that you can put in submission?
Yes,
to be honest, I would say that this. I mean, my view is this is quite direct and strong advice, but that may be that I speak as a Mandarin and not as a lawyer.
All right. Now, in relation to that, did senior public servants get together once the government got in, knowing that there would be these problems, to try to work out a strategy?
Certainly, senior public servants discuss on how we can best serve the government and consistent with the Public Service Act and the like. So absolutely, public servants have been talking about how best we can give effect, what opportunities there are to do the best work we can in fulfilling whatever the responsibilities are. But I wouldn't want to convey the impression that there's a group of public servants scheming somewhere to undermine something. There is absolutely a discussion about how we can, best in a spirit of service meet what's asked of us.
Yes, so it wasn't really about undermining, but it was upholding your responsibilities to give free and frank, and I presume having a discussion about what the best strategy would be that would allow you to meet your Public Service Act responsibilities.
Where we think there is value in testing and engaging and doing things together, absolutely. Officials from different agencies will discuss how best to do that.
All right. And now I'd just like to go to the three options that had been discussed earlier in the 14 December briefing. And one of the options was to not have any engagement at all. Do you think that option should not have been in there, given your requirements under the Public Service Act to provide options that are lawful?
Well, I think our responsibility, which I think we've discharged in these papers, is to be mindful of what ministers are trying to achieve, and some of that was to move this forward quite quickly. You've got to be also conscious of the overarching political environment around this, where I think there's a clear sense of urgency. What our responsibility on that was to set out what the consequences of that would be, which I think we do in the advice.
Yes, but in the Cabinet Circular, this is the 2nd April 2019, document 6.2.5 at 1.3, it says that the requirements by Cabinet for ministers in contemporary Treaty of Waitangi issues is to seek agreement from MCR, and I know that that's no longer available, before they make decisions, but it says or enter into formal discussions with Māori. Now that would be contrary to this option one, or option one would be contrary to that, wouldn't it?
It would be.
So it shouldn't really have been put in a paper as an option, should it?
Well, ministers take those decisions. Our advice was, as it is here, that would not be the appropriate way of proceeding with it. If ministers were to choose to do that, Cabinet can decide to proceed with such a thing if Cabinet so chooses to.
Yes, but I think my point that I'm putting to you is that it shouldn't even have made it in there if you were undertaking your responsibilities to provide free and frank, lawful advice.
No, I think our responsibility is to provide the free and frank advice and to clearly set out the consequences and the risks associated with it, which I think we did.
All right. And just a related question to you. So even though a policy could be seen to be unconstitutional and in breach of the treaty and unconscionable, your view is that you still should support the government with options without clearly and specifically saying that these are what these policies do.
Well, if we thought a policy suffered from those failures, it would be our responsibility to point out those failures to ministers.
All right. Well, I just didn't see in any of the briefings that that was pointed out to the ministers.
Well, I think I would beg to differ on that. I think the advice does set out, it says that, I think there's a paragraph, depending on which paper you're looking at, the 14 December one is the one I have in front of me. We note that the description of the principles differs from current understandings. We note
Sorry, what paragraph?
What paragraph? That's paragraph 19 in the 14 December, but there's a similar paragraph in the March paper. We note that it's a novel interpretation of Article 2 without any support that we're aware of in legislation, judicial interpretation or expert opinion. So I think throughout these papers, I think we're pretty clear as to the shortcomings on the policy as a starting point, and then we attempt to identify how that might be mitigated, including through the involvement of experts and the like going forward.
Yes, well, the problem that my clients have is it says it differs significantly. It doesn't say it's just outright wrong. There's nothing there that says it's wrong and it breaches the treaty. And unless you can point me to somewhere in the briefings where that is made absolutely clear,
I don't think our minister was under any doubt about our views on the policy.
By your minister, you mean the
Associate
Minister of
Minister
Justice?
we were working to,
Oh,
Mr.
the
Seymour.
Associate.
Mm.
Okay. All right. Sorry, a lot of my questions have actually been asked. I'd just like to take you to paragraph 30
In which document, sorry?
of your brief of evidence. And just like to understand more this relationship between your minister and the associate minister.
Between the Minister of Justice and the Associate Minister of Justice?
Yes, yes, and the delegation. This delegation that was given to Minister Seymour, do you know why that happened?
Well, I think that would be a discussion that would have occurred at the political level. I think it was probably so that both ministers could express the views that they might have separately on it through a ministerial process.
And do you give exactly the same advice to Associate Minister Seymour as you give to your minister?
We're fully transparent with our advice. The advice we give to Mr. Seymour relates to his responsibilities to take it forward and therefore may be responding to particular questions of his. But our practice, as agreed with the ministers, is that all of the advice that we give to the Associate Minister is copied to the Minister of Justice, so we have full transparency around that.
And so these decisions that Chief Judge referred to earlier that were at the end of your 12th March briefing, were they decisions that were made by both the ministers or just one?
No, that was a paper specifically to the Associate Minister, and they effectively represent his guidance to us for the next stage of this, essentially preparing the cabinet paper.
Okay, and I see that it was copied to Minister Goldsmith.
That's correct, but essentially that paper was to the Associate Minister, and it was the background leading into the work that we've now done to prepare a draft cabinet paper, and then we're obviously into the next part of the process where that cabinet paper iterates, initially between the Minister and us, and then between ministers and his ministerial colleagues.
Have there been any disagreements that you know of, or different views imparted to you from the two ministers?
In relation to the Cabinet paper, I wouldn't go there now because of the
briefings.
conventions of Cabinet confidentiality.
Yes, but the briefings?
Well, no, not specifically in relation to the briefings, but then I wouldn't read anything into that. We didn't have specific feedback on the briefings that would have drawn out any differences.
Okay, thank you. I'd just like to now refer to your obligation under the Public Service Act, and you would know that there is an obligation under Section 14 about the Crown's relationships with Māori. And Section 14.1 says the role of the public service includes supporting the Crown and its relationships with Māori under the treaty. Has this been pointed out to Associate Minister Seymour?
That we have responsibilities to support the Crown and its relationships with Māori?
Yes.
I'm not sure I've written it down, but I think it's clearly understood.
Sorry.
It's nearly 20 to 4.
Shall we take the break?
How much longer do you think it'll be?
I have a few questions.
Okay, we'll take the break now. Have a cup of tea. Nothing like a cup of tea in the afternoon. Thank you. We're going to take 15 minutes, so be back here at 5 to 4. Have you
Your-
been able to confer with
yes,
council? How do you propose we proceed?
Your Honour, we propose that...
I realise that half the problem's ours. We took too long.
It's the way it
They're
is.
just such good witnesses.
It's the way it is, Your Honour. So what will happen now is Mr. T-Penny will come on because he can only do at this time. Once he's finished, then I'll get back to my questions, which shouldn't be too long, maybe 10 or 15 minutes, and then my friend Ms. Peters will have in between 10 and 20 minutes, and then after that, Kipper will finish today, so we might sit a bit later. And then tomorrow, what will happen is we'll have Natalie on first, and then Andrew Geddes,
very
and then
sensible.
it's all in the same. And we've got tomorrow afternoon spare, so we should be able to get through it all.
That's brilliant, thanks. That isn't all the witnesses I've asked to see, though. Is there a reason why we're not seeing them?
And then the same, we'll have the same order tomorrow.
Okay.
It'll just follow on.
Okay, very good. And that's acceptable to you, Mr. Allen? Thank you.
I'm sorry, tēnā koe te kaipakawa, Ms. Tere Tipene tēnei. Just quickly in relation to tomorrow, I'm just asking whether the tribunal would be open to starting slightly earlier at 8:45. Ms. Coates, who was supposed to be on this afternoon, has another appointment at 9:30. So we were hoping that she, if you sat earlier, you could still have her for 45 minutes and then she could go off to her other kaupapa. Just something to consider. If it's not a go, then she'll have to fit within the half an hour, but she did ask for the 45 minutes if you're open
Yeah,
to
I
it.
think half an hour will be long enough.
Okay,
Ms.
ka pai.
Coates, thanks.
Thank you.
Well, I thought that today, but I can't guarantee it. All right.
Tēnā no e te pānara, Ms. Cherrington tēnei. I will just start now and jump straight over to Mr. Tipene, who is on the AVL screen, and I can see him there. His evidence is at appellation number A11, and he's aware that his evidence is being taken as read, but would also like to make a few brief opening remarks before questioning. Kei a koe matua pita.
Tēnā koe, Mr. Tipene. Nei rā te mihi kia koe. Kei te nota koe.
Ai, ko te awa o tau marere kei muri ia.
Ka pai. Well, mahau te wā i nai nei.
Tēnā koe te kai whakawā e mihi atu ana kia koe. I taku kitenga mutunga i a koe. I Waitangi ke taua. E tata atu ana ki te rā o Waitangi. Nā reira, kua hau tēnei hono atu ana ki te tribunal o Waitangi. E mihi tonu ana kia koe. I runga anō i ēnā āhuatanga katoa. Ara e mihi atu ana ki a koutou te rōpū whakamana i te tiriti o Waitangi. E noho maina i te tepu. I taku kitenga mutunga i ētahi o koutou. I te hui, te tribunal ki raro, i te tuanui o te whare o Manu Koroki. E Monty. E grant e mihi tonu ana ki a kaurua. Ara, ki a koutou katoa e te rōpū e ki te atu ana i a koe e tereki, e mihi atu ana ki a koutou katoa. E ki te ana hoki a hau i te ngā whakahua kei muri i a koutou, ara ko te matua kihi ngātai te tahi. I roto i waku tuhinga, i tuhi atu a hau mo te whakaritenga o te tribunal i te tau 2014. Te whakatau a tērā o ngā tribunal e pāna ki te tiriti o Waitangi he whakaputanga taku kitenga i te whakaahua a matua kihi me mihi atu ki ngā mate katoa. E hoki ana ngā mahara e rima wiki i pau ki roto i te taitokerau, i te timatatanga ka tai atu te tribunal, i te puihi katoa ngā iwi o ngā hapu o ngā puhi. I te mutunga, i whakararata ngā hapu o ngā puhi, ki te tribunal, i te kai whakawā o tērā rōpū, ara ki tērā o ngā rauatahi.
Te rangi nui woka, ki hi ngātai nā reira e haere tonu ana ngā mihi kia koutou, e Kevin, ngā koutou katoa, e mihi ana kia koutou. In terms of opening comments, thank you for your forbearance in the first instance of fitting me in at this particular time. Given I have a meeting with a Minister of the Crown shortly, I appreciate that you were able to fit me in. Can I start by saying I appreciate that evidence is being heard on this significant issue, unlike Te Aka Whaiora and how that was how our people weren't able to express themselves because of how the government ran that particular kaupapa that is part of what I call e ngaru nui, e ngaru roa, is a tsunami of change that is undermining the great deal of work that has been done for a long, long time to get or to continue the trajectory within He Whakaputanga and Te Tiriti o Waitangi, and all of that good work, and particularly in regard to this bill, is undermining the honour of all of those people who have worked together, Māori, Pākehā, the people of this nation. So I wanted to express myself in that regard in the first instance. You have read my evidence. Several points that I wanted to highlight and I end my evidence. I may be jumping around a little bit when I referred to he kokonga whare e kitea, he kokonga ngākau e kore e kitea. While the Waitangi Tribunal can't do that much about those in the shadows, I'm speaking about those people and those motivations that are behind the coalition government at this time. Because those people who are sponsoring each of those parties and therefore are driving those parties in a particular, or to have particular manifestos and to expedite the very issues that we're talking about in this tribunal hearing. I'm always thinking about what's driving these coalition parties to undermine the various pieces of legislation in terms of the work that I've already said, has been done for some time now. I also highlight what I know political parties who hold qualitative surveys and then feed that information to the leaders of each of those parties. So I want to bring that to bear, because sometimes we look at the politicians themselves and those who are articulating their manifestos, but I want to draw some attention to those people who are behind the scenes, who are pushing those kaupapa. I'll leave that where it is. I have come from a meeting at the Northland Regional Council where, while we're talking about Māori wards, and it's not the subject that we're talking about here, but it's all bundled up into the same thing, because at the crux of all of this is He Whakaputanga, it is Te Tiriti o Waitangi, and as I say, or what I highlighted today, is that the Northland Regional Council, as certainly for the Māori committee that it has, its mission statement is rangatiratanga and kāwanatanga working together for the well-being of the environment. And while that may be in the Northland Regional Council, that was envisaged by Kawiti when he put his tohu on Te Tiriti o Waitangi and his two sons, Taura Kawiti and mahi, praone, te kuhanga, kawiti. So those things we hold dear in our hearts for what, and I've said this in my evidence, what is an honourable compact between rangatiratanga and kāwanatanga is hardly the case now with this legislation being mooted and now being progressed through Parliament. And essentially, we as Māori are being sidelined more now than ever. So in highlighting that point, I talk about how our society in New Zealand and in fact the world are tentative at best, but afraid, at least afraid, when the population, society is afraid, they look for strong leadership. And in this case, society in New Zealand has looked for strong and steady leadership, not so much to work with us. Well, it is to work with us and for us, but it's also to deal to them. And them is Te Iwi Māori. In saying that, I think our society in Aotearoa, New Zealand, is and has been working on a trajectory to honour Te Tiriti o Waitangi. It's slow and incremental, but it's going backwards now because more than anything, society is not only afraid, they're afraid because they don't understand. And so there are spokespeople for political parties that are exacerbating the fear that people have about Māori. And look, to conclude, I really wanted to bring all of that to bear here in this tribunal because we must never lose sight of those who are pushing these agendas and how our nation is not living up to the honour of Te Tiriti o Waitangi he whakaputanga. I'll end it there, Judge, panel, tēnā koutou.
Thank you for that summary. We're going to start with Mr. Kevin Prime, although I don't think he has any questions of you. No, Ms. Kapua? No, Dr. Grant?
Tēnā koe. I do have a couple of questions. Thank you for your evidence. I found it really helpful. You said in paragraph 16 of your brief, I don't know if you have that in front of you, but you said that should a bill go to whatever stage, it will water down and continue an undermining of the treaty. And I wondered, could you explain if the bill is not supported by National past a select committee, so it doesn't pass, why would just proceeding that far water down and undermine the treaty?
Because in kia ora, Grant, because the political parties have agreed to even begin the path, because as I say in my evidence, there is no such thing as treaty principles. And I understand fully that we've been living with them for a little while now. But just by agreeing that the treaty principles are the basis of the honour of Te Tiriti o Waitangi is already undermining it.
Okay.
You don't sound convinced.
No, I'm not actually. Partly because of maybe I'm too immersed in it myself, but my understanding is that because the particular words of the Māori language and the English language version of the treaty don't always speak particularly to some circumstances that might emerge in modern society, that the principles of the treaty, what was intended, as well as the words and the meaning and the effect of the words, but also what was intended at the time by the signatories, by those who explained the treaty, and the circumstances in which it was signed, all contribute to an understanding of some broad principles. And I don't see that as an unhelpful thing, but that doesn't mean we don't also apply the words of the treaty. But that's a different issue, I think, to the question of whether the Crown should define the principles of the treaty without consultation with Māori. So my next question for you, I guess, is do you think an exposure draft process, have you been listening today? No, you've been at a meeting. The Crown has advised that there will be an exposure draft of the bill issued for public consultation before it's introduced to the House. And so you may want to answer this in writing if you want some more time to think about it. But my question is whether you think that that form of consultation, an exposure draft for public consultation, is sufficient.
I think I'd better get an answer to you in writing.
Okay. And that's all my questions, thank you.
But just to go back to your previous question, because I said that you didn't sound convinced. As far as we're concerned in Ngāti Hine, our tupuna signed te treaty o Waitangi. They didn't sign the principles or the treaty or anything else. So they understood fully what they were signing. I'll leave it there.
I'll just do a supplementary on that. So your position would be that if there is to be a review, you'd like to see all the provisions dealing with the principles of the treaty reflect the actual text of the treaty or have references to the actual text of the treaty in the whakaputanga, rather than deal with the... So you're the complete reverse of the ACT policy?
Yes.
All right. Professor Williams.
Tēnā koe kara. I was interested in the short description you gave of the hui at Waihomio in 1844 with the Meri Pounamu being smeared with tūtai. And I just wondered whether you would use the same form of protest in relationship to the Treaty Principles Bill. What would your tūtai be in respect of this particular matter before us?
Well, I think we should think of a better word.
Well, well, human excrement then.
Yeah, when I mentioned in my mihi that we were in Manukoroki together for the military veterans hearing, and both Monty and Grant were there on that panel, that I used this example as well. Really nothing changes. That's my answer, because the Mere Pounamu is a rangatiratanga and it's our authority. And every time somebody or a party or person undermines what it stood for, it's being compromised at every step to the point where you'll get left with nothing. But yeah, the same metaphor applies now as it did then.
Kia ora, thank you.
Tēnā koe Peter. Tēnā tāua I runga tō tāua tīpenetanga. No reira, kia ora. We this afternoon we heard talk about this exposure draft where it's likely that if this proceeds, it'll be taken around and no doubt it'll whip up some support and maybe controversy as well. But if the bill itself doesn't proceed past the committee stage, there's talk that maybe there's still some advantage in having a discussion about these principles. And
You know, maybe there's a better way of handling it than that. Do you have any thoughts on that?
Yeah, look, what I do understand is that the coalition government has been stitched together and deals have been made, and one party wants to take it right through. The other two parties want to take it to a point. Yeah, I think that when the leader of the ACT Party publicly states that one of the rationale, the key rationale for putting this forward is so that every New Zealander can be part of debate and discussion and learn more. I don't believe that that is the motivation, even though it has some merit, which is my answer to your question. Anytime that New Zealanders are talking about Te Tiriti o Waitangi, he whakaputanga, it's a good thing, but it's being pitched in a way which is very negative. It's not a proactive, positive manner in which it's being put forward even now. So I hope I've answered your question. I think there is some merit in us talking about it, but I would rather that discussion be held in a much more proactive and positive way, because when you start talking about this in a political way, the majority of people in this country are going to be driven by political imperatives, not by educational or more positive motivations.
There's also talk, and maybe even some planning, for a referendum, and a binding referendum on the issues. Do you have any views on that?
If it does go to a referendum, it's going to be doomed to, failure on the part of Māori, not on those who are pushing it forward for political reasons. It's not dissimilar to Māori wards, where Māori wards went to a poll. It is always going to fail. I have given evidence in other Waitangi Tribunal forums where I say you only have to look at when the first general election and local body elections were held in, I think it was 1853, how women were marginalised, how Māori were marginalised. So when you look at the Westminster system of bringing from Britain to New Zealand and how that system was set up to retain the status quo, while we may be in 2024 now, a lot of that is still very much there, of keeping certain people in power and Māori on the margins. So when it comes to a poll, the population demographics have turned around now, and you're going to be losing.
Kia ora. Thank you very much.
Peter, can you tell me what you believe is the actual harm, even if the Principles Bill doesn't go beyond Select Committee? What's the actual harm to Ngāti Hine?
The actual harm to Ngāti Hine is akin to our kai kōrero to the Waitangi 1040 inquiry, that rangatiratanga and kawanatanga and spheres of influence mean shared decision-making. When you're starting at a much lower standard, you're having to go up to get back to the original, authentic, genuine position. And so, as I say, it's every time you're starting on something less than, you're halving it at every step. I don't know if I've made myself clear in answering your question.
Yes, well, I could see that that might be true if there was an actual consequence. What is the consequence here? Is it a impact on self-esteem, or is it that people don't take Ngāti Hine seriously enough because of what's happening in this debate, or it's just the undermining of is it because the Crown has undertaken this unilaterally, or?
Well, I think it's all of the above, really. And what I'm trying to say is that we know what the spirit of Te Tiriti o Waitangi was on the 6th of February in 1840 and after that. But now, if you start, if the starting point is to talk about the tiriti or the treaty principles, so that's the treaty principles, not Te Tiriti, you're starting about, if it's a 20-floor building, you're starting at the 5th floor, and the only way after that is down. So you've already lost 15 floors starting this debate. And sorry, I don't think I'm answering your question in terms of the consequences. Where that's borne out is any time laws, regulations are made and our sphere of influence, rangatiratanga, is not starting at that original position, we're losing. People may say, well, that's a naive position here in 2024, but I know what the honour of Te Tiriti was on February the 6th, 1840. Well, by the way, Kawiti didn't sign until May the 13th.
Right, okay. And what about the review of statutes that look at the principles of the treaty? To some extent, you answered Dr. Grant on this, and while I accept that you would like to see the reverse of what ACT is proposing, which is that all the legislation with a reference to the principles of the treaty be amended to the text of Te Tiriti, and the provisions were made stronger, but they at the moment provide some form of relief within the different spheres that are covered by the statutes that have those treaty provisions in them. Would you agree?
Sorry, if I understand your question properly.
It's better than nothing, that's what I'm saying.
Yes, yeah. Or how we say it in Ngāti Hine is, pai ke te kore I te kore rawatu.
Okay. Well, I think on that note we might finish.
Ma'am, can I ask one question following up from this? Ms.
No,
Sykes?
you can put it in writing. Otherwise, everybody will want to do it. No. Well, I'm happy for you to put it in writing. Thank you very much, Mr. Tipene.
Kia ora. Kia ora koutou.
I have 3 questions for Mr. Kibblewhite before we go to the other ones. I sought leave for that.
Yes.
And I want that to do before we start on the other witness.
Yes, I don't think Ms. Mason's finished though.
No, I haven't finished. Mr. Kibblewhite. I'm now up to paragraph 59 of your brief of evidence. You make a reference there to the rationale for the bill, and you repeat the ACT policy that the treaty principles are vague. But you don't agree that they are vague, do you?
Our view is the treaty's been interpreted through the courts and through the tribunal. There's a good level of understanding and jurisprudence that supports our understanding of it.
Okay, thank you. And then going on to paragraph 61.
61?
Yes. And that's the reference to the Ministry of Foreign Affairs and Trade. But I just had a question about the UN DRIP, the Declaration of the Rights of Indigenous Peoples. In the briefings from the Ministry, the 14th of December and the 12 March briefings, there's no mention of any effect on the DRIP. Is there a reason for that?
Well, those papers, as I think Mr Chana explained earlier, were all about how we are working with the Minister to understand the nature of the directions he's now giving us over the course of preparing Cabinet paper and resolving the finer detail of that as we move things forward.
All right. Then at paragraph 64, you talk about no tikanga Māori or te reo experts were involved. Why were they not involved? Why did you not involve them straight away?
We would get to the point of involving those experts when we had something more specific to engage them with. I would note that our in-house team, Ati Arangi, worked with the policy group in preparing this, but I wouldn't call that a tikanga experts.
Right, because the Act policy around the treaty principles, which is set out in your briefings, they talk about Article 1, Article 2, and Article 3, and they interpret te reo text. In hindsight, shouldn't that have been something you did straight away?
I think there is ample opportunity still to do that. We're not passing a comment on their interpretation of the te reo text. It's clear from our advice that we think there are difficulties with their interpretation of what the treaty says, and included in that is obviously the issues of interpretation.
Yes, but if you had gotten expert advice straight away, you could have said in the paper, not just that it differs, but it's just incorrect, it's wrong, couldn't you?
Well, these are papers setting out a series of decisions. We've had a lot of engagement and conversation with the Associate Minister on it as well. There has, as I said earlier, I don't think there'd be any doubt as to his views as to where we thought some of the pitfalls lay through this.
Do you know, did he get somebody else to interpret these?
I don't know the specific source of those interpretations.
And have you put alternative interpretations to him?
What we have sought, and you can see that through these papers, is the opportunity to engage as we go to the next phase, including with around how whatever might end up in an exposure draft is worded.
And then just looking at what the party, the ACT party and the policy call the principles, they look more like interpretations of the actual articles, don't they?
Well, I think even then, for the reasons you just alluded to earlier, they're not necessarily a direct translation, I wouldn't have thought, but I'm not in a position to talk about where the ACT principles emanated from. I mean, we've provided commentary on how they might be taken forward.
Right. Can I just ask you to go to the 14th December briefing? And if you can go to page 3 and paragraph 11.
Which paragraph, sorry?
11.
Yes.
Okay. And you'll see there what the policy says in 11.1, 11.2 and 11.3. They start off with the actual articles, and then they have a part of the Māori text of the article, and then they have an interpretation of them. And then if you look down at paragraph 14, your ministry has set out some of the principles, and they say partnership, active protection, and redress. Now that's really quite different from this interpretive exercise that's going on at paragraph 11, isn't it?
It is.
Yes. So would you not say that it's not so much principles that have been set out in the Act policy, but an interpretation of part of the Māori text of Te Tiriti?
I think it's pretty clear in our advice that we think the principles as articulated in the Act statement are quite a departure from any current expert thinking on this.
Yes, so much so that it's a bit odd to call them principles, isn't it? It's not principles per se. it's an interpretation.
I don't really have any comment on that. I think they've called them principles. That's no doubt legitimate in their mind.
Right. Okay. I had also a similar sort of question in relation to the constitutional experts, and you have been asked about this, and you said we will be getting constitutional experts later after this cabinet process. But I'd just like to take you to the cabinet manual, page 89, if you have it. And at 5.83,
My fives run out at 5.77 on the one I'm looking at.
shall I just read
Yeah,
out
why
what
don't
it
you do
says?
that?
Right, okay.
Yep.
So it's basically a section that talks about the referral to Cabinet of decisions taken outside of the Cabinet process. Right, and it says decisions taken by ministers at ad hoc meetings and proposals to implement policies arising from manifesto commitments or coalition or other agreements between political parties need to be referred through the cabinet process if they concern matters that would usually be considered by cabinet. And then it says this process ensures that proper consultation is followed, decisions are taken with the authority of cabinet, agencies and PCO have clear instructions, and finally that the financial and regulatory implications of decisions taken outside the cabinet process can be taken into account. Now, just reflecting on that last requirement, surely you should have got this evidence before the matter went to cabinet, and that's the...
Well, the matter still hasn't gone to cabinet.
No, but you're saying that you're not going to get the expert evidence until after the cabinet process.
As Mr. Chana outlined, there's likely to be 3 cabinet papers on this. The first is a broad one of process and broad direction. The second one is, and this, even then I should stress, is subject to cabinet decision making, but based on our instructions that we currently have from the Associate Minister, the second cabinet paper would be where we would be in the detail of what the exposure draft might contain, and we'd absolutely have talked to the experts prior to that.
All right, so was it the minister who asked you to wait to get the expert evidence?
No.
No. But this requirement in the cabinet manual doesn't say later in the process, it just says the cabinet process, and it would seem that what it's saying is that because it's unusual that a direction comes from coalition government, that actually it has to go to cabinet with
I would
all
say
the
we have the, sorry to interrupt a bit, I'd say we have the expertise that we need for the first cabinet paper, because the first cabinet paper is as much about process and how we might carry it forward. When we get to the second one, which will have the level of the exposure draft, at that point, we will absolutely go beyond the expertise that we have in-house or that we will have engaged with other departments. So it depends. I think the cabinet requirement has to be read in the context of the content of the cabinet paper that it's been talked about.
Yes, but certain basic things like actually the interpretation of te reo, the Tiriti text that Associate Minister Seymour, that his party has done, if it's just blatantly incorrect, surely that should be something that is put up in the first cabinet paper.
Well, I'm not at liberty to talk about what is in the first cabinet paper.
No, but you have said you're not getting that advice until later.
I've said we're not getting the expert advice on the
That's
content of
right.
it at this point.
Yeah. I'm just putting to you that that's a failing.
Well, I would disagree with that in the context of the cabinet paper that we're putting forward.
All right. Now, I have some questions in relation to your 14 December briefing. In particular, at page 8 and paragraph 42, I'll just read that. It relates to the questions that I've just asked. It says, developing a bill that purports to settle the treaty principles without working with the treaty partner could be seen as one partner attempting to define what the treaty means and the obligations it creates. So this problem of the bill, it's really one that goes to the heart of the legal interpretation of the treaty, Te Tiriti. Would you agree?
As is said here, the next sentence, failing to engage, will be seen as failing to meet the obligation under the treaty to act reasonably, honourably and in good faith.
Yeah. So it's an interpretation of the treaty issue, isn't it?
Sorry, I'm not...
So the issue, this is just the previous sentence that I read out, one partner attempting to define what the treaty means. So it's attempting to interpret and define. It's an interpretive issue. Yes?
Well, I think it's pretty clear our advice is that doing that in isolation is problematic.
Okay. All right. Just because you're from the Ministry of Justice, can you think of any situations where a legal document, a treaty, a contract that has pretty weighty implications, and there's an interpretive issue, that it wouldn't go to the courts for resolution?
I can imagine it would. If it's something in relation to a treaty where there are two parties, you would need to have a mechanism for resolving any differences between the two parties that might or might not involve the courts, but it would involve the two parties, which I think is the essence of your question.
Yes, and you wouldn't have one party deciding, well, the party with the most power deciding what it says, would you?
Well, as I said, I think our advice is quite clear that we think that's problematic.
Yes, and it's just inconsistent with Western notions of the rule of law and access to justice. Would agree with that?
I think, as I say, our advice I think is pretty clear that we think that's a problematic approach.
In your briefings, I don't see any mention of the serious consequences to the rule of law of one party dictating through Parliament what this document means. Is there a reason for that?
I think you can read through our advice in a range of different areas, matters that point to that. I think whether we've invoked the rule of law, I'm not familiar if we have in any particular place in the briefing.
No, I'm not meant to be critical, but one of the problems that my clients see is that you are the ministry there to protect justice, and these fairly hefty issues and very serious matters that appear to be just being ridden roughshod over are not even mentioned, and when they are, they're not mentioned and I know you say that's strong language, but there's not really anything in here that says that this treaty has been breached or this is not consistent with the rule of law. There's nothing straightforward like that.
Look, I can understand that your clients may have looked for blunter or more direct commentary, and I absolutely acknowledge that. I think as senior public servants advising on this, we have a range of responsibilities that to provide our free and frank advice to ministers. It's to make sure we have identified where we think the weaknesses are, where we think the risks lie. I think we have done that. Our role is also to help those ministers track a path forward and find a way of, if there is a way of going forward, to do so without, in a way that mitigates as many of the issues as possible. And what you're seeing through these papers is a combination of those sorts of things. These papers have underpinned a series of meetings that we've had with the Associate Minister as well, which have been very direct and engaging and have traversed a lot of the same territory.
Another thing that's really not in here in the briefings that seems to be enormously important is the fact that Parliament has never specified what the principles have been. It's never done that before. And this is really groundbreaking in a negative way. Is there a reason why that's not set out anywhere?
There's at the moment these papers are setting out a path forward through this. There would be further advice given, including in papers such as the regulatory impact assessment that we will be preparing that will canvass all of those issues.
Mm. Yes, but don't you think it's a bit late by then? I mean, this has been around for 6 months now, and these major issues have been flagged.
I don't think the Associate Minister has been under any illusion as to what we think and our content, and won't be surprised when he sees any range of these matters talked about in the regulatory impact assessment and elsewhere. I mean, I would reassure you there's been very candid conversation, as well as I think quite, albeit written from a policy official's perspective, I think quite direct briefings here.
Mm. And then just another example, paragraph 30, where it says there's a risk of damaging Māori-Crown relations because the bill could be seen as an attempt to limit the rights and obligations, but actually it is. It's a very blatant attempt to limit the rights and obligations created by the treaty. So why is that language, direct, blunt language, not used?
Well, I suspect the Minister himself might not characterise it as an attempt to limit the rights and obligations. He would probably characterise it differently. Again, we are drawing out that is a very clear and real risk as to how it might be perceived, and again, we would have followed that up in conversation with him.
Can I ask
We've
how
noted
much
that it
longer you're going to
presents a
be, Ms
significant-
Mason? Because it's now 4:45 and we've still got other people who want to
Your Honour, I just have...
question Mr Kibblewhite.
I just have about a few more questions. Right, thank you. I can put the rest in writing. All right. Now, I had a question about this paper that I don't think is on the record. And this is the briefing dated 28 November 2023, titled New Zealand Constitution, Democracy and Open Government.
No, it's not that one. Yes.
And I'm looking at paragraph 37. And you talk about the constitutional kaupapa inquiry. And you say it is an opportunity to engage in forward-looking conversations about the future of our constitutional arrangements. This inquiry canvasses fundamental questions about how the treaty has been given effect in our constitutional arrangements. And this was a briefing to your minister, the Honourable Ms. Paul Goldsmith. Can I just ask, did he accept that? Did he agree that this was a good way forward?
Did he accept? I mean, I think he certainly took the briefing, and we've had some engagement on it. That doesn't represent a specific recommendation. It's an observation about the opportunity the constitutional kaupapa inquiry offers.
And that has been well received by the minister?
I actually don't know that I'd be able to comment on with confidence on exactly his views on that, because we probably haven't specifically, it wasn't a specific recommendation.
All right, that's all I have. I'll put the rest of my questions in writing, but thank you very much for your responses.
Ms Sykes?
Kia ora. I know it's late in the afternoon, we call it the graveyard shift, but we're going to come from the afterlife, okay? Kia ora. Okay, paragraph 72 of your brief says, the Minister has indicated a preference that the bill be taken to a binding referendum. You recall the panel took you there. But the Prime Minister has said publicly this bill will only go to a select committee. So how do you square those directions? And I want to finish this. Are you working on the presumption that this bill will become law and go to a referendum, or something else? The evidence is confusing on this. I'd like it very clear.
Yeah, so some of that, we're working to our minister. He will, as in the associate minister on this, he will take this paper to Cabinet, and then the ministers will have a conversation about how it lands. I mean, we know from political comment, both from Mr. Seymour and Mr. Luxon, that both of them have different views on this. That will have to get resolved for the purposes of the government around the Cabinet table.
But then, if I can take you to paragraph 8 of your Crown of your Council's opening submissions, this is why I'm asking these questions. How do we square what the Minister said about his preference for the bill to go to a binding referendum with what the Crown has said in its opening submission, that the Tribunal should only consider the Crown action as taking the bill to Select Committee? And that's your submission.
So, can you just put the question again, please, Anne?
So, you're saying that's going to be the Cabinet.
Yep.
But today, in this inquiry, your council has made it quite clear that there's an assumption we're going to the Select Committee from your immediate supervising minister, who is suggesting that he wants a referendum. There's a conflict of power here, both in the roles of the Kāwanatanga actors, but also it's fundamental in this inquiry, I think, as to what, in terms of 4.3, which we've all talked about, is being implemented.
I think the key words here, this cannot be extrapolated, because that is the truth. We actually don't, I can't extrapolate out beyond what's going to happen through the Cabinet process. And that, I think, is the point we're making here. We don't know what's going to happen in that process. We can all read you as well as me can read the political commentary on it. I'm working to a minister. The minister is providing us instruction as to the Cabinet paper that will be his Cabinet paper that he wants to take to the committee. That's been consulted amongst ministers, and that will take its course.
Okay. Am I right in thinking that for the work done on the Treaty Principles Bill is being done at least in part through a constitutional team? You talked about 2 teams.
That's correct.
And who has precedence or who has ascendancy out of those teams?
This has been led out of the policy group, but my expectation of my teams inside the ministry is we bring a collective ministry view. Effectively, all the advice that the ministry gives is on my behalf as Secretary for Justice, and so my expectation is that it internalises all of those issues.
So you accept that this bill has constitutional implications?
Indeed.
Thank you. So why did you say nothing about the New Zealand's constitutional arrangements in the briefing to Mr. Seymour, the incoming Associate Minister of Justice, when his delegation specifically involved this constitutional bill?
I don't think Minister Seymour has been under any doubt that this has constitutional implications.
I accept that. It's a follow-up question from my friend, Ms. Mason. You have an obligation, full, free, frank advice.
Yep.
You're accepting today, and in fact all the material I want to, it's in there, but it's not directly in there, and this is something that needs to be squarely assessed by him. It's not just a policy to clarify judge-made law. It's a policy that is constitutional in its implication and implementation. Why didn't you say that in your statement to him?
Well, and perhaps in our more bureaucratic way, I think we made that point quite clearly in these papers.
Okay, and then I'm still not, this is my last question, I'm still a bit unclear. You would have seen me belabour the point this morning with your friends from Te Arawhiti. So what is going to happen? Are we going to, from now forward, are you going to have 2 teams working on the Treaty of Waitangi Bill and another team on the treaty review process? What is happening? Because it's very unclear, and this needs to be clarified for us today.
So let me tell you, as the lead CE now for both of them, how I make sense of it, and that may be helpful to you and to the tribunal. So there are 2 separate coalition commitments. They're both essentially part of the agenda of this government, as agreed and mandated in the Cabinet Minute that we've talked a little bit about today. So my role now, consistent with that minute, is to work with the two ministers who will be lead, being the Associate Minister on the Treaty Principles Bill and the Minister of Justice on the other one, to progress those pieces of work. They are obviously both separate, but they're covering, broadly, they're playing in the same space. There is a broad net of things that includes the issues that arise in both of them. For actually quite practical reasons, I'll have the same people working on them. We're focused on the Treaty Principles Bill at the moment. As that works its way through, we will lift our work on the treaty references side of things. And part of what will have to happen as we go through this, it will happen quite a lot of it, I suspect, in discussions between ministers and between political leaders, is how some of the differences are resolved and how some of that different work is taken forward. Because we know, again, from public commentary, that the different party leaders all have different views on how the two things sort. Our job as officials is to respond to help the particular tasks that the Cabinet has said that we should work on, and to give our best advice to our two ministers in this case on how best to progress it. To the extent we can see opportunities to make connections between them, we will provide that advice. But at the end of the day, some of the conflict of ideas that you're describing will only be resolved at the political level, or at least between ministers.
And the last follow-up on that is, my friend took you to the obligations of costing, and in this kind of time that we're being razor cuts right through the public service, is that a cost-effective way to deal with matters? And I'll put that bluntly, if a policy is in breach of the treaty, then why are we reviewing the principles? That they should both be abandoned. Seems logical.
Well, from a resource allocation point of view, we agree the priorities for our work program with our minister. We have a limited number of people working on policy and a limited level of resource, so trade-offs have to be made. This is identified as a priority by the government, and therefore is a thing that we're working on.
And if it's abandoned, just, because that's what we're being told by the Prime Minister, then shouldn't we also abandon, logically, the treaty review bills process, a treaty review process?
I'm not seeing the connection, because I don't think the Prime Minister's made any similar comments on the treaty references work that he's made on this one.
But you see this connection as we've explored it in the hearing today, don't you?
Well, yes, but I've said that I think it's clear to everybody that both of these matters deal with the treaty and the way the treaty is dealt with in law and statute, and so clearly they're in the same. There'll be overlaps, and there'll be some of the same people and some of the same commentary, and many of the people here will be interested as the fact that we're doing both of these together in the same two things. That doesn't mean they are the same. They're two separate policy pieces of work. That part of our job is to understand the loose knit between them as we go forward, and that will only evolve as ministers make decisions.
Thank you. I have no further questions.
You? You're going to ask questions.
Tēnā koe te kaiwhakawā, o ka pātai e tuku ana ki a Mr. Chana.
I think at this stage, if you need to leave, Mr. Kibblewhite, you're welcome to. But thank you for today.
Appreciate it.
Tēnā koe, Mr. Chana. Tēnā koe I au kōrero taunaki kua tukuna ki mua I te aroaro o tēnei rōpū whakamana I te tiriti o Waitangi. Just acknowledging the evidence that you've brought before the tribunal today. So thank you. My name is Ms. Peters from Kaupari Law, and I will be leading some of the cross-examination questions for you, to you on behalf of Claimant Counsel. And just for context, the clients that I represent in this inquiry are a applicant group, Ngāti Rehia, a hapu from Te Taitokerau, and also an interested party being trustees of Te Aupapa Kohatu Trust, who hail from Motiti Island in Tauranga Moana.
my pātai for you have been refined to some extent in light of other pātai that we've already been that have been explored. One topic to begin with is just in terms of just understanding the role and responsibilities of a ministry, and in particular from your perspective in your role. So to begin with, at paragraph 5 of your joint brief of evidence, you say your role is to advise ministers on policy and legislation related to New Zealand constitutional arrangements, correct?
Correct.
Do you accept that the proposed Treaty Principles Bill, as well as the statutory review of existing treaty clauses, raises issues of constitutional importance?
Yes.
And also issues that are of fundamental importance to Māori?
Yes.
And would you agree that Māori have a direct whakapapa to Te Tiriti in terms of what's been canvassed in some of the kōrero today, where they descend from rangatira who signed Te Tiriti 184 years ago?
Yeah, I think that's evident in the evidence that's been filed on behalf of the claimants, and some of that has raised and addressed that directly, yes. And
you would accept that Māori have kōrero tuku iho relayed from tūpuna in successive generations about Te Tiriti and the significance of that and the relationship and understandings that come out of it?
I suppose I'm finding it difficult to kind of say just yes to some of these things, because you're putting to me sort of expert evidence or interpretations, whereas I'm not a tikanga expert or an expert in anything Māori.
I'm certainly not
so in that
suggesting
regard,
that.
I just kind of want to sort of put that caveat on that. It's like I can accept that experts have expressed these views.
And you would accept that that kōrero tuku iho, in terms of the oral traditions within hapu, forms part of the body of knowledge within hapu whānau today?
Well, if that's what if I'm saying yes, I'm not doing that on the basis of any of my own personal knowledge or expertise in this space. I suppose I'm here as the head of the policy group, and sort of as we delve into some of these particular expert matters, if it's in the evidence, and I have read those briefs, there's some elements of that in there, and I wouldn't dispute any of that.
So the briefs that you say you've read, have you read the briefs of evidence of the claimants themselves?
I've read the briefs that were associated with this hearing today.
Okay. Have you read the brief of evidence of Kipa Munro, for example?
Yes, I've worked as I said earlier, I have read them, but I haven't had the opportunity to really engage in depth with what has been put. But in that level, I wouldn't say I have any. They are of interest and they are of value, and they explain and develop the various ideas. Hence, the earlier thought about saying yes, they could be relevant to us as we go into the next stages of the process of developing the policy.
Ka pai. Turning to the Crown and in your role as Deputy Secretary Policy at the Ministry, what is your understanding of Te Tiriti and the Crown's obligations to Māori?
Well, that's a deep thing. I mean,
I guess as a, for example, you'd be aware of the principle of partnership.
Yes. Maybe if I can give this in context, I mean, I think you're asking me specific knowledge questions as to me. In terms of my role as Deputy Secretary, I don't sit down and write advice to the ministers based on my own knowledge and experience. My role as Deputy Secretary is that I have a group of people, and also I have all the resources, as Andrew was saying, in the Ministry of Justice, including my colleagues in Atiarangi, and I also have access to Te Arawhiti and Te Punikokri and others. So in terms of developing advice to ministers, while I might have a role in commissioning and finally signing out, which is more or less on behalf of Andrew as Secretary for Justice. And if I reflect back when I first started my career, I would never sign my name personally. I would never sign over my name personally. We'd always used to sign over for Secretary for Justice to really highlight the fact this is the Ministry's advice. So in terms of what I do in terms of creating the advice that's done here, this has all been prepared by large numbers of people in my team. Plus, in addition to that, we have a number of quality assurance and peer review processes which all of this goes through. And so in that respect, my part is to establish the teams, ensure that they have the necessary resources, support the creation of those quality assurance and policy development processes, which then results in this final product.
Yes.
Which is a reflection of that, and then my role in signing it is to more or less say, yeah, that's an accurate reflection of the Ministry's work and that it represents the
Yes.
Ministry's advice.
And
so
in
I
signing
yeah.
those,
Yeah.
for example, the two briefings to the Minister from December last year and March this year, that are signed off by you,
Yes.
you would have an understanding of the contents of those
Yes,
briefings.
and I would have had that though from interacting with my teams on that rather than, and I would have worked my way through the briefs with them at the time based on their expert knowledge as well.
Goodbye. So in terms of the partnership, would you agree that that means or includes that Māori should be engaged with on matters of significance and importance to them?
Yes, and that's captured in the Cabinet Office circulars and the guidance that's prepared by Te Ara Whiti, so that's very clearly the Crown's, the stated approach within the public service and the guidance that's provided to all policy advisors.
Yes, and that includes the duty to act in good faith and honourably towards Māori, doesn't it?
Yes.
And you are aware of the concept of rangatiratanga?
Yes.
And what is your understanding of rangatiratanga?
Well, in some ways, I've read the evidence of Professor Mutu, and I've read the other articulations of that, and Natalie Coates, I think, also addressed it. Plus, we've got the articulations throughout the advice from Te Ara Whiti, plus the Cabinet Office circular. So, without wanting to repeat everything, I would articulate it in the context of the rangatiratanga sphere. I suppose it's the other development, and another way of expressing it would be around chieftainship or responsibility and leadership over not just physical property but over people and taonga.
Tēnā koe. And you mentioned the rangatiratanga sphere. What's your understanding of kāwanatanga?
Drawn from the similar sources, and that's the kāwanatanga sphere, the rangatiratanga sphere, and then what's the interaction of those and who has authority in different places over different aspects, and what is the relationship that needs to, the respectful relationships that you need to have when you have things that engage both or may overlap.
Sorry, just to clarify, did you say that the rangatiratanga, you see the rangatiratanga sphere and the kāwanatanga sphere as one and the same?
No.
Okay. In terms of, at paragraph 20 of your evidence, you talk about the Ministry having a role with other agencies supporting the public service to understand tiriti, or the treaty, obligations within current constitutional settings. Do you recall that?
So was that paragraph
20?
Yep, got that there.
And you also explain in paragraph 14 that ministers consider the advice by the public service when making decisions of government policy. But later on in paragraph 49, you say the policy to review the statutes was not arrived at based on a policy proposal or a problem from the ministry. So in other words, you're saying there that ministers made decisions without advice on a complex and constitutional issue. Is that correct?
No, I wouldn't characterise it like that. If I was to put it in context, I mean, in this case, we're dealing with something that's articulated in a coalition agreement, which now forms the basis of government, as you can see in that Cabinet Office circular. But if I think back to prior elections over my career, while it may not be coalition agreements, parties always have manifesto commitments, and when they come in, those have been developed through their own party political policy processes. And when they enter government, in large part, they will always be wanting to implement what might have been in their manifesto, which they put to the electorate. In some of those cases, then, what our role is not, well, we don't say, well, don't do it, because they've made a very clear commitment to do it. Our role in terms of providing free and frank advice and serving of the government of the day is to see how we can support them in implementing their policy, prescription, or their approach, or whatever initiative they want to do. And through that, though, we are providing free and frank advice about what are the risks, what are the issues, what are the downfalls, what are the potential advantages, what are the other considerations. And a lot of that then you can see articulated in the Cabinet Manual and other guidance material, which sort of sets out all the different types of things that we might do.
So are you saying that the governments or the agencies' understandings of the Treaty of Waitangi, of Te Tiriti o Waitangi, change or can change depending on the government of the day?
No, I think if you look at the briefing and what is happening here, the coalition government has a proposal that it has agreed to that it wants to introduce as soon as practicable a treaty principles bill. So that is what they want to do. I think in our advice, what we have gone through both in December and the March advice is then highlight to say, well, that's a novel interpretation. Here's some of the risks and issues. Here is the issues that arise if you adopt the approach that you are suggesting in terms of not having elements of engagement or providing opportunities to do so. So that is the nature of our role in terms of supporting and advising the government of the day on their objectives and priorities.
So in terms of the general policy process that has been explored to some extent already, you mention in your paragraph 15.1 that the general policy process includes ministers deciding the direction of and priorities for the agencies in their portfolio, and the agencies can also give advice on the direction and priorities of the portfolio. So that didn't happen in this case, did it? Because the coalition agreement, as you referred to, has preempted that standard policy-making process.
That paragraph's talking about a much broader exercise in looking at the entire set of priorities that the minister may want to work on inside the portfolio. So what we're referring to there in that particular paragraph is that the sources of a particular policy project or an initiative could be any number of things. It could be based on our advice highlighting that there's a deficiency in a statutory framework or there's an issue to be resolved. It could be from party political manifestos or coalition agreements. It could have been raised by external stakeholders in relation to an issue they're having an issue on, and the minister will then ask us to explore that further. So international obligations may give rise to a need to explore a particular issue. So any number of places may generate the need to undertake some policy work and take forward a issue. What we then do in sitting down with the minister is that because we only have limited resource, plus you're also constrained by the amount of time in terms of time within the cabinet committee process, time within the parliamentary process, the resources of parliamentary council as examples, we would work that way through, and in sort of my experience, we usually try and do that on the basis of a parliamentary term to say, well, what do you want to do first, second, third, where is this one, how important is it, an assessment of what is the size and complexity of particular projects and what the sequencing is. So that's what we're referring to when we say that, you know, ministers will decide directions, but then we also have to explore how do we prioritise within that and what the priorities for the government and the minister might be.
So if your role is to give independent advice to the ministers, does that include rejecting the statement of the policy or the policy problem or the proposed solution?
Well, no, we provide free and frank advice. And in doing that, we would highlight what is the value, what is the cost, what are the relative merits of this versus any other particular issue that may need to be worked on. And that's then for the minister to consider and determine what he or she may want us to work on and develop further.
So you would consider that the coalition agreement sets the parameters of your advice?
No, it doesn't set the parameters of our advice, but it sets the parameters of our work program or the matters that we need to work on. So,
which then informs your advice?
Or then we provide advice on the matters that are being progressed or the initiatives that are to be developed.
So regardless of further changes or iterations, the cabinet paper that eventually is finalised must remain consistent with the coalition agreement. That's correct?
Well, the purpose of the cabinet paper is to advance the coalition agreement, which is to introduce a bill as soon as practicable based on Act Party policy, I think, and if I paraphrase it. So that is the purpose of the cabinet paper, and that is what we are providing advice on, and that's what cabinet will engage on to determine how that will then occur.
And just following on from that, I think my friend took you to the Cabinet Office, or it was Mr. Kibble-White actually, the Cabinet Office Circular document number 6.2.6.
Oh, that's a paragraph in the Cabinet Manual. Yep.
Yes, and it's headed National Act in New Zealand Coalition Government.
Or, no? Am I thinking of the...
Yes.
Oh, the circular, yes, okay, no,
March circular.
that's all right. I'm with you. Yep, 24.2. Yeah.
And that talks about, at paragraph 4.2, it talks about the coalition agreement being guided by a no surprises principle. So you're not expecting any surprises, so to speak, in the Cabinet papers or outcome from the ongoing policy process?
That's not the context for this. That's not, I mean, this is as a between the relationship between the parties, that they shouldn't surprise each other. We're still going through the, and in part, the no surprises is given effect to by sort of all the operative provisions that are set out in the circular. So if you sort of go back through, you've got the collective responsibility, confidentiality, consultation, ministerial consultation, and so that is one way of giving effect to no surprises.
Yes.
Then more generally, you've got sort of the commitment that they have made between each other, and which they have informed of, is that they don't want to surprise each other. So at a practical level, would be mindful of that when we are advising ministers on, you know, consultation processes and other things that are needed to take things to the cabinet process. So that's how I'd kind of explain that. It wouldn't,
So
I think it
it's
relates in the way you were saying in terms of surprised with the content, because it won't be a surprise because it's subject to a broad-ranging ministerial consultation process.
Yes, but it's just in terms of the understandings of the parties reflected in the Act policy, for example, in respect of the Treaty Principles Bill. There wouldn't be any surprises there. In terms of your role to advise the ministers, you'd agree that it's limited in the context where we have this coalition agreement that has predetermined the policy direction. And so what influence can Māori realistically expect to have in any changes to the policy and its process?
I suppose that's what's being worked out, and it's kind of in our March briefing, which I sort of referred to earlier. We've kind of got a series of 3 cabinet papers that we're working our way through, or that's kind of what we've proposed as the way through.
So there's none?
Sorry?
So there's no realistic expectation that Māori can have to influence that process now?
Well, no, I wouldn't agree with that, because it's still, in terms of we're only at the first cabinet paper, and that's where decisions are yet to be made about what is the nature of the process we'll adopt once cabinet has signed off on the overall approach and sort of the initial sign off on what the content of the principles might be.
Yes, and you've accepted the partnership principle in terms
Yes.
of working together with Māori, and so that's an important aspect of this relationship in terms of the development of the policy itself. You'd accept that?
I'm sorry, I didn't discern I'm sorry, you've lost me there a little bit.
You've just mentioned in terms of the cabinet papers still being underway, and that my question was about the realistic expectations Māori can have to actually have input, meaningful input into how this policy process has been developed. And you said, well, that's currently what is underway.
That is what's been thought. That's what the first cabinet paper is has an element of process to it.
Yes.
And part of what's being determined is what is the nature and opportunity there will be for engagement. And at this stage, what the Associate Minister has indicated he wants to go the next step to be the development of an exposure draft of the bill, and that is where there's a proposal that they'd have an opportunity for consultation, and we are still determining what is the nature and form of that and the time available for that.
Yes, and in the context of partnership, rangatiratanga, which you've already acknowledged, are very crucial and fundamental in terms of the relationship between Crown and Māori. That process isn't in line with that principle, is it?
Well, it depends on what the final process that is actually determined through the Cabinet's first paper that it's still yet to consider. And so we'll...
So is it fair in your view for Māori to wait until that whole process is completed before they have a chance to actually have input into it?
Well, that is the nature of the process that's being developed. At this stage, we haven't had any engagement. We've been very clear about it. We've advised ministers on the need for that, consistent with the principles, and that what is going to Cabinet in the first paper that's sort of outlined in our general plan there is one about, well, where do we go to next about consultation and engagement?
Ka pai. Turning to the three options that were proposed in your briefing paper from 14 December 2023. I don't propose to rehash the ground that's already been covered in that respect, but I do have a couple of supplementary questions, just for clarification. In terms of the recommended option 2, which I think is that paragraph 28 of your evidence, 28.2. And just as a reminder and benefit for those in the room, that provided for a small amount of targeted engagement with iwi and hapu during the policy development phase. You've accepted, well look, Mr Kiva-White had accepted that the targeted engagement referred to there was with the iwi chairs. You recall that?
Yes, and we've written that in various parts of these briefings as well. There was an element of iwi chairs.
And are you aware that iwi chairs are not representative of all hapu, and in fact hapu maintain their own mana and rangatiratanga over matters affecting them?
I think I probably have already covered this a little bit in kind of the earlier answer. So the three options were more not so options as three types of approach, and then some of how broad the engagement could be, or how small or large the targeting group could be, depended a little bit about timing. And so in terms of working this through and presenting it to ministers, part of it was the shorter the time period, the fewer we could consult, and then we'd had highlighted the issues about the lack of breadth of consultation and that, but we do accept that it's iwi hapu whānau and other Māori organisations, not just iwi chairs, would have a very direct interest in wanting to be engaged.
So in terms of the development of those options and the continuing advice that you'd be giving in terms of options for the Minister to consider, why were Māori not at the table working out those options and what they should look like, given that they are the ones who will be first and foremost directly affected by how that policy is developed?
Oh, at this stage, we were working alongside Te Arawhiti, Te Puni Kokiri, and having a look at this stage, in terms of largely process stage, what the potential approaches could be. And we have simply worked our way through that, and at this stage we didn't look at engaging more broadly beyond government and providing this initial phase of advice.
So those are very internally focused.
Internal to government, but I would also say that we were highlighting sort of three broad approaches, and as I've said, probably options is a too strong way to describe each of those three. They were more sort of three approaches. I think it's probably also worth highlighting the context in this is that the Minister had advised us to provide timing options, and that included, which we refer to in the purpose, as including one that would enable Select Committee consideration to be completed by the end of 2024. So in that context, we were laying out what would it look like if you wanted to land particular forms of timing, hence then going into the next part of the detail of the briefing and having illustrative examples, which then kind of draw in what are the steps that one must take in order to get the necessary approvals to actually introduce a bill. So largely this was about being able to have a basis on which to engage with the Minister on different forms of timing for introduction. And that was critical, I suppose, in the context of the coalition agreement having a specific reference to its introduction as soon as practicable.
So that largely involves responding to messages and exchanges within Crown agencies without actually considering hapu or tiriti obligations to hapu.
Well, I think we've highlighted the treaty obligations in terms of partnership, good faith, and the necessity that results into consult. And so that, I think, is clear in our briefings about what those parameters are. And at this point in the briefing, we aren't actually getting into any particular design or approach to consultation, but just merely looking at what the opportunities or broad opportunities could be within the time that's available, and hence sort of highlighting three approaches. One, what if you were to try and introduce a bill, I think I was saying, and shortly, and have the select committee process, which is a standard 6 month. If that was to be completed in 2024, what could that look like? What are the risks and issues that arise through that? What would you do? Then our next option was to say, well, what if you created some space to have some engagement? And then how would that look if we were still to land a bill to be introduced by towards the end of 2024? And then our third option was the more expansive one, to have a greater amount of time to enable much broader engagement and consultation.
So
and that's the
saying,
three approaches that we outlined.
Are you saying the Crown tiriti obligation to hapu is subject to that timing?
Well, it's kind of, it's not subject to that timing. It was about, this is a piece of work about providing advice to ministers about how they could achieve and implement, as required to under paragraph 4.3, how do we help them implement their coalition agreement. The coalition agreement's got aspect to it which is as soon as practicable, and this provided a basis for conversation with the ministers about how soon as practicable could be, or what would that mean and how we could achieve it. But in doing that, I think you can see, when particularly the sort of discussion we have from paragraph 39, we do go through and highlight what are the various concerns and issues we have. And then, yeah, it would be, and we kind of state quite clear that it would be impossible to have any meaningful external engagement prior to introduction, including with iwi and hapu.
Are you aware of, or have you read the reports of Te Paparahi o Te Rake in terms of their stage 1 report and or their stage 2 report?
No.
Just filtering through other questions that have been covered.
How much longer will you be, Ms. Peters?
For about 10 minutes, ma'am.
10 minutes, that means that you've had nearly 45 minutes.
Time goes fast.
Yes, well, I'm also bound by the length of the answers, ma'am, but I will...
but can you shorten them? Just put the questions rather than taking us through the long...
Tēnā koe, ma'am.
Introductory sentences.
Just turning to, because my clients in particular have a concern about the Treaty Principles Bill and the policy in terms of the reo Māori that is used in the proposed principles. You would accept that the proposed principles being defined in the bill draw on te reo Māori in the text of Te Tiriti?
Yes, we've cited what the ACT Party has come up with, but I just also note that the commitment is to develop a treaty principles bill based on what is in the ACT Party policy, and in our discussions with the Associate Minister, which we do record, and I think in the March briefing, at paragraph 12 of that one, which we say from our meeting, we understand that the principles in the ACT policy document are a starting point and there is scope to adjust them during the process to develop the bill and following public consultation on the exposure draft. So I just want to put that in context to say that it's a starting point, and the Minister has concurred that there is the opportunity to further develop them.
Are there people with expertise in tikanga o reo Māori who are part of...
Stop you, because that's been answered. Why are we going over this ground again?
Tēnā koe, ma'am.
Thank you.
Just one further question. Oh, actually, sorry, two questions. In terms of your paragraph 70, you talk about who's undertaking the analysis of how the bill will impact on any existing treaty rights of Māori and Crown responsibilities under the treaty.
So paragraph 70, in the
joint brief.
Joint brief, thank you.
And you say there that the advice includes the potential impacts on the bill and the timing and process of its development on any existing treaty rights of Māori and Crown responsibilities. Just a point of clarification really, was that meant to say potential impacts of the bill rather than on?
Impacts. Oh, I suspect it is of the bill, including, because that's actually what we say in our briefs, is that, yeah, we need to assess what is its relationship to existing settlements and other statutory enactments.
Thank you. Can you tell us who undertook that advice?
That's advice that my team is undertaking, or they're leading the development of that advice.
And my final partai for you is whether you can tell us that whether the proposed bill or the wording of it would be in Reo Māori and in English?
I don't know. We're at this stage of the process in the first cabinet paper, we're just seeking approval to what the principles could include. How that would then be articulated in the form of a bill is the next stage, which we'll be working on with Parliamentary Council as in their expertise, and then drawing on access to experts as we've indicated.
Thank you. Sorry, one more question. Do you accept that the potential reach of this proposed bill, if it proceeds, is enormous?
Depends what's agreed by Cabinet in terms of what its reach might be.
Okay, that's enough. Kia ora.
Koe
Before you think of another question, Ms Sykes.
I've got a number of questions I'd like to reduce in writing, if my friend please. They are on topics of roles and responsibilities around stewardship, and the other one that I want to take into a statutory review, which are topics that haven't been covered. They will take longer, and I want to be respectful to Mr Munro, who's been waiting patiently. So with your leave, Ma'am, I could do it overnight.
Yes.
This is it's ready. I just got to make it into a question.
Okay. Yes, no, that's fine. If you're happy to answer that way.
Yes, that's in the interest of progressing things this evening, yeah.
Well, I think that brings us to the end of your time here with us, so thank you. There was one other question that emerged out of all of this for me with the regulatory impact analysis. Mm-hmm. Will you also be looking at the role of the Auditor Generals in this?
In what respect?
Well, potentially the cost of going through this process all the way to Select Committee and then not going ahead with it. Is that, in your opinion, a good use of public funds?
It wouldn't be the first time that I've taken a bill through to Select Committee and it's gone nowhere. So most of this comes back to, in terms of the expenditure of the government's money and its prioritisation of resources, what I'd say is that the ministers have set clearly in that Cabinet Office circular, it sets out this is a priority on the basis of government, that is the commitment, and that is what we're asked to expend resources on.
All right. So in previous arrangements, you wouldn't have had a predetermined outcome. You might have had a bill that you marshalled through to Select Committee that didn't progress, but you've never had a predetermined outcome before if, in fact, your evidence is correct and that the National Party aren't going to support this bill beyond Select Committee.
So the National Party has said they won't support this through Select Committee, but as an official, my job is to prepare a bill that is capable of going through all its parliamentary stages, so that's what we're doing, and then what the government's position would be determined by Cabinet, and then I think in that Cabinet Office Circular 24.2, you can see what the nature of the relationship agreement is and what the parties would need to do in terms of discussing amongst themselves of how they want to vote in the Parliament.
Yeah, no, that's very important because just like you, we can't accept what we don't know will happen in terms of the National Party and its position.
That's correct.
You'd agree?
Oh, I can't.
So there's
I work to a minister and I'm part of a government and I'm
Right.
obliged to work towards those processes. I can't accept what a political party is saying, even if it's the Prime Minister wearing a different hat. My training has always been that I will develop
And
a bill
very
and
well
take it through the
trained you are
process.
too. Thank you so much for today.
Thank you.
And for your assistance with Mr Kibawai. Ngā mihi kia kōrua. Thank you.
Kia ora.
We now are going to hear from Mr Kipper Munro.
Ai, tēnā koe, Mum. We'll just rearrange ourselves.
Ai no mua te timatanga e te kaiwhakawau, he pātai ko tāku, e pehe ana wā tātou nei taringa, pehe ana wā tātou hine ngaro.
Pai ana ki te whakarongo ki a koe.
Tēnā.
He rere ki e tērā
Tēnā koe.
āhuatanga.
Tēnā koe. Ai, ai.
Tēnā koe te kaiwhakawā o te rai te pānara, hei kapo ake ana kōrero, hei kapo ake mo te pūranga, rongo tēnā hea tō kōrero mai tō ingoa, hei kapo mo te
Ko
pūranga.
Wiramu Kipa Munro tōku ingoa no ngā tirehia.
Ka pai. I tukuna e koe te tahi kōrero taunaki, i te rā toru te kau a Perira.
Ai.
He āpiti hanga i tāpiri ki tērā kōrero taunaki me te tahi whakapākehatanga ko tana tohu ko te ātoru A, me te ātoru B. E tika ana tērā?
Ai, tika ana tēnā, hakoa poto te wā ki au, i oti tēnā mai, tēnā koe.
E oate ana koe, e tika, e pono ana e rā kōrero ki roto i ngā tuhinga.
Ai, pono marika, pono marika.
Ka pai, tēnā koe, ka tukuna te wā ki a koe kia wā wāhi ake i etahi kōrero mō ngā tirehia.
Tēnā tātou katoa, e rite ana tāku noho i te rānei, mai tēnei kaupapa i mua i te aroaro nei. Kei wahoke au ngā kōrero katoa i te rānei, e rongo anau ngā kōrero ngā kaikareme, rongo anau ngā kōrero te krauna, tainoa ki te haorerei, pohe au kei kone au mo te karakia whakamutunga. Hakoa i pērā tāku kōrero, e pēne ana te krauna kia tātou. Ko wareware ke rātou ki ngā tohunga i roto i a tātou, ngā tohunga reo, ngā tohunga mātauranga, ngā tohunga katoa. Ko hoki muri tātou ki tēnei āhuatanga, e Māori hare mai whakakapito tātou hui. He karakia tonu, noiho toku hiehia kia koe. Nō reira. E kore timata au, kore au timata tēnei tūtāku i roto i te whakatūwheratanga. Kei kona katoa ngā kōrero i tuku iho i roto i tēnā wāpoto, me pēnā tāku kōrero. Hei tirohanga mā koutou katoa. Ko tāku, tukuna mai ngā pātai kia whakawhānui atu au o ku whakaro i roto e nā tuhituinga. Nō reira, kau ke mau te katoa o ku whakaro ki roto i tēnā tuhituinga tāku. Nō reira, kei a koutou kia whakawhānui aku o ku whakaro ki roto i ngā kōrero kei te tukuna atu i au i tēnei ahi pō makariri ki roto i Pōneke. Mei kei te kāinga ki au, kei roto au hoku traupoto e Kevin, me toku hingereti katoa. Mari, tai mai hau ki konei ki roto i Pōneke. Nō reira, tukuna mai ngā pātai. Kei konei au mo te pō, kei te noho au mo te pō. Nō reira, hore kautake ki te homa, e nei kōrero. Pera atu te krauna, o reo rongo o na koro, te horo o na tona reo. Tōku āta haere. Kia mārama te katoa I roto I tāku reo. Kia koutou, ānei ko tāku. Me tāku kuia, me tāku hapu, ngai Māori, tātou katoa. Harake tēnei whakahe, whakaiti, mō ngā tirehi ānahe. Nā reira, tēnā koutou. Tēnā koutou.
Pātai tāku, hei a pōpō ka hoki mai koe?
Ai, a pōpō ka hoki mai anō.
He wā pai ki a koe ki te whakautu I ngā pātai?
Kei a koutou, kei a koutou. Moi hanau, ko taunga ke koutou katoa I tēnei ngengetanga. Kau ke enei hunga nei, hoki ana ki te moi, hoki ana rātou ki te mahi, pera atu ia koutou. E hoki mai ana au a pōpō. Hoki mai ana au a pōpō.
He pātai anō tā
Whai ana. Tēnā koe.
Tēnā koe te rangatira. Anei taku pātai kia koe. Hea hai koe I wete mai tō trau poto kuhu o ngana kāka hara mai tawhiti ki konei, ki te kōrero ki te hunga nei. Hea hai koe te kaha o tō whakaaro I hara mai pēnei koe ki te kōrero ki a mātou. Hea ngā mea kei mua I a koe.
E pātai pai
Mō te
tērā.
kaupapa
E
nei.
pātai pai tērā. Nā te nui o te kaupapa nei. Nā te nui o te whakahe. Nā te nui o te whakaiti. Nā te nui o te tiu tūkino. Hore kau he kupu pai ki roto I tēnei pire. E kōrero nei I te krauna nei. Mena ka ia koe ngā kino, ngā kupu kino, whāri ki tia ki runga I tēnei pire. Nā te mea hore kau he painga. Nō reira te take I haere mai, mena ko te tahi wiki, rua wiki au noho ana ki muri, ka noho. Nā te mea te nui tēnei kaupapa, te whakahe I ngā whakaaro o a tātou tūpuna, mai te haina tanga o tō tātou nei tiriti tahi mano warurau whātekau. Ko taku tūpuna I reira, I kororo hia taku roia, taku kōtiro, e nei kōtiro, mo te mea o te whakapapa. Ko te triti he whakapapa ki tō tātou iwi. I hainangia o a tātou nei tupuna tēnā pepa, ka mutu, ka heke, ka heke, ka heke, kei reira tonu tēnā triti kei roto I a mātou. Nā ko tai noa tu kia au. Ka haere tēnei ki hai hiaraini. Nō reira te take I haere mai, hara mo te makariri, he tēnā koe. Engari, nā te nui o tēnei kaupapa, me tāku whakaro, e hake tātou nohana ki kone mo tēnei take. Nā wai whakaro me kōrero tahi tātou mo tēnei kaupapa. He mea tūkino tēnā ki toku hapu, he mea tūkino tērā ki toku iwi, arā kia tātou katoa ngai Māori. He poto tēnā whakautu, e Derek. Poto noi o tēnā whakautu.
Engari, hāngai ki te kaupapa. Kara mo, kororo no wahau, ka te ihe koe mo te pōnei, hārane.
He maha, kau keu hoki ana te pōnei, ka hoko I mea tu kia, he mea he kōrero ana oku.
Hana tēnei, hoki anga whakapau karekia.
Ai riko, here mai kone whakatara, whakapau karekia. He maha ngā kōrero e Derek. Ki roto I tēnei kaupapa, nā te mea, he maanga tau ko whakaheke, ka whakaheke ki au nei. Tēnā pēr me hopu au e tahi, ka wakoutou hoha ki au. Ka wakoutou hoha ki au.
Kei te pai rātou.
I rongo au e tahi o ngā pātai, ka whakaro, perautu te kaumata nohana ki runga te taumata, mena he hui nui, he maha ngā kōrero ka puta. Ka whakaro o pai tērā hei herenga. O pai tērā hei herenga. Ko ngā herenga kei tēnei tāho te whare. Hore kau e herenga ki tēnei tāho te whare I ngā kōrero ko puta ake. Mahara nau ki toku tupuna tāreha, nā te mea I whakahuangia Ngāti Hine o rata nei tupuna. E pita ke nā koe. Me hau mai taku tupuna. E mai kai. E kōrero kai kia pita. I ngā wā o mua, wa mātua nei tupuna, pera atu toku tupuna tāreha. Mena ka mea atu ia ki ona pononga. Me pēnei, me pēnā, me pēra. Ka mahi. E rite tonu ki ngā kaimahi nei. Mena ka meanga minita ki ngā kaimahi nei, me kake koi tēnā maunga peke. Ka peke. Kei reira ke te raru. E mai ana wa rātou mahi, i runga i ngā whakaetanga, i runga ngā hiahia, ngā wawata, ngā moimoia o te tahi. Me ki au, tēnā tahi he tamaiti. Tōna mōhiotanga hore kau he iwi, hore kau he tangata mōhio ki te Treaty o Waitangi, ko ngai Māori. I roto i tō rātou nei whakapapa, tēnei he noho ana ka tuku iho, ka tuku iho. Te tamaiti ka taimai ki Wainganui a tātou, kuare. Kuare ke te treaty. Engari, mōhe ana ki ko tōna mahi, he whakatakahi a tātou, he whakaiti a tātou. O reire he rerekētanga ki te kuare, i te tino kuare, engari e hara ki tōna mōhio. Ki tāku kite hau, kauke ia kuare ana ki ona mai ki te tūkino i a tātou ngai Māori. E te tuahine e Karen.
Kei te kōrero koe mō te tangata kei te hia hanga i tēnei pire. Wai nā te tangata e kōrero nei koe.
Ai. E mea nei tamati.
Ai. Engari, ki tō whakaaro, hea hanga whakaaro o na whananga, o koutou whananga. Kei te haki.
Nāku tēnā tamaiti. I tōna ki. E ki te koutou aku tuhinga ki roto i ngā pepa nei. Me tāku haere, tēnā pēr te nuinga o ngā hunga i waho i tēnei rūma kauke mōhio ana. Ki tō mātou inoi kia aia, hara te inoi e tono, me nohotahi. Ka mutu, e kore au tae te taongo hia tōna whakapapa. E Kevin, pe rātu tae. Kore au tae te mea tu e hara koe e ngāti ine. E hau ka patu iau koe iau. Me nā ka pēra koe kia au hoki. Ngari i tāku kōrero kia ia, kore tae te taongo hia tō whakapapa. Engari mena e tuana koe ki te whakapepeha, tia tōku pepeha, ko tēnei ke te hanga o ngā tirehia. E hara ko ngā kōrero e kōrero hia nei koe. E hara ko te huarahi e haere nei koe. E hara tēnā ko ngā tirehia. Me tāku mōhio, ko kāpō ke e nā taringa o te tamaitira ki au. Ko kite koe ko kāpō nā te pire nei. Hakoa ko kōrero ke au kia ia, kāpō tonu ona taringa. Ki ngā kōrero o tōna hapu, me nei whakaki ana ia ko ngā tirehia ia, ko Waitangi tōna awa, ko tauwhara tōna marae, ko kāpō katoa ia ki tēnā taha o tōna o ngā tirehia. Reira he kōrero anō hoki tēnei kia tātou katoa. E hara kē tōna whakakino ki au kia ngā tirehia anahe. Kia ngai Māori katoa, kia rongo tātou. Ona kōrero e kōrero hi ana ki au, e hara kē he whakaiti i au anahe. Ko tātou katoa ngai Māori. Reira, he take nui tēnei, he tino take nui. Kore tae te noho ki te kāinga ki te tuku ini kōrero. Anei taku kuia. Hare mai. Te tikanga ke, kei te kāinga ke maua, mahi ana wa maua nei mahi mo tō maua nei hapu. Hei whakanui atu tō maua nei hapu, hei oranga mō tō tātou nei iwi. Hara ki konei. He mau taima tēnei. He maha o tātou mahi ki te kāinga, ki kō. Ka mutu, ko taimaha katoa tātou, i ngā kōrero o te tamaiti. Me pera tāku kōrero. E te tepu. I kōrero tahi au ki waho nei, me ngā kāmera, pohehe ana rātou pai toku hanga, no, ka haupungia. Ka mea au, mena he kōrero tāku ki te premier, mena ko tahi tāku kōrero kia ia, here ato kuri. Here ato kuri. I mua tono huringa ki te ngau ia koe. Ko ki te tātou tērā. Ko ki te tātou tērā. Mena kore koe here ato kuri, ka huri tēnā kuri te ngau ia koe. Ko tai ki tēnā wā. Ko tai ki tēnā wā. Nō reira. E wai ona tu kona pia.
E te rangatira, tēnā koe mō kōrero.
Tēnā.
Tēnā koe. Me tō whānau i hara mai.
Tēnā koe.
He pātai anoa, Monty, kia koe.
Kawa, tēnā koe Monty.
Ai, tēnā koe e kipa. Tēnā koe mō tērā whakamāramatanga kia mātou. Arohatu kia koutou o Ngāti Rehia. Hoi anō, ko taku pātai e pāne ki te kupu kāwenata. Kai roti o kōrero, ko te tiriti me te he whakaputanga, he kāwenata. He heke mai tēnā kupu nā o tipuna.
I hopu te tahi atu i runga i te tō rātou whakaro, ko tēnā te kupu tika mō a rātou anō whakamāramatanga. Pērā atu i ngā kupu e pangahia ana te tamaiti ki runga i te tepu nei. I runga i tō rātou whakaro, ko enei ngā kupu e mau ana i a mātou, i te puta i te waha, ko tēnā te kupu, hei hopu, mō a rātou anō whakaro. E pērā ana te triti o Waitangi me te triti hoki. Pērā tonu ana, ngā kupu ki roto ki waho, ngā taha katoa, he rereke te whakaro o te tahi, i runga i tōna mōhio, me te tahi i runga i tōna pōhehe. He wānanga tērā kōrero e.
Te tai anu. Mō hoku e te reo Māori. Pēhea whakaro mō te...
Whakaro o
ki
patu?
ngā principles, Party Act.
Ai. Ko te mate ke, e mau ana, e whai ana ia wataua kupu, Māori. Ki te whakamārama atu tōna kupu Pākehā, ko tēnā te tino raru, pohe ana ia he tohunga ki tōku reo, ka mahia tōku reo, ka whakapākehā tia ki tōna hiahia. Whakahe ana te katoa. Tēnā te whakautu poto, whakahe. Māma noiho, nā kupu poto, engari hohunu tōna whakamāramatanga.
Kevin?
Kaua koe pātai tōku whakapapa ki a koe, Kevin.
Kaore ku aku nei pātai, tine ke tino ke au, ko te au te pānui au, kōrero, mālama, tikāna ke au, hoi te kōrero i tuatu i tēnā. A mihi ki a koe kui e no.
Tēnā koe te tuakana Kevin, tēnā koe.
Hei kupu whakamutunga mo te rānei. Nā reira. Ko mutu i konei.
Tēnā koe.
Engari, he mihi nunui ki a koe nā te mea e mohi ana tātou, mātou, o te tribunara ka hara mai tāwhiti mai koe. Nō reira, tungi i tōkaha me te kaha o tō hoa, rangatira. Tēnā kōrua.
Tēnā koe. Ei whakakapi pia te tuahine. Mātou, me e rātu o ngā kaikareme, e aru ana tēnā nohonga tribunara ki tērā. Ka piki ake tātou te ngai Māori, ka poro hoa mātou nei wāwai. Ka piki ake anō, ka poro hoa mātou nei wāwai. Tēnei pire, he poro upoko. Ka tae hoi te hikoi tonu, ngari mena ko poro te upoko, ka pēhea tātou. Nō reira i runga i tēnā. E mihi kawana ki enei, me koutou katoa I te tepu. Kei a koutou ke te mahi taumaha, kau ke rātou whakapono ana ko tērā te tepu. Engari e me mihi atu kia koutou ka tika. Mei ka mihi au kia koe e te tuahine e Karen, ko mihi au ki tō tira. Nō reire, mihi kau ana kia koutou katoa, huri ana, a tēnā koutou, tēnā koutou, a tēnā koutou katoa.
Te piki a te ri,
Timatai whangaroa, huri ngai taha taha, puta ki purerua, reira ka huri mai, ai ma te o Hawaii, o tiria tau marere, hei hei au e.
ka tahi
Ka rua, ka toru, ka wha, ka rima, ka ono, ka whitu, ka waru, ka iwa te te kau, matahi marua, matoru mawha, hari mai. Kevin, I rongo koe tēnā pepeha ko o tira ki roto. Nā te mea, me haere au mā o tira kia hoki au te kāinga ka hau atua o tira ki roto I tēnā pepeha. O reira runga I tēnā e tātou mā. Ko oti tēnei noho makariri ki muri nei. Me hoki au te kāinga me oko poto, trau poto. O reira tēnā koutou katoa. Tēnā koutou katoa.
E hoa e kipa o hewe o maoe. E tuku tana te karaki haka te ino e haka mutunga mau I te mea ko koe koe roa e koe a pupuri ane I a mātou.
Tēnā tātou. Tēnā koe te tuakana o mai tēnei honore hei kapinwāti tō tātou nei hui huinga. Nō reira me ino I tātou. Ko te mea tuatahi anō hoki kia tau anō te rangi māriatanga kia tātou katoa ko tau mai ki raro I te tuanui a tō tātou whare. Kia tātou mai koe te tama te rangi māri e ki wanganui a mātou I tēnei pō. E ho mai te māramatanga I te ora I te kaha I te rangi māriatanga. Ko koe nei hoki tō mātou nei kai arahi, kai awhina mai a mātou I ngā wā katoa I mui a mātou. Nei mātou tuku ana e nei whakawhetai kia koe. Kia whariki tia mātou I tō korowai awtawhai, tō korowai manakitanga. Kia hoki ora mai anō mātou ki wainganui o mātou whānau katoa. Whariki tia tēnā korowai ki runga wa mātou nei whānau e noho poharana, I roto I ngā hohipere, I roto I ngā whare here here, kia hoki ora mai anō rātou ki wainganui a mātou. E ni manakitanga katoa e pā inoe ana hoki ki a koe. I raro I te ingoa tāu tamatonu e te matua tō mātou nei kaiwhakora, ai ani ake nei ai. Kia ora tātou, kia ora tātou.